The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. This is the biggest showing of youthful exuberance we have ever had in the Supreme Court of Pennsylvania. Welcome to our second day of our spring argument session here in our magnificent Harrisburg courtroom. Today, as you may have guessed, the Administrative Office of Pennsylvania Courts, AOPC, is celebrating Take Your Child to Work Day. Let me hear from the children. Are there children out there? Let me hear. Hey, yeah, there they are. I thought there were some kids out there. These kids are here with their parents who are employees of AOPC. Throughout the day, they will learn how the court system works and hopefully be encouraged to explore careers in the law. To the children, I hope that each of you realizes just how important your parents' work is to the operation of our statewide system, and I hope you enjoy your activities today. I'm going to tell you just a little bit about the Pennsylvania Supreme Court and about our courtroom, and then after that, I think that Mr. Minner is going to escort you on to your next adventure. The Pennsylvania Supreme Court is the oldest Supreme Court in the United States. In fact, it's the oldest in all of North America. Our roots date back to 1684. We were William Penn's provincial court at that time, but our Supreme Court was formally established in 1722 pursuant to the Pennsylvania Judiciary Act. In May of 2022, we celebrated our 300th anniversary with a special session in Old City Hall in Philadelphia. We justices are proud of our rich history. We have the privilege of sitting on the bench in this majestic courtroom. This courtroom was designed in the Greco-Roman style, as indicated by the Ionic columns and the Greek grille wainscoting, all handcrafted. All of the wood in this room, including the bench where the judges sit, is made of mahogany imported from Belize. I'd also like to draw your attention to the 4 2-ton bronze chandeliers. They're unique, and yet they're different from one another. Under the main light, inside each of the chandeliers, you see the ball that is the main light, the white light. Underneath that and inside the chandelier is a statue dedicated to 4 great lawgivers. To my right are the Hebrew lawgivers. Closest to the bench is Moses, and in the back is King Solomon. To my left are the Greeks. Closest to the bench is Aristotle, and in the back is Solon, the father of democracy. The green and gold stained glass dome, if you look up, it's so pretty, was designed by Alfred Godwin, and it's one of the many domes in our state capitol, but this is the only stained glass dome, and it's only visible from inside this courtroom. The majesty of this courtroom is designed to remind all of us of the seriousness and importance of the work we all do here. Next, and my favorite part, I draw your attention to these beautiful murals all around our walls. They were painted by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Murals Project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. Ultimately, she devoted 25 years of her life, from 1902 to 1927, to painting 43 murals in our Capitol. I trust that no one who works here takes this gift for granted. While there are many things that our three branches of government may disagree on from time to time, I know that our judiciary, along with our legislative and executive branches, all agree that we have been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent Capitol. President Roosevelt attended the dedication of this building in 1906, declaring this the handsomest state capitol I've ever seen. The architect of the building envisioned this to be a palace of art, and in no chamber was his vision as well embodied as in this courtroom. On May 23, 1927, the Supreme Court of Pennsylvania convened to unveil the majestic Violet Oakley murals. Ms. Oakley had been selected by the Capitol architect Alfred Houston in the hopes that providing such an opportunity might inspire other young women to pursue art. At the time, such a commission to a woman was a radical concept. Ms. Oakley proved to be up to the task. Already a well-regarded artist, Oakley's work in this building made her world-renowned. Oakley's vision for this room was to write a book on the evolution of law, and the murals in this room may remind you of the pages in a medieval or Renaissance manuscript. Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. The remarks from that day were published along with copies of this beautiful artwork in Violet Oakley's 1931 portfolio, Law Triumphant, and a copy of that book is displayed in our hallway. I can't tell you how happy we, as justices of the Supreme Court of Pennsylvania, are to welcome all of the kids here today, and we thank their parents for the work they do for our court system and for bringing the kids to see us today. I hope you have a wonderful time at the Capitol, and Mr. Minner, would you escort the kids? Thanks for coming.
Thank you. Thank you. Thank you.
It's great, big turnout.
Yeah.
That's wonderful.
Amy's two kids. Yep. 3 kids.
Chief, good morning. Thank you.
Thank you.
Thank you very much.
Thank you for coming.
Have a good day. Have a good day.
Have fun, kiddos.
Appreciate it. Thank you.
Have fun.
Perfect.
couple of PUC cases. I think they're going to have more fun moving on. Before our court crier calls the first case, I'd like to briefly remind counsel of a few matters of protocol. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel may rely on their briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should not repeat the same argument as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not permit rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Larry Krasner in his official capacity versus David Sunday as the Attorney General. Representing Mr. Krasner, Mr. John Summers. Representing the Attorney General, Mr. Daniel Mullen. Representing SEPTA, Mr. Matthew Aplt.
In this direct appeal, the District Attorney of Philadelphia raises constitutional challenges to Act 40, which mandates the appointment of a special prosecutor to investigate and prosecute crimes occurring within the Southeastern Pennsylvania Transportation Authority, commonly known as SEPTA. The District Attorney asserts, among other claims, that Act 40 infringes upon the jurisdiction and powers of the Philadelphia District Attorney and his office and violates equal protection guarantees by treating Philadelphia and the Philadelphia District Attorney differently than other counties served by SEPTA. Please proceed.
Good morning, Your Honor. May it please the court, my name is John Summers. With me are my colleagues Andrew Erdlin and Michael Massandero.
Welcome.
What a wonderful way to start with those children. I had a discussion with Mr. Minard and I asked him who 30 or 40 years from now in that crowd will likely be arguing and who may be sitting on the bench. Good morning. Act 40 grants sole discretion to a special prosecutor to exercise preemptive prosecutorial jurisdiction over any criminal proceeding or action in which the Philadelphia DA is involved for crimes that occur within SEPTA. What I'd like to do, Justices, is there are three baskets of arguments that we have. Some involve, admittedly, issues of first impression. I'd like to move those to the second category and really start with the first category of arguments, which are, I think, the least complicated. And those are that Act 40 violates Article 3, Section 32 in really two ways. It creates an unconstitutional special law, a closed class of one, and it arbitrarily singles out the Philadelphia DA. Then I will move to the discussion that the acts putting in place a special prosecutor with sole discretion impermissibly strips the district attorney's territorial jurisdiction and power to prosecute and investigate crimes that occur within SEPTA. And third, there are two additional constitutional issues, those that relate to the stripping of a criminal defendant of the ability to raise an argument challenging the act, and also the argument that drew the attention of the of two of the Commonwealth Court judges, namely that the act is a violation of the improper delegation provision.
Counsel, I apologize for interrupting. I understand the arguments, but before we begin, share with me why you did not address Article 3, Section 20 of our Constitution, which permits the General Assembly to legislate or regulate counties by population, and any legislation they deem is general legislation. It seemed to be conspicuously absent, and I kind of understand that to defeat your entire argument. Can you address that before we get into this sub-issues that you've indicated?
Sure, Your Honor. I believe we did address Article 3, Section 20. I don't have the page reference in front of me, but the gist of Article 3, Section 20 is that it allows for the classification based on municipalities. That is, the legislature shall have the power to classify counties, cities, boroughs, and the like. The court's jurisprudence is very clear, and I think one need only look at Justice Mundy's opinion just a year ago in laying out the broad contours of the closed class violations of the special laws provision. And Article 3, Section 20 doesn't trump the closed class doctrine that has been well recognized and ensconced in this court's jurisprudence for over 100 years.
I apologize. Are you saying our law trumps the Constitution? Judicially created law trumps?
No, I misspoke if I was thought to have said that. Article 3, Section 32 prohibits the General Assembly from enacting local and special laws.
Great.
That prohibition,
I got it. But Article 3, Section 20 specifically says the General Assembly has the power to regulate counties by population and, quote unquote, all laws passed relating to each shall be deemed general legislation within the meaning of this Constitution, which takes it away from a special.
respectfully, Your Honor, no, because Article 3, Section 32 prohibits, as this court has long held, special laws that are closed classes of one. So even if nominally, as Act 40 does, uses the phrase first county, but doesn't specifically call out a Philadelphia, it is without doubt a closed class of one.
Counsel, aren't there, I can think of at least one, you probably can think of more, laws passed by the General Assembly that provide specific rights and benefits to the city of Philadelphia and the county of the first class that are not available to other counties in the Commonwealth of Pennsylvania?
What makes those different?
So the answer is yes.
There are some laws that.
Philadelphia does benefit from being a county of the first class with regard to laws that allow them to do things that other counties can't.
There are laws that the General Assembly enacts that are constitutional that reference counties of the first class. Yes. However, those are open statutes. That is, there could be other provisions, other counties that could become first class counties in time. Unlike
that differentiates from 6108, carrying a firearm on a public street or property in Philadelphia. Is that a special law?
it is a.
It's exclusive to Philadelphia. Everybody in this Commonwealth can carry a gun on their street except our residents in Philadelphia. Now, if that's not a special law, then how is this Act 40?
The special law prohibition that the Constitution in Article 3, Section 32 prohibits is a closed class that restricts and limits the powers of a locally elected official. The cases that you're talking about don't purport to do that. Here we have a democratically elected district attorney, and we have a statute, Act 40, that preempts his jurisdiction. It is restrictive. it prohibits and it puts in place a statewide attorney general designee over the locally elected district attorney. That makes that law a different kind of special law.
Well,
What makes it
isn't the real distinction not what you just said? Because that doesn't really find purchase in the language of the Constitution. Isn't the answer to the question Article 9, Section 13B, which allows local and special laws relating to Philadelphia? And don't you have to defeat that provision to prevail on this argument?
Yes, and I was going to address the role of 13B. Look, the reality is that the Article 9 provisions that were enacted in 1951 as part of the development of Home Rule provided that the goal was to unify the government of Philadelphia so that it could exercise the powers that came with Home Rule. And that's a provision, as is 13F, that's a part of it. And the purpose of those laws, of those rules, was to allow for the consolidation, the creation of Philadelphia offices. And so there could be a special focus on Philadelphia to facilitate Home Rule. This law, Act 40, is the opposite. It's anti-Home Rule. It's taking away the powers of a Philadelphia officer. Look, in 1953, the General Assembly passed precisely the kind of law that is intended and permitted by Justice Dougherty, the provision you referenced. Section 1 of the City-County Consolidation Act of 1953. It says that the purpose of the act is to carry out the intent and purpose of the Consolidation Amendment, i.e. Section 13, by enabling the Council of the City of Philadelphia to act with respect to offices. But look at Act 40. Act 40 doesn't do that. It doesn't do it at all. It's anti-Home Rule. Far from enabling Philadelphia Home Rule, it weakens it. It takes power from the City of Philadelphia and its voters and places that power in the hands of an unelected special
The
prosecutor.
Assembly's allowed to do that. I mean, there is nothing in our Constitution, or is there, that says the General Assembly must in all circumstances be pro-Home Rule. In other words, you can only be a Home Rule municipality to the extent the General Assembly says you can be a Home Rule municipality. They can step in at any time and cut you back as well as empower you. Am I wrong about that?
Well, not cut you back in a way that's part of a scheme that is creating a closed class. That's number one. Number two, the force behind those Home Rule provisions was to abolish certain county offices to allow them to be city offices.
Well, you've said that, and I think that's interesting. How doesn't do we get that from the actual language, or do we have to glean some intent beyond the language? Because the language seems to, that's what's going to guide the decision here. And I think the language, as Justice Wecht read it, doesn't give those nuances that you're trying to put on it.
The text of the provision needs to be read with and in conjunction with the structure and what was being accomplished and sought to be done. I think there isn't any doubt about what.
Is the text ambiguous?
The text, I think there's some, frankly, Your Honor, under 13B, there is some ambiguity about what the scope is. It says local and special laws regulating the affairs of the City of Philadelphia and creating officers or prescribing the powers and duties and officers of the City of Philadelphia shall be valid notwithstanding the provision of Section 32 of Article 3 of this Constitution. That's what the text is. Now, it is the heading for Article 9, Section 13 is abolition of county offices.
Okay, so we ignore the heading. That's in the Statutory Construction Act. We ignore the heading. Let's look at the words. What is ambiguous about the words?
I think the Act 40 is a law that focuses on the regulation of the SEPTA special prosecutor. Now, I acknowledge that it has an impact on the affairs of Philadelphia, obviously. So I don't want to suggest otherwise. But does it regulate the affairs of the city of Philadelphia?
That's somewhat inconsistent with the other part of your argument, that this is clearly all about stripping Mr. Krasner.
Well-
It's clearly about stripping him of jurisdiction. The question is whether he's an officer of the city of Philadelphia or he's the Commonwealth. Isn't that the issue?
And I think there's some ambiguity in the lead up to by this court to that issue. I think the fairer reading, I acknowledge, is that he is probably a city officer rather than a county officer, given the home rule status.
Then you lose that argument, don't you?
I think the ambiguity is a very modest one. I think the text, one of the principles and canons of construction is that you can't accomplish through a textual reading something that is counter to what the purpose was of the law.
Where's that canon?
Where is that canon? I don't have the citation, but I'd be happy to provide it.
Well, didn't you just you're telling us that we disregard the language in pursuit of the spirit. That of course, turns the canons on their head, right?
I think we don't disregard the language. We read the language in conjunction with other provisions. And the other provisions are the provision that prohibits special laws. And so the prohibition against special laws and the creation of a closed county, just think of the consequence of what this could go unchecked. The General Assembly could enact a law that says in Philadelphia, we're going to replace the police. We're going to replace all labor laws, and we're just going to do what we want and only in Philadelphia. That's not what Article 9, Section 13 was about.
Well, they can basically do whatever they can eliminate municipalities.
I beg your pardon, Your Honor?
The General Assembly can eliminate municipalities, can they not?
Well, when it comes to and this will take me to the second argument, when it comes to a locally elected district attorney, respectfully, no. That is a quasi-judicial officer. That's not something in the scope of what the General Assembly can do.
No, I'm not suggesting they can cut somebody's elected term of office short.
We're
Well,
limiting
I don't know where you're getting this quasi-judicial aspect, but the point is that under Article 9, Section 13, they appear to have the constitutional power to monkey around with Philadelphia offices. I'm not sure how you can maintain otherwise.
Your Honor, in Ray Shelley, which is the second part of my argument, and that line of cases is where I get quasi-judicial officer, where the Supreme Court has recognized that a district attorney is different from other positions. It's different from a sewer commissioner or a school board or other entities by virtue of the powers that a district attorney has.
We said it was a quasi-judicial officer? Did you say that this court said that?
In Ray Shelley.
There's some funny old cases. I remember when I was Register of Wills quoting it to a court that an old case of this court that said the Register of Wills is a judge, and boy did I get hell for that.
Well,
There's
Justice,
all kinds of things. in that case.
Justice Stern, my authority is Justice Stern, and among the great justices on this court who identified the district attorney as being a quasi-judicial officer.
What year was that?
I beg your pardon?
What year was that?
In Ray Shelley, 1938.
And so you've got a lot of history that happened since 1938 in the Commonwealth of Pennsylvania with regard to the amendments to the Constitution, the Commonwealth Attorneys Act. That was a different time in Pennsylvania constitutionally, and the structure of law enforcement and the powers exercised by the General Assembly. And I think Shelley factually was an effort to give powers of an elected official to an unelected official. Here, you can't dispute that the Attorney General is elected by all the people of Pennsylvania, including the people of the county of the first class.
I think the weight of the historical developments is favorable on this question rather than unfavorable. Let me turn, if I could, to the second set of arguments, which relate to that this court and the lower courts have long held the DA's power may be superseded only where, one, the district attorney has a conflict of interest or is engaged in some kind of misconduct, and two, that the supersession is reviewable by a court. I think In re Shelley is a foundational case in 1938. That case involved a situation where there was an act that granted the then appointed Attorney General absolute discretion to supersede a district attorney, and there the Attorney General attempted to supersede the Dauphin County DA who was investigating charges against the sitting governor and other officials. In a 6-1 decision, Justice Stern's opinion held that the law required some limiting construction on absolute discretion. That's what we have in Act 40.
That was before the Commonwealth Attorneys Act.
And the Commonwealth Attorneys Act precisely sought to embody what was in re Shelley and subsequent cases in restricting the authority of the Attorney General to preempt and supersede a district attorney in the significant respects here. One, under the Commonwealth Attorneys Act, there needs to be some finding of misconduct or thought to be misconduct on
You're
the part
missing
of
the
a
point,
district attorney or
counsel,
conflict of interest.
is In re Shelley did not stand for the proposition that the General Assembly can't pass a law that provides for supersession. There was no law that provided for supersession, as I remember it in re Shelley. By an elected official, by an unelected appointed prosecutor. This law is, at least I see it, as similar to the Commonwealth Attorneys Act, where you're vesting prosecutorial authority specifically as between the local law enforcement body and the statewide law enforcement body, both elected officials, investing it in one versus the other.
Respectfully, I disagree in multiple respects. One, as to the details of In re Shelley, I've learned in life, when we're talking about specific cases, I know when we wrote the brief we were careful, and I would defer to exactly how we characterize things in the briefs, but I have a very strong recollection that In re Shelley involved a statute.
I agree with you. I agree.
And the
I
statute,
said otherwise, I misspoke.
the statute required said that the Attorney General has absolute discretion, and that was the fatal defect that Justice Stern identified, and that is the fatal defect in Act 40. That's number one. Number two, the Commonwealth, other than Act 40, and the General Assembly, have enacted a whole set of laws that allow for an Attorney General and a district attorney to sit side by side and work cooperatively with each other. One of those examples relates to a gaming act. The unfair trade practice law is another example. And, Your Honor, so is the Commonwealth Attorneys Act, because what that provides for is very limited supersession. Not the kind of supersession that is in Act 40, but rather supersession by an Attorney General only, where A, there's some identification of some conflict of interest or some kind of misconduct by a district attorney, and B, it is subsequently presented to a court for a cross-check. That's what that act says. Here, Act 40 bulldozes right over those limitations.
Counsel, does that make it constitutionally, facially unconstitutional? I mean, certainly Shelley and Schaub stand for the proposition that there is some proceeding that takes place when supersession is asserted, so that the discretion can be checked. I mean, obviously in Shelley there were no statutory standards. Here there are. I mean, the statutory standard is in septa. So, I mean, how does this work? I mean, does the special prosecutor, does the AG go to a court and say we're superseding the district attorney in this matter that occurred at such and such a place at such and such a time?
No, it does not, Justice Donahue, and that is what makes it unconstitutional.
Well, but can
and
we
different.
read that into it without calling it facially unconstitutional? That's what Schaub did.
Here,
That's what Shelley did.
yeah, it's facially unconstitutional because it doesn't provide for that kind of either A, any standards, that is Act 40 doesn't, and B, it doesn't provide for any judicial review. And it's actually worse than the statute in Shelley, because what I'll get to at the end, which is that criminal defendants are actually prohibited from bringing a challenge.
Well, I think you go too far. They're limited. They can't bring a challenge to the authority, but I don't know that they can't bring a jurisdictional challenge. They're two different things. I mean, if the AG exceeds the parameters of whatever in septa means, certainly a challenge can be brought to the jurisdiction, to hear that type of, to handle that type of case.
I think the I understood the restriction, the prohibition against challenging the jurisdiction included.
Well, this is
challenging the
authority.
authority.
This is challenging the authority, correct?
Included challenging the authority. So the prohibition against challenging the authority makes it worse than the kind of Shelley prohibition.
Except that, I know you, that's another argument you have, obviously, but with respect to that other argument, that would be a challenge not before us.
Right.
In some particular criminal case, a defendant would come before us and challenge that provision. It seems unright, but can I come back to the Shelley argument and
Yes.
Schaub for a minute? Wouldn't it be anomalous that on the one hand, the Constitution provides and case law validates that the General Assembly is free at any time to alter our jurisdiction, this court's jurisdiction, right? So you're standing in front of us and telling us that the General Assembly, with the governor's approval, cannot supersede aspects of a district attorney's jurisdiction. How does that work? And particularly in light of the fact that Shelley and Schaub were decided at a time when the Attorney General was not an elected official.
Well, if I understand Your Honor's question correctly, I think it presupposes something. If the General Assembly said that this court has no jurisdiction over cases arising out of Philadelphia, I think that's not constitutional. It can't do that. Likewise, if it abolished all courts of common pleas in Philadelphia, I think that's also something that would be not permissible. And so I think that was the predicate of your question. And so I think it applies with respect to district attorneys. If I may just return to your ripeness point with respect to the challenge. There were challenges brought to D.A. Krasner's standing, maybe also ripeness, but standing with respect to raising these challenges. And the Commonwealth Court was persuaded that he had standing and things were sufficiently ripe because of the imminent possibility of an interference with any prosecution. That is, there's a crime that could occur on SEPTA, within SEPTA, whatever that means, okay? And then the district attorney begins to investigate, may bring charges, and at any time, that authority could be taken away for any reason and unchecked. And that amounts to a interference ongoingly. Now, I will allow it as true that that one of the things we've learned, and it's in our papers, what's been the history of this law? Well, since the law went into effect, I can point to three things. One, crimes plummeted, but the special prosecutor hasn't done anything, and serious crimes have fallen by 33%. That's, and there's citations to the source of that. But not because the special prosecutor's done anything. I mean, the reality is there are exogenous external things that affect what's going on with crime, not other things. But crime has fallen. Special prosecutor actually hasn't done anything. And as we've cited in our papers, interviews either with the SEPTA chief of police or with the special prosecutor, SEPTA's pretty satisfied with what District Attorney Krasner is doing. Now, the ripeness point comes from the problem posed whenever there's going to be any interference. The DA can raise the claim because his jurisdiction is taken. He's not asserting the constitutional right of a criminal defendant, but rather he's leaning on the fact that there are it's really two constitutional rights that we cite. It's the defendant's right to state and present arguments, as well as the separation of powers argument. That it's not for the General Assembly to say that a criminal defendant can't raise a challenge in the court. It's up to a court to decide what it can hear and what it can't hear.
Why can't we rely on competent, zealous counsel for those future defendants to vindicate their claims? Doesn't the district attorney have enough to do representing the Commonwealth and not trying to project what the interests of the defendants are too?
He's not projecting the interests. What he's protecting is the orderly prosecution. Because if we have a situation in which someone is charged, someone is convicted, and then it's overturned because of an improper Act 40 restriction on a right, there may be a double jeopardy problem. He may never be able to charge again.
Counsel, that happens in every case.
I beg your pardon?
That happens in every case.
Not every case. This case is totally, there are not other cases that we've uncovered that have ever sought to strip a district attorney of these kinds of powers and interfere.
You were
with
talking
his-
about a criminal defendant's right to file an appeal and maybe face double jeopardy, challenging that particular case. That happens in every single criminal conviction.
It's always
Conviction
the
happens at
case.
the Superior Court, and then it can come up in front of us in Alicata. So that's no different than any other case, right?
It's always the case that the rules governing double jeopardy would govern any appeal and prevent or affect a subsequent prosecution. What's different here is the striking fact that the person that the entity that is creating the difficulty with the prosecution is the General Assembly's law. And it's the General Assembly's law that's creating the interference with with D.A. Krasner's job. And that's what makes it different.
Counsel, can I just ask,
Yes.
where am I going to find a job description for D.A. Krasner?
Well, one partial answer, and I will need to think about it longer to think about what city document there may be that describes it, and I don't have at my fingertips what that is. But I think, for starters, the answer is, look at the wealth of the law that this court and the lower courts have issued on what a district attorney does. That is, there is no dispute, but the district attorney is an extraordinary officer different from all others.
No doubt. I'm asking, but so you've given a couple answers. One, you haven't said the Constitution. You haven't said a statute. You've sort of referenced city documents, but then you've said common law. So in your view, it's city documents and common law that are going to tell me what the duties of the District Attorney of Philadelphia are?
I think that doesn't fully account for my answer, okay? And here's why. The SEPTA in its brief concedes that D.A. Krasner is a constitutional officer, number one. Number two, cases from this court repeatedly say that the district attorney is a constitutional officer.
Whose duties are,
There are a lot of cases that describe what the duties are. He's the chief law enforcement officer for a jurisdiction. He's responsible for enforcing the Commonwealth's criminal laws and some civil laws. He has the discretion in investigation, in charging, and is given the heavy responsibility of implementing the law by holding trials. So those are all things. Is there a HR department document that lists or some other list? I'm not aware of it.
no, but you concede that it's not in the Constitution,
Well,
and it's not in a statute.
what
Except for any statute, like the state police, the Commonwealth Attorneys Act certainly references the district attorney. But there's no, unlike some counties, the county code provisions that list the duties and obligations of certain officers, there's nothing you can point to that has a duties responsibilities section for the district attorney.
The Constitution, I acknowledge, doesn't, but it doesn't list I think other than the governor, I'm not sure it lists the duties of anybody. I'm not sure your duties are in the Constitution. I'd have to think about what statute might identify what your duties are. But that doesn't mean you don't have duties, and that doesn't mean...
There are statutes that identify our jurisdiction.
I beg your pardon?
There are statutes that identify our jurisdiction.
Yes, and Your Honor keeps returning to the Commonwealth Attorneys Act. The Commonwealth Attorneys Act demonstrates why Act 40 is unconstitutional, okay? As we've argued in our briefs, the Commonwealth Attorneys Act embodies the long line of cases as to the constitutional authority and powers of a district attorney. And that law has real restrictions on the ability of the Attorney General to supersede. If those restrictions, I submit, if those restrictions were in Act 40, we might not be here.
Doesn't the specific prevail over the general? So to the extent you're correct about the anti-supersession flavoring of the Commonwealth Attorneys Act, wouldn't that be trumped by Act 40, which appears to manifest the legislative and gubernatorial will with respect to these SEPTA cases?
No, because I think the Commonwealth Attorneys Act reflects the constitutional role of a district attorney.
We have some statutes that are quasi-constitutional, and they prevail over other statutes?
I wouldn't use the phrase quasi-constitutional. Let me try.
Quasi-judicial DA and a quasi-constitutional Commonwealth Attorney.
Well, look, far be it from me to argue with Justice Stern. Okay, those are his words, and I'd roll with those anytime. Okay, as to the specific and the general, the Commonwealth Attorneys Act isn't just another statute. It's a statute that was enacted in the wake of these cases about the district attorney's office. And it is part of the constitutional shadow of the role of a district attorney. Now, and I say that not to say that the Commonwealth Attorneys Act is an article of the Constitution, because it's obviously not. But I think the fair reading of the case law, and we lay it out in detail, is that the Commonwealth Attorneys Act embodies those constitutional provisions. And so that I'm not pointing, so when I say there's a conflict between the Commonwealth Attorneys Act and Act 40, it's not that one General Assembly act can nix another one. It's that the Commonwealth Attorneys Act embodies a higher and broader principle that Act 40 plainly violates. I mean, there's never been a law like Act 40. There's never been an attempt to go strip a local district attorney of authority like this. And it's a head-scratcher to try and think about how that is remotely possible given the role of a local district attorney. I mean,
We do have laws that strip local elected officials of power.
A district attorney, is elected, as the amicus brief, I think, made very clear.
So is a school board. We have laws that strip them of power. So do municipalities. We have laws that strip them of power.
And in our framework, the district attorney is on a different plane. And I started by saying I'm leaning on In re Shelley and those cases, but that's what.
Higher than the power of mayors? I mean.
I beg your pardon?
Higher than the power of elected mayors? I mean, there are acts that our General Assembly has passed with gubernatorial approval, superseding and significantly restricting the powers of elected mayors and city councils. Act 47 in Pittsburgh, the Chester situation, and on and on and on. I mean, the legislature gets to do stupid things as well as wise things. I'm not sure how your repeated invocation of the district attorney as some sort of person above all is convincing.
Well, I think there are two answers. I think the answers are embodied in Act 40. One, under the jurisprudence, I'd say it's 100 judges and above mayors. And I mean, I think just putting it right out there, when you look at what the case law, and that's what is meant by quasi-judicial officer. The legislature, I think that's sort of number one. Number two, the singling out in a closed class, as this court has repeatedly said, is per se unconstitutional. I mean, per se unconstitutional.
See, I think that's your strongest argument, but you still got Article 9, Section 13 to deal with. The framers put that Philadelphia-specific provision in there, and you did concede, I think, that the DA is a city of Philadelphia employee. You didn't bite on the, was that Judge Wolf who said it's the Commonwealth, or was it somebody, yeah?
Yeah, I just, I take my obligations seriously as to where I think the arguments shake out. I think that it would stand those constitutional amendments on their head to use the constitutional amendments that were designed to facilitate the creation of home rule to strip the home rule, to strip Philadelphia of those authorities. That's just not what any of those laws were about. And I don't think there's any real actually contest about that. I think if you looked at the legislative history and the constitutional history that we have cited, if you look at the subsequent laws that have happened, and you look at this extraordinarily unprecedented, there hasn't been another case like this. I mean, this is an extraordinary act that's been done. And I think I acknowledge the textual point, but that is interpreting that text beyond the breaking point of it. And it's not as if there's a simple little remedy. You know, if your honors are interpreting a statute and are just dead on in interpreting the text of a statute, literally, as someone might think, there's somebody there, the General Assembly, to fix it. And say, you looked at it. Not so with the set of constitutional amendments. I mean, it's way more, that process is way more in amber. And so there's more room for the court in doing its review and its textual analysis to recognize what this is really about and how this is an anti-home rule, not a pro-home rule. And I mean, I've never heard that argument before. That seems like a scary proposition, that we can look at the clear and unambiguous provisions of a constitution, constitutional provisions, and we can look past that clear and unambiguous language and divine what it was about, and then give an interpretation that is in tension with the text because it was about something else. Respectfully, I think There are many, many decisions interpreting, well, look, the First Amendment says Congress shall pass no law. But everybody, if we're restricting freedom of speech, everybody knows it also applies to the president. In Article 1, it's not just Congress. I mean, there are many, many instances in which that courts allow for more elasticity than one might others in interpreting to address it. Let me go with a final point, which was highlighted in Judge Fisano-Cannon's dissent that also commanded Judge Cohn-Jubileer, which was that Act 40's delegation to the special prosecutor of preemptive jurisdiction over all crimes within SEPTA violates the non-delegation doctrine. We did not burden the briefs with an extended discussion of this because the discussion and the opinion was so clear. She found that there are two fundamental limitations on legislative power. They've got to take General Assembly's basic policy duties, and there must be, with legislation, adequate standards. And she held that Act 40's reference to crimes within SEPTA is impermissibly vague, in effect giving the special prosecutor unfettered discretion with no guidance from the legislature. And we believe that to be true. So I will rest on the balance of the briefs. There are other, which I'm happy to entertain any questions. There are other components to equal protection analysis, namely that Act 40 was arbitrary. And if I could just give one quick focus on that. The special law prohibition has really two components to it, as we've presented it. One is there's a per se violation where there is a closed class of one that's created, and indisputably this is a closed class of one. But there's a second problem, which is a more traditional kind of equal protection notion. And that notion is that there needs to be a non-arbitrary reason for the provision.
I guess that is notional because the words equal protection and arbitrary, they don't appear in our Constitution, do they?
No, but the case law from this court.
Probably from Justice Stern also. But is it time for this court to use the language of our own Constitution, which is much longer than the U.S. Constitution, and maybe be a little more humble about just grabbing terms from the U.S. Constitution that don't appear in our own? Why do we need the term equal protection when we have clear language about special laws that you've been arguing about?
Well, the equal protection principle is different from a special law principle in the sense that in this second component, which is that the equal protection component is that the General Assembly has a wide range of authority of enacting legislation, but it can't do it in an arbitrary way. And that's important and that's foundational. And it would seem to be extraordinary for this court to depart from its long, long history of embracing that notion, let alone with this case.
Maybe I'm more amenable to departures, but we have Article 1, Section 26, the non-discrimination provision. So if you're arguing about discrimination, why don't you just argue about discrimination, and then you've got your argument about special laws. Why grab at a notion of equal protection? I guess the answer to that is this court has encouraged you to do so.
As a lawyer, we tend to take the law as it comes to us. Far be it from me to be at the cutting edge of saying justices overturn 100 years of precedent that's well settled.
Well, Counsel, we signaled, it's Justice Donahue. We signaled an issue with Section 32 in Allegheny Health Network. signaled that we weren't going to address it because of the briefing in that case, but it certainly, its construction needed attention from the court and the bar. So, I mean, you know, that was certainly a signal that maybe somebody should raise. One of the other parties in this case has actually raised that issue.
Yes, that was a signal. I think if I were a more careful student an even more careful student of this court, I'd see that there might be often signals of a variety of kind, but that doesn't mean we take it up every time. I think that this is a foundational notion, and Justice Wecht and Justice Donahue, whether it is dressed in the context of the special laws provision or the discrimination provision, there's still a basic bedrock concept that if I could just explain, and that is there needs to be a justification for the distinction made in the statute, right? It can't be arbitrary.
Counsel, what's arbitrary about it? SEPTA is a creature of the legislature. It's a Commonwealth agency. What's arbitrary about designing a protocol that deals with either actual safety issues or the perception of safety issues within SEPTA? Why is that arbitrary?
That's not the problem. The problem is the distinction drawn between the preemptive authority with respect to a DA from a first-class county and the other counties where SEPTA operates. The pernicious effect and the problem with the statute is that distinction. Now, let's hypothesize. Let's remove the closed law situation. Suppose the law were stayed in effect and Montgomery County became a first-class county. So then, Act 40 would operate to distinguish Montgomery County and Philadelphia County, in which case there would be preemptive authority, and the other counties where SEPTA operates. And ask the question, is there any basis in the legislation for that? And the answer is absolutely clearly no. Why? Because in the light most favorable, and I submit counterfactual, the support for the law was that D.A. Krasner wasn't following through in prosecutions. That does not support the distinction between first-class counties and not.
So then you'd have a rational basis challenge. But you don't have that here. In other words,
Well, we do.
What hurdle? Well,
Why do you?
What hurdle? Yeah, what hurdle did this? You disagree and you think it's pernicious and no doubt pretextual. But the record is papered with all kinds of statements by legislators in this building about Mr. Krasner. So they made up their mind about him in a way that you don't like. But how does that make it irrational?
Because the statute. Look, respectfully, I think I win either way. The statute says we're not singling out, let's assume that they're right that the statute doesn't single out Philadelphia. Okay? If it doesn't single out Philadelphia, then who gives a hoot what you think about D.A. Krasner, let alone things that just to be clear, we think are completely counterfactual, that when you look at the record facts, he, in fact, was proceeding with prosecuting at the rates on SEPTA with prior administrations and for serious crimes and with respect to similar. But if the view is it's not about Krasner, it's about first-class counties, then if there's another first-class county, there's no support. Alternatively, if they say, well, it really is about D.A. Krasner, then it's a slam dunk per se unconstitutional statute because it's a closed class.
What if it's just about facilities?
If it's just about?
What if it's just about facilities and it has really nothing to do with Krasner? What if the General Assembly passed a law that said all prosecution of crime occurring on state-owned property in Dauphin County must be prosecuted by the Attorney General, thereby divesting the elected Dauphin County District Attorney of authority? Would that be a problem, since it's a focus on a General Assembly policy judgment that we want crime that occurs on state property to be prosecuted by the statewide prosecutor?
if there is a distinction between that preemption for Dauphin County and there is concurrent jurisdiction for all other counties, that's a prohibited law. If it is because you run afoul of the special laws provision, if you're just singling out Dauphin County, so that's violative. Look, there's another, and so I think that's really the short answer. Let's be clear, it's in our briefs, and I don't want it lost, that if there's going to be a special law, and if this is in fact recognized as a special law, which I think it is, there's a mandatory requirement on Article 3, Section 7, that there be notice. And
I'm not sure you preserved that violation.
we did. We raised it in the Commonwealth Court, in our briefing.
Not in your petition for review in the Commonwealth.
Didn't need to be.
Yes, it did. At least I view that it did. It's a separate constitutional challenge to the passage of the law. It's a procedural constitutional challenge to the passage of the law.
We regarded it as a defense to an argument that they raised.
Okay.
That is, we just didn't, you don't have to raise every constitutional defense in your initial petition. After we filed our petition, we got their answer and we learned what their responses are, and therefore we proceed. So respectfully, I don't think, I mean, this issue's been kicking around a long time.
Fair argument.
They've had fairness, they've had a fair opportunity to address it in the Commonwealth Court. They knew it was there at the time. They had ample opportunity to reply to it, and it was here in front of this court in day one.
Would you wrap up, Mr. Summers?
Yes. Act 40 is really an historic challenge to the district attorney and to Philadelphia. Broadly speaking, to the powers of the district attorney, specifically with respect to the Philadelphia district attorney, it's a law targeted to him because of a difference of opinion about policies. It is clearly got two fundamental sets of problems. One basket of problems are that it's a special law that singles out Philadelphia, that for which there was no notice, and secondly, because it's stripping the authority of a district attorney, it's different from other officers. And that's what that's the first set of arguments that I raised, that the supersession is a particularly odious and constitutionally infirmed statute. Thank you very much.
Thank you, Mr. Summers. Let's hear from Mr. Mullen.
Thank you. Madam Chief Justice, and may it please the court, my name is Daniel Mullen. I'm here on behalf of the Attorney General. With me here today is Matthew Haverstick, counsel for intervener SEPTA. We're very familiar with this court's no piling on rule, and we have divvied up the issues accordingly. I'm going to address whether Act 40 violates Article 3, Section 32, the Local and Special Laws Clause. That includes the equal protection aspect of that challenge. I'm also going to address the related issue of whether the DA preserved his notice claim under Article 3, Section 7. That leaves Mr. Haverstick with everything else. The Article 9, Section 4 claims, whether the DA has standing to assert the rights of criminal defendants, and whether the DA preserved his delegation claim. I want to begin with Justice Dougherty's question to my friend about Article 3, Section 20, and then I want to turn to Article 9, Section 13, and explain why my friend's position on that clause is frankly untenable. Beginning with your question about Article 3, Section 20, as you'd note, it provides that all laws relating to each class shall be deemed general legislation under the Constitution. And on pages 39 and 40 of our brief, we cite a series of cases that support our reading of that provision. And I want to quickly discuss the one that I think is the most important. It's Haverford Township. It's a 1942 case. This court upheld a statute requiring the appointment of a police civil service commission for first-class townships only. And this court said that the plain language of Section 20 makes it clear that the legislature can classify municipalities and that laws for classes so provided shall be deemed general for all purposes. And this court went on that the purpose and effect of this amendment was not to contract, but to broaden the latitude allowed for the legislature and to eliminate any controversy about the creation of classes containing only one member. So Section 20 recognizes that we can have a class of one member, and the General Assembly can legislate for that class as it sees fit. And my friend, frankly, does not respond to any of those cases in his reply brief. Turning to Article 9, Section 13, my friend's position is untenable for two reasons. One, Justice Robson, as I think you noted, there's nothing in the text that supports it, and that should be enough. But I'll also highlight that in 1968, it was put to the people of Pennsylvania whether to keep that provision or not. It was initially adopted in 1950. By 1968, the consolidation had been complete. A charter for the first-class city had been in place, and the people of Pennsylvania decided to keep it verbatim. And so if they felt it had outlived its usefulness and was just this one-time thing, and it's over once the consolidation happens, why is it still there? And so the reason is the people of Pennsylvania recognized that it was giving Philadelphia a structure that no other municipality in the Commonwealth was getting, this consolidation of city and county authority into one entity. And it wanted to make sure that it could be kept in check. And so it carved out two exceptions to the local and special law provision, those that regulate the affairs of Philadelphia, and those that prescribe the powers and duties of Philadelphia officers. And so we think that this case can be resolved on the plain text of those two provisions of the Constitution. I welcome the court's questions.
Are you going to talk about the notice provision?
Yes, I'm happy to address that. And I think it's important to quickly go over the timeline of events in the Commonwealth Court. So the DA files his petition, does not raise the issue. We have a status conference with the Commonwealth Court, and it's conceded that there are no fact issues involved in the case, and we can just decide it on legal argument on the briefs. Then he files his application for summary relief, again, does not raise the notice issue. Then he puts it in his brief, and our position is it's waived and it turns on fact issues. So we were not actually given the opportunity to build a record about whether notice was provided. And there's a presumption under this court's decision in Perkins that notice was complied with when a statute is passed by both houses of the General Assembly and is signed by the governor. And so because he didn't raise it in his petition, there was never an evidentiary record developed on that point.
Any other questions? Any other questions from the justices? Well, you're getting off easy.
I'll take it. Thank you, Chief
Mr.
Justice.
Mullen. Let's hear from Mr. Haverstick. How many times have you argued before us, Mr. Haverstick?
Your Honor, I think it's around 15 or 16.
Yeah, we see you all the time. Welcome back.
I hope that's not a signal. Madam Chief Justice, Your Honors, may it please the court, my name is Matt Haverstick, and I represent SEPTA. And Your Honor, in a lot of those arguments, the alpha and the omega of the argument is this, this green book, the Constitution. And I can say in the continuum of those cases, this one becomes relatively easy because there is zero text in the Constitution that somehow elevates the district attorney to a super constitutional or ultra constitutional officer. The duties of the district attorney are not prescribed in the Constitution. They are purely statutory, as are the powers of the Attorney General. I dare say if either of those officers has a role defined in the Constitution, it's probably the Attorney General, but it's certainly not the district attorney. What does that mean? Well, sort of obvious, right? I mean, the General Assembly decides what the duties and jurisdiction of a district attorney are. That's exactly what's happened here. This is not novel. This is not unique. OAG has exclusive jurisdiction over some crimes, for instance, violations of the Lobby Act. That's entirely OAG. I think you can argue credibly that in environmental cases, because they're referrals from DEP, that's almost always exclusive jurisdiction inside OAG. Again, this is not special. It's not unique. there's nothing, I think, here that is of a constitutional dimension.
Well, it is special in the regard that the law, if it was just a law that preempted, or preempted is probably the wrong word, supersession or whatever the proper terminology is, all crimes that occur on all SEPTA properties are vested in the Attorney General, that would be one thing. But this law does differentiate between crimes that occur on SEPTA properties in the city of Philadelphia versus crimes that occur on SEPTA properties outside of the city of Philadelphia.
Well, only for the supersession.
Well, that's what I'm
procedure.
saying. And that's really, if there was an argument that piques my interest in this case, that would be the one I would really focus on, because you have to concede that there is a disparate treatment between the elected prosecutor in Philadelphia and the elected prosecutors in the other counties.
Well, and I think that's allowed by the Constitution. I think, as articulated during the argument, the Constitution deliberately treats Philadelphia different than every other municipality in the Commonwealth. We can all wonder why that is, and maybe it'll change someday, but the words are what they are. I mean, it says in the...
By hypothesis, could the lawmakers have, instead of superseding on SEPTA, could they have said, we're taking away all your felony prosecutions? Or all your misdemeanors, or all your death penalty cases, or, can they do that? Is there any limit?
There's some outer limit where you've taken away so much of the authority of a county prosecutor that I think you've effectively removed him in a way that is not prescribed by the Constitution, that is by Senate address or by impeachment. But we're a long way off from that. And
we have case law fighting those battles, because we've had statutes that have withstood constitutional battle on basically eliminating all duties of elected school boards, all duties of elected. I mean, there's some. They still get to do some things, and I think that's what saved them. Yeah. but the complete omission of the office, other than to keep the pay and sit at the desk, that might be the.
I think I'm on solid ground saying if the statute eliminated every single duty of an elected district attorney.
That's too easy a case.
You're right. That's why I like it.
I'm asking you I think it's a harder question.
You are.
If you're right. If you're right that the General Assembly could do this, what's the principled reason that they couldn't just cleave out all the felonies or all the misdemeanors or, all the armed robberies or whatever? What's the principled difference?
Well, look, the principled answer is I think there is a lot of latitude for the General Assembly to take away jurisdiction from one prosecutor and give it to the chief law officer of the Commonwealth, and that's the Attorney General. Now, but look, I mean, that's not the statute, right? This statute doesn't take away jurisdiction from the District Attorney of Philadelphia. It grants jurisdiction to a designee of the Attorney General who shares concurrent jurisdiction with the District Attorney, and only in those cases, which may never happen, where there's an effort to supersede in Philadelphia, could you argue that the district attorney has lost something? But up until then, they both have jurisdiction over crimes on SEPTA.
But suppose it was a situation where the General Assembly cleaved out all prosecutions superseded the DA, gave it to the Attorney General for certain neighborhoods of Philadelphia. I mean, you'd come in front of us then and say, well, Article 9, Section 32 is the exception to the special law provision. I mean,
but I might not.
What's the stopping point there?
But I might not, because I'm not sure that you can stretch the language in Article 9 that far, because it says Philadelphia. It doesn't say wards of Philadelphia. It doesn't say neighborhoods of Philadelphia. It doesn't say zip codes of Philadelphia. It says Philadelphia. And I think the principled argument that one can make is, yes, we can treat Philadelphia differently. Beyond that, you ask a very fair question, but I think the answer is, Your Honor, you probably couldn't treat different neighborhoods in Philadelphia differently, at least under that section of the Constitution. There might be another argument that...
Mr. Haverstick, let me follow up on that. What's within SEPTA mean?
Say again?
What's within SEPTA mean?
Well,
I live in East Tarsdale, I live right near the Tarsdale train station, within a couple hundred feet. If somebody breaks into my house, who's got jurisdiction on that?
so look, Your Honor, I think, I don't want to give a glib answer, but I think within is a pretty universally understood term, but.
Tell me what it means.
Well, I will. If you go to the definition section in Chapter 17, where it's talking about metropolitan transportation authorities, I think there's a definition for transportation systems, and it lays out what that is, like all of the places that are within a metropolitan transportation authority. And I think that's the answer, because if you look at it, it talks about on the cars, on the trolleys, on the buses, at the stations, in the right-of-ways, in the powerhouses. I mean, so I think that's what it means.
So basically, Mr. Krasner would have no jurisdiction, say, for anything happened anywhere in Suburban Station, for example?
Well, he certainly wouldn't, Suburban Station. I was thinking of something else. I was thinking of the one in Monaco. No, he has jurisdiction there because it's concurrent jurisdiction. He has and shares jurisdiction with the special prosecutor. The only time that we got
superseded at will by the special prosecutor.
Well, let's talk about that for a minute, because I think the supersession discussion and this talismanic effort to elevate, two cases that were before the Commonwealth Attorneys Act and two cases that were before we constitutionalized the Office of Attorney General bear pretty close scrutiny. And what those cases, Schaub and Shelley, did not say is that there is a constitutional dimension to supersession. They were talking specifically about two statutes and how you read those statutes and how you balance the authority of the elected DA with the unelected at the time Attorney General. But in neither of those cases was supersession disallowed, and in neither of those cases did anybody say, oh yeah, the DA can't be superseded because the Constitution says he can't. All of these powers and duties that we're talking about are statutory. And this is another statutory expression of when supersession can happen. Does that mean it's unchallengeable? No. I mean, I suppose if there was supersession and somebody like the district attorney thought that it was an abuse of discretion, he could come back to this court and say, I think this is an abuse of discretion.
How would that happen? And let's say either the district attorney or a defendant wants to challenge a determination to prosecute because the activity was, quote unquote, within SEPTA. Defendant disagrees. This is not within SEPTA. Where would that challenge be brought? Or where would the district attorney bring that challenge? How would that percolate?
Well, look, I guess I got to think about I think you'd have to file, if it was a district attorney, I think the district attorney would have to file a PFR in Commonwealth Court because it's a designee of the Attorney General. So I don't think it would properly lie in Philly Common Pleas.
Let's go back a step. I mean, if the within SEPTA is outside of Philadelphia, there's a process that takes place.
Right.
In writing. The supersession is in writing, and then the agreement is also in writing. How does it happen in Philadelphia?
The statute prescribes that the special prosecutor notifies the district attorney's office that the special prosecutor is going to take over the case, and that's supposed to trigger mechanically the transmission of files and papers and all the other stuff that happens. And I guess if there's a grand jury, they figure that out.
And there's no court involvement of any type?
No, not written into the statute. Okay. But if Schaub and Shelley are helpful to Mr. Krasner in any way, it's describing what I don't think is a remarkable innovation in the law, and that is that authorities have to exercise discretion when they're using their power. And just like in those cases where, in the first it was the AG on behalf of the governor going to court, and then I think in Schaub, I forget the procedural I forget the procedural posture, but somebody went to court. Somebody went to court and challenged the exercise of the discretion.
And there's nothing in the statute, but your point was Commonwealth Court has jurisdiction. If they want to, if the DA wants to sue the special prosecutor or the Attorney General for exercising their discretion, file a declaratory injunction and seek a preliminary declaratory judgment and seek a preliminary injunction.
Isn't that exactly what happened in the opioid case? I mean,
Yes.
in the opioid case, didn't the DAs of Allegheny and Philadelphia sue the Office of Attorney General and claim, oh, you've superseded me and you've abused their discretion? So sure, there's an avenue for that.
All right, any other questions?
I do.
Okay.
Counsel, I've read in one of your amici, the Commonwealth versus McHale case from this court from 1881. Would you address that? Are you familiar with that? Or permit me. What I understand.
I think I know which one that is.
Back in the day, there was a challenge to the position of the district attorney or his involvement in alleged voter fraud, but this court had written, and quote unquote, it is said the appointment was illegal because the Constitution adopted by the Act of 1866 was passed, makes the district attorney a constitutional officer, and such he cannot be stripped of his powers by the legislator. There's little force in this suggestion. This is the important part. While the legislature may not abolish the office, it can control the officer. They can regulate the performance of his duties and punish him for misconduct, as in the case of other officers, and where he neglects or refuses to act, or where for the circumstances of a given case it's improper and indelicate for him to act, it is competent for the legislator to afford a remedy. My understanding is, as Justice, I believe it was Weck said, this legislation was in response to a policy decision by the General Assembly, in essence, to punish our district attorney, because they did not believe he was adequately protecting the citizens on the Philadelphia SEPTA transit. How does that play into you or go against your argument?
Well, for once, I'm not up here talking on behalf of some aspect or element of the General Assembly, so I can't, I can't speak to the intent, but I wouldn't and shouldn't, because I think the statute itself lays out the basic public policy reasons related to safety and security on the system that underlie the statute, and why the addition of a resource to the district attorney and to the people in Philadelphia in the form of a special prosecutor was a good idea. But McHale is, I mean, it's the case I was thinking it was, Your Honor, is sort of seminal whenever we get to these questions about the authority of the district attorney. And it came up in the impeachment cases too. And it really states a pretty basic but important proposition, and that is, the office may be mentioned in the Constitution, and you may not be able to remove the person in the office except by use of the Constitution. But what the person's job responsibilities and jurisdiction is not in the Constitution. And therefore, the General Assembly can largely do what it wants in terms of defining the jurisdiction of the office and the officer. And let's not forget, the district attorney didn't start out as a constitutional officer. He was a statutory creation. He was created by a statute in the 1850s. Then he was put into the Constitution to make it so that he was an elected official, but nothing more. So the history of the district attorney in our Commonwealth has always been one where the jurisdiction of that elected official has been defined by the General Assembly, which is, again, why this Act 40 is not that remarkable. And thank you, Your Honors.
Thank you. And Mr. Summers, Mr. Mullen, and Mr. Haverstick, tremendous arguments. Great job by all three. Your clients were well served today, and we'll take it under advisement.
Thank you.
The Acting Consumer Advocate versus Pennsylvania Public Utility Commission et al., representing East Whiteland Township, Mr. Matthew Shapiro, representing Mr. Penn, Mr. John Aplt, representing PUC, Ms. Erin Tate, and representing Consumer Advocate, Ms. Christine Cooper.
seems to be our week for PUC cases. In this appeal by allowance, Aqua Pennsylvania Wastewater, Inc., which is a public utility, entered into a voluntary asset purchase agreement with East Whiteland Township to purchase the township's municipal wastewater system. Aqua thereafter filed an application with the Public Utility Commission for approval of the purchase agreement. The PUC approved the application, finding that Aqua and the township satisfied the substantial affirmative public benefits test by demonstrating that the proposed acquisition's increase in customer rates was outweighed by other factors arising from the purchase, which substantially benefited the public. The Office of Consumer Advocate appealed that determination to the Commonwealth Court, contending that the acquisition was not in the public's interest. The Commonwealth Court reversed the PUC's determination, reasoning that the primary public benefits found by the PUC, such as Aqua's size, technical and financial fitness to operate the utility, and the economies of scale which would accompany a large public utility's acquisition of a municipality's wastewater system, would exist in any purchase of a municipality's wastewater assets and were not specific to the transaction at issue. Further, the Commonwealth Court held that the township's wastewater system already provided the same or similar services as Aqua would provide without an increase in customer rates. Our court granted the petitions for allowance of appeal filed by the PUC, the township, and Aqua to review the Commonwealth Court's application of the substantial affirmative public benefits test. Please proceed.
Madam Chief Justice, Your Honors, may it please the Court. Matthew Shapiro, Obermayor, Redmond, Maxwell, and Hipple, and I have the pleasure of representing East Whiteland Township. We have supervisors, people from the Township Manager's Office, and the Township Solicitor in the audience behind me. I'd also like to introduce my colleagues, Tom Wyatt and Matthew Olish, who are in the audience, worked on this case, and in particular, Melissa Blanco, who is sitting directly behind me. And to the extent we got anything right in our briefs and I get anything right today, it is likely because of her. I hope
Well, if she passes out, we'll call it one.
Get ready.
I do feel compelled now to add, if I get something wrong, it is undoubtedly because I forgot what she told me. In terms of traffic keeping for this argument, I'm obviously going to start and give an overview and I think generally describe what we all believe the Commonwealth Court did wrong. I will be speaking specifically from the point of view of the township and the public. Mr. Povolitis will speak next on behalf of Aqua. He will be speaking from the point of view of a certified public utility and specifically to 1329 and how the policies of regionalization and consolidation play from the point of view of a certified public utility. And Ms. Tate for the PUC will be wrapping up, and she will be speaking to the appropriate deference that the PUC ought to be afforded by the Commonwealth Court. We've obviously all discussed this, worked in advance to try and eliminate redundancy, and I know Mr. Povolitis and Ms. Tate will be listening to the questions and be ready for whatever I punt on, and hopefully we'll tick things off if we cover them while I am speaking. If that works, I will proceed.
Please.
This case, I believe, distills to a very simple question, actually. And the simple question is, when can the Commonwealth Court reweigh the facts, rewrite the statute, and reverse the policy decision of the township to avail itself of an avenue afforded by the general legislature to get out of the wastewater business? And I believe that the answer to that very simple question is never. And it's never, Your Honors, because the PUC does the facts, not the appellate courts. And it's never because the General Assembly writes the statutes, not the appellate courts. And it's never because the General Assembly and the PUC, to some extent, get to do policy. The appellate courts don't do policy. And I think that those simple principles decide this case. And I will address the kind of three ways in which I think the Commonwealth Court ran afoul of those principles. It went off the tracks. I think I will assume in the best. It had good intentions of protecting the public, but I think it didn't because it ignored those principles. And I think it ignored them in, again, reweighing the facts, rewriting the statutes, and doing policy.
Counsel, before
Yes.
you move on, remind me, when the PUC reviews the determination of the administrative law judge, what is their scope and standard of review,
The administrative law judge gives a recommendation.
right?
So, in fact, the PUC is free, not just free, I would say, actually obligated to make initial findings. I mean, I almost don't even want to call it de novo on everything because I think all they get from the ALJ is a recommendation. So the PUC reviews the entire record, right? It's
And the record is made before the administrative law judge.
So the record is initially made before an administrative law judge. The PUC, I think, then has the choice of whether it expands the record or not. But the PUC is the decision maker. The PUC is assigned by the General Assembly
Right.
to
I get
find
that.
the facts and make the findings.
Just really wanted clarification, since the PUC rejected the recommendation of the administrative law judge.
That is correct. It did, Your Honor. And the PUC, and what the PUC did in rejecting that recommendation to start is it actually weighed the facts and the evidence. It determined credibility. As any fact finder in this Commonwealth, it was free to accept some, none, or all of the evidence presented to it. And the PUC did that job, and the PUC made abundant factual findings. I actually think in many ways this case starts and ends on page 1786 of the record. On page 1786 of the record, the township manager lays out the abundant benefits that the township sees in this transaction. And the PUC heard that. The PUC hears the testimony, and the PUC found that credible. It also found additional testimony from Aqua credible, and the PUC goes through in about 4, 5, 6 pages the findings of fact that it makes. And the Commonwealth Court actually recognizes this, right? And I think it's on page 10 of the opinion, but it's the page of the opinion that has only a few lines at the top and a huge footnote. Because in the huge footnote, the Commonwealth Court goes through all of the findings that the Commission made. It goes through all of the factual findings of a benefit, of affirmative public benefits that the Commission made. And at that point, the Commonwealth Court's role is not to say, do we agree that these are benefits? If this evidence is before us in the first instance, do we find that there's an affirmative public benefit? No. The Commonwealth Court's job at that point, if it's doing facts, and this Commonwealth Court said it wasn't doing facts, which I'll continue to talk about, this Commonwealth Court recognizes all those facts are found and then decides that it doesn't like those facts and it wants to reweigh the credibility and reweigh the facts. It actually says in the last footnote of the opinion, appearing on the last page, that it isn't doing facts. All it's allowed to do as to facts, and this court knows this, in any appeal from a agency decision, we have a statute, section 704, which says what the Commonwealth Court, and in turn this court, is actually allowed to review. It can review for a constitutional question, which is not the case here. It can review for a violation of PUC procedure, again, not the case here. It can do legal review, which it gets to do de novo. And in a confusing-esque sense, I think that's what the Commonwealth Court here says it's doing, because it doesn't want to say what it's actually doing.
Well, counsel, can I just stop you there for a minute? Because I do want to take issue with your characterization of the Commonwealth Court not liking the facts. I don't want to try to get into the mind of what motivated a judge. So I'm a little concerned about your characterization that they were motivated to write the opinion they wrote because they didn't like the facts that were found by the PUC. I think if you look at the words that the Commonwealth Court chose instead of trying to ascribe it some sort of improper motive, the Commonwealth Court felt that the benefits that the PUC relied upon did not meet the statutory definition of affirmative public benefits. They looked at they sort of accepted them, but they said, from a statutory perspective, those don't work. Isn't that really what the court said as opposed to what you think they wanted?
So first, let me say I agree with Your Honor, and I apologize if I appear to be characterizing what was in the Commonwealth Court's heads, because that's not what I'm trying to do. But I think that what the Commonwealth Court did was say that the facts, let me step back. Whether there is an affirmative public benefit is a factual question. This court has said that quite clearly and repeatedly over 30 years. So I think the question that the Commonwealth Court is weighing is there an affirmative public benefit? And I think its role in determining that fact, in determining that question, is to ask, it can ask two things. It can ask whether there's a legal question about it, or it can ask whether there is substantial evidence to support a necessary finding. And I will read for Your Honor, because I think this answers, and maybe this is where I used words that I shouldn't have. But in the kind of penultimate paragraph just before the conclusion, the Commonwealth Court says, the benefits or potential benefits arising from the aspirational statements of ACWA and its technical, financial, and operational assistance are not substantial enough to outweigh the known harms of this proposed transaction. And so when the Commonwealth Court is weighing the benefits against the harms, declaring some of them aspirational, some of them heavy, some of them this, some of them that, it is doing the PUC's job. It is doing the PUC's job because that's what this court tells us about administrative review, and specifically administrative review under Section 1103 is supposed to operate. Was that a fair response to the?
I think that's better phrased.
Thank you.
Can I follow up?
Yes, Your Honor.
So, and I suppose we're going to get into this with counsel for PUC, but it's evaluation of a fact. It's not interpretation of a statute. Is that right? The enterprise you were just talking about there.
Yes, the weighing, that's absolutely evaluation of fact. Yes, Your Honor, yes.
And the public benefit?
Yes.
Matter of reviewing the fact record. It's not interpreting what a statute is saying, right?
I believe that, yes, Your Honor, yes.
So your position is that whether or not there is an affirmative public benefit or using the city of York in some substantial way, you're saying that is not a question of law based upon the facts? I'm asking.
Correct, Justice Donahue, with the exception that I'm saying Your Honors said that in City of York and Elite and Popowski Verizon, right? Your Honors have made that clear over 30 years that that's a question of fact.
Well, I think we've said that whether there is an affirmative public benefit is a question of fact. I don't think we've statutorily, or we've defined what the General Assembly intended by the phrase affirmative public benefit. And that, to the extent that statutory construction principle would be presented to us, we certainly could reach that. If somebody said, so, what did the General Assembly mean by affirmative public benefit?
Yes, except the statute, Section 1103, actually says necessary or proper for the good of the public. It lists a couple of reasons. Affirmative public benefit, that actually comes from City of York. That actually is Your Honors, not the general, well, predecessors to Your Honors. It's from this court.
Which has nothing to do with the language of the statute. The statute, I mean, you said it says necessary or proper, which is less than necessary.
I agree with that entirely. Proper is less than necessary. The statute controls. Affirmative public benefits is a test that this court created to help the Commonwealth Court and the PUC evaluate whether the statute is satisfied and whether there is an appropriate, now I'm being redundant, whether there's a necessary or proper purpose such that the certificate of public convenience shall be, and that's what Section 1103 says, shall be granted. And
why shouldn't we jettison the affirmative public benefit language that was created by court if we just simply examine the record to see if there's any necessary or proper basis to do this?
Because that's actually what your argument is. I mean, I'm hard pressed to think of a situation where, under your analysis, the PUC could approve the issuance of the certificate, and it could ever be touched. When would that be? I mean, you're saying the facts are binding, the weighing is binding. It's a question of fact, whether or not it is, an affirmative, substantial benefit to the public. I mean, how would that ever be touched?
So let me give a kind of couple examples, one which I think actually plays right into this case. If the PUC, in considering the affirmative public in considering whether, we'll do it the way that your honors have just suggested, if the PUC in considering whether the transaction is necessary or proper were to fail entirely to examine what impact there might be on the rates.
What does that mean exactly? I mean, I'm really, truly, I mean, that's why, I mean, this whole area is, I don't know, designed for affirmance. I mean, what does it mean that the court must consider in a general fashion the impact the acquisition would have on rates? What does that mean? There may be an increase, there may not be an increase. Is that sufficient? What?
I mean, I think that they have to pay attention to it. They have to show that
What does that mean? What does that mean?
Well,
Like, for
well,
example,
let me give the example. I'm
yeah,
sorry, Your Honor.
okay. Go ahead. You give me an example.
Well, I was going to give the example in this case, which is, in this case, we have 4 or 5 pages of analysis in the PUC opinion of the fact that the rate base, if the transaction goes forward, will increase, and therefore there might be an increase in the rates. Now, you don't actually know, and there's going to be a separate rate proceeding before any rates actually do increase. But what you know is there'll be a higher rate base. At the same time, you know that whatever the rates are will be spread across Aqua's other customers. So there's a lot of things to think about. But I think that Your Honor raises, I mean, we, in kind of thinking this through, had this question of, well, okay, they spent 6 pages considering it. Is that enough to satisfy it? It has to be enough.
I don't know the answer to that. I don't know the answer to that. I mean, and, you know, honestly, I mean, maybe I missed it, but I mean, Aqua, for example, is very active in this area and very successful in regionalization of the water and wastewater treatment facilities. But I don't see anything in the record that indicates what happened in other acquisitions. Did rates go up? Did rates go down? I mean, you know, the fact of the matter is, if somebody's going to consider in a general fashion, I mean, certainly what happened in the past would be interesting information in making that consideration. But here, I started with the proposition that it seems to be enough to say they could go up, they may not go up. We've considered it. End of discussion.
I think that that's right, Your Honor. I mean, I think what is directed to the PUC is to hear the evidence and hear the testimony. And what I think they have to do is there has to be some testimony about the rates.
Why? Why? I mean, you know, you're saying there has to be, but I mean, we don't, the legal principles don't exist just to sort of fill a void. I mean, there has to be some end game for any consideration of this nature that's taking place. Wouldn't you agree?
I would agree with that, but as Justice Robson already criticized me for trying to get in a court's head, far be it from me to try and get in this court's head when it said that you have to consider the rates, right?
In a general fashion?
In a general fashion, right. I agree with Your Honor. It's hard to know what wouldn't satisfy that, and I forget if it was
That's exactly right, and which brings me back to my first point. I mean, this seems to be an exercise just for the sake of, you know, having an exercise. If the PUC is going to be affirmed, and I mean, the only thing that I know is that if there's no consideration in a general fashion, none whatsoever, it's going to go back. But that's the only standard I see here at all.
Well, I mean, again, we're obviously here seeking a reversal, so, I mean, I think the Commonwealth Court got it wrong because I think, and this is an example.
They looked at it too closely. They didn't consider it in a general fashion. They actually considered it.
Well, they didn't defer to the PUC.
They did not defer to the PUC. I think they looked too closely at the rates, certainly. I also think they actually misread the law, too, right? I think they misread Section 1103, which says necessary or proper. And this court, again, has said or and proper are 2 words that the General Assembly deliberately put into the statute, and they have meaning, and the Commonwealth Court didn't consider that meaning. So, for instance...
That is applying a level of scrutiny not supported by the language of the statute. That's what you're saying the Commonwealth Court did.
I'm certainly saying the Commonwealth Court applied a level of scrutiny to this case that was not supported by the statute, absolutely.
But they used a standard that this court developed.
No, I don't think the Commonwealth Court
They
used...
said they did.
They
said
well,
they
I'm
did.
not even
They
sure
said
you're...
They didn't affirmatively promote. I mean, I'm not disagreeing with you.
No,
You know, the law says what it says, but
Yeah.
I mean, I don't think you could criticize the Commonwealth Court for applying a standard that we developed in City of York to give guidance to the application of the term necessary or proper, because that's what they did.
I agree with that, Your Honor. And when I was saying, well, I would push back on whether they use the standards, I think we're talking about different standards because I think they pull in an abuse of discretion notion where with a cite to a criminal case.
Yeah.
And frankly, that confuses me a little bit as I try and figure out how to tell Your Honors what the standard and scope of review appropriately is.
You're not saying they didn't apply the proper standard under the statute. You're saying they violated the appellate standard of review.
Yes, I think they violated 704, which has the 4 ways to go in, and it could have been one of 2, and it's kind of neither. And we could go line by line and try to explain what they were really doing, and I don't think we actually get there. And I think that's
You would agree under the law that the General Assembly passed and the governor signed that created the opportunity for these regionalization and these privatization of the authority. You would concede that a rate increase is the likely result. I mean, it's it's almost expressly contemplated by the statute. You can't, I mean, that's what I found was so interesting about the Commonwealth Court's decision. The General Assembly knew that these things were going to result in rate increases. They built that idea into the system. So why are we always looking at, well, there's going to be a rate increase? Well, of course there's going to be a rate increase. Why does that even factor into it? We know there's going to be a rate increase.
100%, Your Honor. You are 100% correct. And when I said of my initial 3 buckets, I had kind of facts, statute, and policy. That's the policy that I was speaking to. So in other words, we have 1329, and exactly as Your Honor says, Section 1329 allows for an increased rate base. It says we can do a fair market value transaction.
And the reason the General Assembly did that was because they wanted to encourage companies like Aplt to purchase, and they wanted to encourage municipalities who were stuck with a value for these facilities back in the day of when they built them to get fair market value for an asset. That's the reason.
100%, Your Honor, yes. And to say to East Whiteland townships of the world, you don't want to be responsible for your sewers, right? You don't want your police receiving the call on weekends and evenings that somebody's sewage is backing up in their lawn because of the latest storm, and we'd much rather not have our police after hours deferring to our 3 public works people who don't really have the expertise. We'd rather have Aqua come out and do that. We'd rather have Aqua responsible for that. We see that as an enormous benefit, and yes, the rates may increase. I agree. The rate increase, the concept of it is built in. There's conditions in many of these orders that determine how and when and how much. And there's obviously an entirely separate rate case that has to be brought in where, and now I'm going to forget the words, I think it's just and unreasonable is the magic language for the rate increase, but that's a separate proceeding. And in effect, what happens here, and in fact, 1329, and Your Honors, I know we wrote this in the brief, so I apologize if I'm repeating, but 1329 was passed in 2016, enacted in 2016, and there were transactions and people objected to the rate case, to the rate increases that happened out of it. And in 2021, the General Assembly had additional hearings at which the OCA and others complained about the rate increases, and the General Assembly could have amended, could have repealed, could have changed, and it didn't. And it left 1329 exactly in place. And the reason, Your Honors, is that rate increases are, I mean, I agree with everything the court has said. I think the Commonwealth Court looked too closely at it because sometimes rate increases are appropriate. They aren't necessarily a harm.
Mr. Shapiro, could you address the concept of aspirational benefits in the context of this case?
Yeah, because I think that's another fact-finding of the PUC that those benefits were not aspirational or nonetheless satisfied the City of York standard that you can't know everything that's going to happen and how it's all going to play
That
out.
doesn't mean it can't be considered.
It does not mean it can't be considered, and that's what this court said in City of York, and I think that the Commonwealth Court was not only wrong, but I think actually kind of inconsistent in the way it says that all of the benefits that the township and its witnesses and Aqua and its witnesses identified were aspirational benefits, whereas the rate increase, which, as we just said, has to go in front of the PUC, is not somehow speculative in the future, right? We don't know how the rate increase is actually. Again, I'm not arguing that it's not likely that they're going to go up. What I am saying is we don't know how much, and we don't know the circumstance, and we know that the rates will get spread out across Aqua's legacy customers, and we don't know what the expenses are going to be, and we know if the township keeps its wastewater system, that it's going to have to either increase taxes or increase the rates.
But that's a different issue. I mean, the rate increases we're talking about here are rate increases that are tied to the cost of the transaction. I mean, there will be other rate increases, I'm certain, by Aqua for improving the system and things of that nature, but this is recouping the cost of the acquisition that is going to cause a rate increase, correct?
So I'm going to push back a little, Justice Donahue, because until Aqua goes to the PUC with its petition for
But that's a different issue. I mean, but what they would be going to the commission with is a request for a rate increase to recoup the cost of the acquisition.
They very well might. There might be other things included in that.
But that's true. But you can't say that, you can't compare that to a situation where the municipality keeps the treatment plant. Because if they're asking for rate increases, it's going to be because they're improving the system or retrofitting it or something of that nature. Aqua could do that same thing, and likely will sometime in the future. But the rates that we're talking about are really tied to the cost of the acquisition. And there's nothing wrong with that. I mean, apparently the legislature thought this was just fine. And so I'm asking you the question, I'll ask your opposing counsel, why must the rate increase be considered in a general fashion? Isn't that a task that has no meaning?
If Your Honor is asking me whether this court should overrule the requirement that they even consider it,
Well, let me throw this.
I'm asking for my edification.
Yeah.
I'm asking so that I can make sense of what I see as an area of the law that uses a lot of verbiage that has no particular meaning at the end of the day.
I think the best I can do for you, Justice Donahue, is to tell you that I think at least requiring the PUC to think about the rates in a broad sense, I think is beneficial to the public to know that they're at least thinking about it, because these are meaningful transactions, right? How we deliver water in the future across the Commonwealth is an important thing, right?
But thinking about it in the context of it doesn't make any difference what you decide after giving some thought to the idea is really an empty exercise.
So in the sense of how we're considering tests and overall law that this court makes, I think that may be right. But I'll go back to, I have been in courtrooms many times where I think it was quite clear that either I, unfortunately sometimes, or the other side was going to lose. And I think nonetheless the judge let the losing side have their say, speak their words, have their day in court.
Why should it be, it's not in the statute. Why should there be this common law overlay mandating it? Why shouldn't it be permissive?
Again, Your Honor, I'd be happy to stand here and argue for overruling that.
Well, you would, because under the current law, the way it is, the PUC could use rate impact as a justification for denying one of these acquisitions. They could have weighed the evidence the same way that the Commonwealth Court did, and you still wouldn't have. in other words, it cuts both ways. So that's sort of why it exists, in the sense that it almost gives the PUC a way to deny these.
That's a very good point, Justice Robson. I think that's right. I think, for instance, if the affirmative benefits that were being pitched were that having clean water was going to make the grass grow greener on the Little League field and make the local team more likely to make it to Williamsport, and against that was the
I
rate...
appreciate the Lycoming County analogy. Thank you.
And against that was the rate increase, I would think the PUC might come out differently on that, yes.
Is it a one-way ratchet? I don't know the market. Is it, if, do rates only go up? In other words, if there's some competitor of Aqua out there, I don't know what kind of sunk costs are involved in this or the duration of these agreements, but if Aqua's competitor looks at this and says, wow, they're really overcharging, we can underbid this and do it better, does the market support that kind of potential for a subsequently lower rate, or is that just unrealistic?
I suspect that's unrealistic. I might toss that one to Mr. Povolitis, but I'm speaking just from my personal knowledge base, right? My electricity bill, my cable bill, all of the things that are regulated by the PUC, those things go up. And I actually think, in fairness, the reason those things go up is that I think that those entities actually are constrained in the rates they can charge by the PUC. And they're constrained by costs, and they're constrained by real-world things. So it's hard for me to imagine how they would go down. Though, as I even say that, let's imagine that Aqua or one of its competitors tomorrow develops the cheapest, most endurable, will never fail pipes in the history of the world, and they want to lay those pipes as the new mains for everything, and they require absolutely no maintenance, and they never fail. Then maybe our rates will all go down.
Not at first. They're going to build the cost of installing those pipes in there, and then they're going to go up. But
All right, are there any other questions for Mr. Shapiro? All right, thank you very much.
Thank you, Your Honor.
Hear from Mr. Povolitis.
Good morning, Madam Chief Justice. Madam Chief Justice, Justices, may it please this honorable court, I'm John Povolitis, representing Aqua Pennsylvania Wastewater in this appeal. Joining me as co-counsel in this appeal are Alan Michael Seltzer, James Mackerlane, Joel Frank, and Maureen Murphy McBride. I would like to address three particular issues, but I don't often encounter other legal minds that I can discuss the City of York case with. So I would like to address some of the questions that arose in the course.
Or who care.
Well, Your Honor, if I start talking about discounted cash flow, I will empty this room immediately.
Exactly.
First, City of York. A couple things to understand about City of York is that it became a landmark case because up until that point, the case law in Pennsylvania was that a transaction should be approved unless it imposed harm on customers. The significance of City of York, and it looked at that and said, these transactions are supposed to be in the public interest. There must be some affirmative benefit. So that's the origin of the affirmative benefit consideration, and that has largely continued to be part of Chapter 11 ever since. The other thing to consider, to Justice Donahue's point about what the Dickens is, consider rate changes generally. If you look at the facts of City of York, you basically had two companies that were going to combine. One company had higher rates than the other. So there was consideration given to, are we blessing essentially a rate increase here? There was no immediate plan to combine those companies, but nevertheless, it is an issue that could possibly arise down the road. So I think that is probably the origin of the court's words. The commission should generally consider that situation. As far as what the commission does in these transactions and why it continues to make sense for the commission to consider in a general fashion potential rate impact is the reality that these are application cases. They're not rate cases where every single cost element of the utility is reviewed, whether expenses are going up, whether they're going down, whether rate of return has gone up or down. All of that for the entire company, not just the acquired company, is being considered. I don't know that you could do more than generally consider potential rate impact. You certainly can't be specific.
Could generally mean actually, generally we know rates are going to increase, but specifically we don't know by how much?
That's correct, Your Honor. In fact, jumping ahead to what I think is a very interesting issue of what the Commonwealth Court called actual known harm, if every utility in Pennsylvania that increased rates was harming its customers, there would be nobody's certificate in Pennsylvania.
There would be no what?
No one would be certificated as a public utility because they are harming, they're imposing harm on their customers.
Counsel?
Yes, sir.
Correct me if I'm wrong on this. I mean, two different types of rate increases. One, in a situation where there's an acquisition such as this, there's an anticipation that there will be a recoupment of the acquisition costs, and that might result in a rate increase.
That's correct.
Separate and distinct from, we're improving the system, we're adding magic pipes, and that would result in a different rate increase. But generally speaking, as I understand what we're looking at here in a general fashion, is what the impact of the acquisition costs are going to have on a rate increase.
Yeah, there's an estimation of what is called revenue requirement that can be translated into potential rate impact. That's usually described in PUC cases as a range from 0 to some other percent. Of course, in this very transaction, one of Aqua's commitments is to invest almost $17 million over the next 10 years in the East Whiteland Township transaction. That is a future cost that would be addressed in the next rate case, the portion of that commitment that actually has been deployed at that point.
Right, but that's different than the acquisition cost.
That's different from the acquisition cost revenue requirement.
So the costs that need to be considered in a general fashion are those acquisition costs that may result in a rate increase.
The potential rate impact. I like to look at it as there are three things the Commission has to study when it's considering whether it should approve one of these transactions. One is, if it's a Section 1329 case, it has to consider potential rate impact. The other things it has to consider is the evidence on harms and benefits. We take issue with the Commonwealth Court characterizing the inevitable, as Justice Browson pointed out, upward pressure on rates from a Section 1329 determination, which basically takes original depreciated cost and elevates it to fair market value. That's an upward push on rates. It's inevitable. That's the expected operation of the statute. Yes, Justice.
Under Section 1329, both the buyer and the seller are required to provide expert kind of analysis on the cost of acquisition, fair market value. Is that correct?
Correct. That's correct.
Included in that actual expert report, does it include kind of a projection on the potential rate impact?
No, it does not, Your Honor. It's a very thorough exercise.
It's a separate analysis completely.
That's correct. All right. That's correct. Typically, the utility will take the acquisition price and extrapolate from that a revenue requirement associated with it and a potential rate impact, a range of rates. But those, one of the reasons, the statute, Section 1329, provides protections for the utility, its customers, and the public at large. It's an extremely thorough process. The first step is to get an independent engineering consultant that will determine that the assets are there and they're in good condition.
Both the buyer and the seller do that, right?
Yes, that's correct. And then both buyer and seller, from an approved list of appraisers, select an appraiser that does the fair market value calculation. The most understandable element of that process is that they take the original cost and they trend it forward to determine what the current market value of the assets may be. I'd like to address the issue of the Commonwealth Court disregarding benefits, specific benefits associated with consolidation and regionalization and the technical capability of Aqua. These are long-standing affirmative benefits that have historically been recognized. In fact, the Commission has issued 3 policy statements in which it encourages smaller companies to join and become larger companies. It does that because, based on its years of regulatory experience, the Commission has determined that larger water and wastewater companies are more likely to avoid becoming non-viable. There are also...
Are you using the term potential benefits to be synonymous with aspirational benefits?
Well, I think aspirational benefits are probably a little more general than more specific affirmative benefits. Take, for example, I think a misimpression that the Commonwealth Court's opinion gives is that the Commission didn't do much more than say, well, this is creating a larger company. That's consolidation and regionalization. That, along with being basically fit to provide service, that's enough, that it didn't look beyond that. If you break it down, there were specific affirmative benefits in the area of consolidation, regionalization, as well as Aqua's technical capabilities. In consolidation, the transaction basically took about 4,000 customers and added them to 45,000 other wastewater customers, making a much larger entity. That's like a 9% increase in customer count. And that wastewater company would be affiliated with a water company of over 400,000 customers. To be more specific, the Commission did far more than just look at creating a larger company. In the limited due diligence interval that Aqua had before completing the transaction, it calculated a 29% reduction in East Whiteland Township's operation and maintenance expense. This is more than saying there are likely a general aspiration. Oh, there are likely to be economies of scale here. This is a specific calculation of an $800,000 saving. That's very significant, and it creates the potential for more economies of scale savings. In regionalization, this transaction now permits Aqua, who already provided the water service to East Whiteland Township, to also provide the wastewater service. That means they can be more efficient in doing maintenance and replacement of mains. They can coordinate it between the water pipes and the wastewater pipes. Furthermore, this isn't the only company that Aqua owns in Chester County. It owns several other water and wastewater operations. That establishes that there can be a more efficient use of its personnel in Chester County, creating savings and better serving the customers. As far as technical capabilities are concerned, the Commission did more than just say, well, this is a fit company. In the area of Aqua's capabilities, again, during the limited due diligence interval they discovered issues relating to inflow and infiltration. Without getting too much into the weeds, inflow and infiltration is the phenomenon where groundwater enters the pipes conveying the wastewater to the treatment plant. If you take the actual sewage and you combine groundwater, it increases the volume that the wastewater treatment plant has to process. Your costs go up unnecessarily. It already detected that. It also detected electrical safety issues, and of course there are other benefits relating to emergency preparedness and customer benefits. And also the Section 1329 actually supports the consolidation and regionalization policy in the following way. The policy statements of the Commission on Consolidation and Regionalization try to employ acquisition rate incentives to encourage companies to come together. But it was always restricted by the ceiling established by you having to use depreciated original cost to value the assets. Section 1329 broke through that limitation and created an incentive for both acquiring companies and municipal systems to come together in transactions and create a larger company. A point I'd like to make on the court's characterization of the potential rate impact as actual known harm is that, again, the potential rate increase is due to the ordinary operation of the statute. We can't imagine that the General Assembly deliberately legislated a harm that, when introduced into the transaction, actually tips the balance against approval of the transaction. The General Assembly cannot have legislated harm that basically undoes the potential for getting approval under Chapter 11. We agree with the court, the Commonwealth Court and OCA, that Section 1329 didn't change the Chapter 11 standard. However, what the Commonwealth Court has done in this decision is to essentially take off the scale certain affirmative benefits associated with consolidation, regionalization, and Aqua's capabilities. And it has required additional specific benefits to obtain approval. We think that basically changes the Chapter 11 standard.
Well, counsel, on that point, under 1329, I think this is what Justice Donahue's point was, almost every acquisition under 1329, if it's consistent with the statute, would have an affirmative public benefit, at least under your view, because the General Assembly made the policy decision that there's an affirmative public benefit to allowing these things to happen.
That's correct, Your Honor.
So there's really, it's almost like these transactions, unless there's something wrong with the acquirer, a fitness issue, or the anticipated rate increase is exorbitant or something like that. The General Assembly's already made the policy decision that these acquisitions have an affirmative public benefit. Is that your position?
Yeah, so you think it's definitely encouraging the combination of companies with the inevitable potential rate increase from the higher fair market value.
So then I'll ask you the question. Why do we consider, quote unquote, in a general way, rate increases?
Well, there's still, you are dealing with a fluid purchase price. The way Section 1329 operates is that you get a appraisal value for the assets from each of the appraisers, and then of course there is the actual transaction price. The average of the appraisals is compared to the purchase price, and the lowest number will be the value of the transaction and what is allowed to go into rate base in the next rate case. In this very case, OCA litigated some issues taking issue with how the appraisals were calculated. In fact, the Commission sustained some of those objections, and in fact, the purchase price was not the ultimate rate-based value of the East Whiteland Township system. It was actually about $500,000 lower. So that is the number that will become the rate-based addition in the next rate case. Now, OCA may, in their argument, point out that since the Commission decided the application case, there has been a subsequent Aqua rate case. And in that rate case, the revenue requirement associated with East Whiteland Township, stipulated to by Aqua, OCA, and other parties in the case, was actually higher than the estimated revenue requirement of the transaction in the application case. But what the Commission has said is that what is really relevant about the potential rate increases is not the range of potential increase that could occur. For example, in the recently decided Greenville Sanitary Authority case, decided December 2024, it's attached to Aqua's reply brief. The Commission noted that the potential rate increase, the high end of it, the range, was 180.85%. But it said that even if that becomes the rate, the important point is that this is still a substantially lower rate than Pennsylvania Americans' current monthly rate of $133 a month. So the commission continues to look at this issue and sees other ways of judging in a general fashion the potential rate increase.
And finding it's okay.
Well, I think, you can't predict what the facts of a future case may be. That's one of our elemental points here, is that the commission has to look at the evidence on what the potential rate increase is and what are the other harms and benefits. And the commission has to be the fact finder, do the balancing, give weight to the various elements of evidence, and make a final decision on whether there's net affirmative substantial benefits.
Are there any questions for Mr. Are there any questions for Mr. Pawlowski? All right, thank you, sir.
Thank you.
Let's hear from the PUC, Ms. Tate.
Good morning. May it please the court. I'm Erin Tate. I'm representing the Public Utility Commission in this matter. I'm joined by my co-counsel, Colin Scott, and I believe that our General Counsel, David Screvin, and Deputy Chief Counsel, Sharon Webb, are also attending. I am going to address the rates in a general fashion, or at least I'm going to try to. But I'll get to that. But this, for the PUC, is a matter where deference was not extended to the commission.
Deference to your view of what the statute says, or deference to your fact-finding, or both?
The fact-finding to the commission. The commission.
Because I thought
That's a really good answer.
Yeah, that's a good answer, because in your brief, you demand deference to your reading of the law, and I thought that's what we're here to do.
Well, the law, the 1329, is pretty unambiguous, but 1103 is the statute where the PUC is charged with considering the affirmative public benefits, and those are factually based.
Yeah, that's a fact finder, right? So what do you mean? Or let me ask you this: are you standing on the assertion in your brief that you're entitled to demand deference to your understanding of what public utility law is? Wouldn't it be better to say you're here to persuade us rather than to command us?
Of course, I'm here to persuade.
Because your brief says we must give deference
to
your understanding of public utility law. I just don't understand that argument.
Well, the commission is charged with evaluating these transactions and considering the facts, and they are entitled to deference unless there's been an abuse of discretion, which is whether the PUC's judgment is unreasonable, it's part prejudice, bias, or ill will, and this doesn't fall into any of those categories. This is
just one more, and then I'll stop on this. So is it the commission's position that it is entitled to deference on fact finding, but not entitled to deference on what the law says?
the law, the PUC statute, when it's interpreting the PUC statute, then the PUC should be entitled to deference unless it's abuse, there's an abuse of discretion.
I want to ask you about that, and I understand there's some old case law, and you've cited some of it. What's the basis for that? Isn't what we do interpret statutes? Don't we want to hear what you think about it without having to defer to what the statute says?
You want to hear what the PUC, do I understand your question? You want to hear what the PUC thinks about the matter, or thinks about the facts rather than what the statute says? I mean, they're applying the fact. Am I not understanding your question?
Just a moment ago, I thought you reiterated something you do say in your brief, that you're entitled to deference on what the Public Utility Code means.
When we're interpreting the law as from the Public Utility Code, when we're interpreting the facts from the Public Utility Code,
No. You're mixing facts and law. I understand the deference on fact-finding. Mm-hmm. But there's a code, right? It's a statute passed by our General Assembly. these folks downstairs, they wrote a law, the governor signed it, and it's our job to interpret it when it comes to court. Are you with me on that?
Yeah, I am.
Okay. So where's this other piece come in that you're entitled to come in and demand deference on what that law means?
Well, when we're interpreting, when we're interpreting our statute, then we are entitled to the deference from the
That's what I
courts.
don't understand. It's your statute, because the General Assembly made a statute that governs your agency, you're somehow entitled to tell us what the statute means, and we're bound by that telling.
Well, you're not bound. You're not bound by what we say, unless we've abused our discretion. And in this case, we do not think that there has been an abuse of discretion.
Ms. Tate, could you consider rephrasing your argument to deference on fact-finding, yes?
Yes.
And advocating for your interpretation of the law, but not demanding deference to it?
Right, correct. I mean, we're not demanding the court do, I mean, the court's going to do what they do.
Well, deference.
Well, I'm not trying to be a semanticist here. I mean, I'm just asking you if you could acknowledge there's a difference, because I'm not asking you about your discretion or about your fact finding. I'm asking you about interpretation of law. And I don't fault you, because this court in decades past, has been sloppy on that in my judgment. I think there's a different enterprise when we're interpreting what the statute means. That's one of the things we do.
Mm-hmm.
And I'm very interested in what you think it means, but I'm not on board with deferring to you on that, because you didn't write the statute. You're the agency that's charged with enforcing it.
And interpreting it as it,
Yeah, but counsel, is this case about an interpretation of the statute, or is it about facts?
it's about facts.
Nobody's disputing about what the
Facts.
statute
It's about
means.
benefits and,
Yeah.
rates and,
Yeah, that's my point, is you didn't have to oversell it. You could have said, well,
You might have just block printed it from another PUC
Yeah,
brief
and
where
you
you
could
put down
defer-
your standard.
Defer that argument to a different PUC attorney at a different time.
Right.
and then I'll beat up on him or her.
that's the trend, right? That's what we get. But in this case, the commission was entitled to deference on the facts, because the commission is the fact finder in this matter.
No different than any other agency that issues an
Right.
adjudication is
Yeah, no,
entitled to deference on the
The PUC is not
fact.
entitled to special treatment. And here we believe that the Commonwealth Court reweighed the evidence when it examined the case, it reweighed the evidence considered by the commission, and that reweighing of the evidence led to the Commonwealth Court issuing an opinion that was contrary to Section 1329. The PUC applied the law as it existed at the time, and that's why I wanted to get into the rates. I mean, the law that it existed at the time, the City of York case was in effect, and it says you must consider rates in a general fashion. What is a general fashion? I don't know what a general fashion is, but the PUC did try to interpret that, and it was in the commission's order, and it was on page 44, and it said, and this is coming from my brief, the commission found that the proposed rate impact is a non-binding, and this is a quote, non-binding estimate of the incremental rate effect, and is used as part of the notice procedure to customers in Section 1329 proceedings. That's how the PUC characterized the rate impact. It's also characterized as a harm. Actually, the Commonwealth Court has characterized it as the ultimate harm that can never be outweighed by any evidence of other benefits.
But how is it even a consideration if the only evidence on rate impact for the transaction is the evidence and the rate impact that the General Assembly already acknowledged can happen? How could any 1329 transaction ever be approved if the harm that the General Assembly actually contemplated from a rate perspective is always there?
It's always going to be there. And even if this transaction is not approved, the record has indicated that the rates are still, and the parties acknowledge that the rates will increase regardless.
But those will increase without legislative blessing. Those will increase at the blessing of the PUC. Here, the rates that the Commonwealth Court focused on will increase as a result of legislative grace.
Right, they're going to increase regardless. I mean, the benefit, I think, because rates are typically characterized as a harm, but they could be, I don't know, a benefit, but Aqua is a regulated utility, so at least those rates come under some protections.
Lots of people get harmed, they don't realize it, and I appreciate the impact of increased rates on the pocketbook of consumers in the Commonwealth of Pennsylvania, but ask life insureds about the recent life insurance companies that have gone belly up because of inadequate rates. That harmed a lot more people because an insurance company tried to undercut the market. And the same thing could be true of a utility company, to Justice Weck's point, that tries to undercut the market with rates, ultimately gets consumers, and then can't sustain its operations due to inadequate rates.
So, I mean, the rates have been characterized as a harm.
But that wouldn't happen with the rates that are anticipated under 1329. Those rates are built into the cake.
Well, they
could decide to eat them, but that's probably not true, or we would have seen evidence of that, of happening in the past. But I guess I keep getting back to my point. I don't actually know why we're talking about this impact of 1329 rates when, by definition, those rates are going to increase as a result of the transaction.
Right. I mean, it is built into the statute. It was considered by the legislature, but the city of York, which was part of the law that existed at the time.
You want to give yourself some wiggle room, right? You don't want to argue you're bound by the statute. You, as the PUC, you want to have some wiggle room to still consider the statutory rate impact.
Right. I mean, you stated that earlier, and that, I mean, you can deny a transaction based on a rate impact, but I mean, I'm sure there's other harms that could be, but most of the time there's benefits in these types of transactions. But as far as abuse of discretion, the PUC applied the law as it existed at the time, but that wasn't good enough for the Commonwealth Court. And the court said that there are no benefits that differ substantially from the benefits that were already being provided by the township. And that statement by the court demonstrates that they did reweigh the evidence, and they reweighed the evidence by taking all of the benefits considered by the commission and characterizing them under the umbrella of Aqua's fitness. But they're benefits, regardless of whether they're fitness or what, they're still benefits. And the court then determined that there were no benefits. There could be no benefits from the transaction that were sufficient enough to outweigh any potential rate increase. And they said that because the township was providing the same services that Aqua was offering.
Well, didn't what the Commonwealth Court really say in their opinion was that the general benefits that were testified to were insufficient under these facts and circumstances to this case because they were looking for specific benefits?
Well, the court, they said that they were based on Aqua's size, the size of the company. But they did look.
Well, the size and the expertise of the company are the overall general benefits. In other words, coordination of assets, consolidation, all of those different things they talked about, generally speaking. I think what the Commonwealth Court said was those types of benefits happen in any kind of case where a larger utility acquires a smaller utility, but we want something specific to this particular transaction.
Well, there's still benefits, and the benefits were still
I'm agreeing
specific.
with you on that. That's why I'm asking the question. I'm saying they really ignored the testimony regarding the general benefits, and they said that happens in every case, but we want something specific to this case.
I mean, they did ignore the benefits. They did, and they essentially removed all of the benefits from consideration, which. But then they said they added something too. They suggested that the only benefits that could outweigh a rate increase is if the system being acquired isn't viable. And that's not part of 1329. And in fact, we believe it's contrary to 1329. I mean, waiting until a system is in disrepair before attempting a sale is not a benefit to the public. In fact, is a danger to the public. I mean, you can be risking some environmental contaminations. This is a wastewater system, but risking environmental contaminations or other catastrophes that could be associated with a non-viable wastewater system. Unless there's other questions that you would like me to address, I'm going to wrap up. But in this matter, the Commission followed the law as it existed at the time of the transaction. It properly weighed the benefits against the potential rate impact, which was the only identifiable harm. That's consistent with what is required of the Commission under Section 1103. So I do ask, how could the Commission have abused its discretion if it followed the law as it existed at the time? And even despite this decision by the Commonwealth Court, despite this decision, the Commission is still tasked, we're still evaluating these Section 1329 transactions. But now it's difficult for the Commission to discern what kind of benefits are enough, what is enough to outweigh an allowable Section 1329 rate impact. So instead of clarification, this decision has created confusion. And it is for these reasons that we are asking this court to overturn it.
All right.
Thank you.
Thank you, Ms. Tate. Let's hear from Ms. Hoover for Consumer Advocate.
Good afternoon, Chief Justice Todd and Justices of the Pennsylvania Supreme Court. My name is Christine Maloney Hoover. I'm of counsel at the Pennsylvania Office of Consumer Advocate. I too, like Mr. Provolitis, love having discussions about all of these things, so I appreciate the discussion so far. I really wanted to touch today on three key parts of the Commonwealth Court's decision that they found the Commission abused its discretion, committed an error of law, and its analysis was not entitled to deference. But the court applied the correct legal standard under 1102 and 1103. What it did, it found no net benefits. The court also confirmed what the McCloskey court said. Oh, I'm sorry.
I was just thinking, could you answer the last question that your opposing counsel just posed? Under the facts and circumstances of this case or any other case, what kind of benefit could outweigh what the Commonwealth Court relied upon, which was the potential rate increase?
Sure, I will do that. Let me just say that the McCloskey decision, which was the first decision about the interplay of 1329 and 1102 and 1103, had been issued, subject to check, I don't have my exact dates, but had been issued when the Commission considered the East Whiteland Aqua application. And I would note that in that McCloskey case, two things occurred. The most critical, though, was the Commonwealth Court's rejection of the Commission's argument that it couldn't possibly consider the rate harm because there were all these things that would happen in a rate case that they didn't have in the application case. And Commonwealth Court rejected that argument, yet we heard it again from Mr. Provolitis today. So it directed in the McCloskey, it was New Garden Township acquisition, it directed the case back to the Commission so that they would review the rate harms in the context of that case. And that was there for the Commission's knowledge and understanding of what they needed to do in this case. And why that's important is because the specific facts of each of these transactions are critical to knowing what the harms and the benefits might be. So in some cases, there may be smaller rate harms, for example. The range here for East Whiteland was between 66 and 130% rate increase. So in other cases, there might be less rate harms. There might be specific benefits to the transaction beyond the generalized aspirational benefits of Aqua's fitness that would be present related to there may be economies of scale. The record here did not support economies of scale. They were acquiring the customers at a higher cost.
Counsel, you used the phrase rate harm. Can you define what a rate harm is?
Sure.
To me, a rate, just so I give you my statutory definition, a rate harm is a rate that's unjust, unreasonable, or discriminatory. That's what the statute provides as a bad rate. So how do you define a rate harm?
Yes, I apologize for sort of the shorthand that I'm using. In the 1329 applications, if 1329 is used for fair market value, the commission sets the rate-making rate base related to acquiring that system in the application case rather than waiting for the next rate case. As part of the notice requirement to customers, Aqua, the buyer, calculates the revenue requirement associated with that addition to rate base. And Aqua also includes that first year of capital expenditures, to be fair to them. That revenue requirement is compared to the revenue that's collected from the seller's customers. And when you see a shortfall, so the customers of the acquired systems revenues, the rates they're paying to the municipality, do not cover that revenue requirement of the acquisition rate base, then there's a shortfall, and we've sort of colloquially talked about that as the rate harms. I agree that the rates would not go into effect until the first rate case and rate cases thereafter.
You define a harm as an increase.
Well,
Any increase is a harm.
Or the deficiency.
the deficiency, the
Which
revenue
is what is it,
shortfall-
$5 million annually in this case?
It was, yes, it was. To us, it is a harm. It may be bigger in some cases.
It may be just, it may be reasonable, it may be non-discriminatory, but it doesn't matter because it's harmful.
Well, the exact rates to collect that revenue deficiency, I agree with opposing counsel, that those rates won't be set until the next case. But the revenue shortfall will be collected either from the acquired customers or Aqua's existing customers.
Through rates.
Through rates that would be approved in that next case, yes.
Is it essential to your view that the question of rate increase be evaluated without regard to possible improvement in service?
Oh, no. We fully understand that the standard under 1102 and 1103 is to look at the benefits and the harms. And that must be done as part of the application case because, as Mr. Provolitis explained, I agree with him, it used to be a no-harm standard before City of York. Now, after City of York for the last 50 years, you have to show an affirmative benefit. And so both the harms, all harms, and benefits need to be looked at. Where we differ is that we think the Commission did not adequately address the rate harm or the revenue shortfall or the rate impact of that rate-making rate base.
How would they do that? I mean, that's where I get confused, because it seems to me that 1329 is going to anticipate in all cases some deficiency, as you described it. In this case, it happens to be $5 million annually. But I mean, there's going to be some deficiency. Existing rates are not going to cover the cost of acquisition. So, I mean, how can you refer to that as a rate harm when 1329 is built in such a way that that is going to occur?
So we do not think that 1329 does anything other than provide the buyer with a new way to calculate the value of the acquired assets.
An advantageous way.
Advantageous to the
order to
buyers,
encourage.
investors, and advantageous.
Or in order to encourage the investment.
Well, and advantageous to the seller.
I was about to say that.
It's advantageous to both.
Advantageous to both.
We certainly acknowledged in our testimony below that the fair market value is advantageous to the buyer and to the seller. This is not, but to the ratepayers of the buyer and the seller, it often, almost always, creates harm. But we think that's why 1329 didn't amend or change the 1102, 1103 standard. It gives them a valuation method, and it gives them that commission order that approves that new rate-making rate base in the application. They don't have to wait for the first rate case following the application. But it didn't change 1102 and 1103. The commission still must weigh the benefits and the harms. And so in some cases, the rate harm or the revenue deficiency may be relatively small if the fair market value is not multiples over depreciated original cost.
I'm still struggling with this use of the word harm.
Okay.
And I understand it comes from City of York, but the only authority that the PUC has to reject a rate is if it's unjust, unreasonable, or discriminatory. There's nothing about, and it harms consumers. By your definition of harm, every rate increase is harmful, period, every one. But the PUC's authority is not about, they have the authority to disapprove harmful rates. Any rate that seeks, any filing by a utility that seeks a rate increase is per se harmful. There's not, I don't know where that comes from. Maybe it comes from City of York, and I'll go back and look at that. But here, it's a rate, it's an obvious anticipated, although we don't know the amount of it, and maybe they won't seek it, but the General Assembly clearly knew that these acquisitions came with a rate impact.
I agree that in this case, there was a rate impact that would have increased rates in the future to those customers.
And the General Assembly knew that would happen, or could happen, or was likely to happen when they passed the law.
It certainly, that's why we think it's important in each of these cases to say what are the harms and what are the benefits. In this particular case, we didn't see any benefits that were any different, essentially, than what East Whiteland Township was providing.
Well, how about the benefit of $54.9 million?
Oh, yes, so we certainly agree the township benefits from the proceeds of the sale of its wastewater.
That's $54.9 million.
Right.
That frees the township up to use on other essential government services.
Yes, and we did not challenge that the township sees that benefit and that Aqua's investors see a benefit, right, from a higher rate base. But we explained and what we argued and what the Commonwealth Court understood, we think properly, was that in exchange for those benefits, the ratepayers of East Whiteland Township and the ratepayers of Aqua would see rate increases related to paying for those proceeds.
Which is what Section 1329 expressly provides for.
Well, 1329 doesn't always result in revenue shortfall. So there was a case where there was no revenue shortfall. There have been other cases where there have been other sizes of revenue shortfall, but there may have also been benefits. I mean, over 20 cases have been filed under 1329. Most of those cases have been settled or litigated without further appeal. There have only been a few appeals. In this case, we think that the Commonwealth Court correctly found that the Commission elevated its policy statement, did not address the rate harms, the revenue shortfall adequately, and I'll come back to that in a general fashion.
Can I ask you a question? It's something I don't understand. You concede that the municipality has a benefit from that. Mm-hmm. I mean, there's raw dollars, but there's also increase in other municipal services that otherwise may not take place. Why doesn't that benefit the ratepayers? I mean, the same ratepayers are going to benefit from those increased municipal services.
So we made a distinction between the benefits that the East Whiteland Township residents may receive from the township's use of those proceeds, from the rate impact that they will see in the future as a result of the transaction, and that's as ratepayers, then Aqua ratepayers. So we did draw that distinction, that they may see benefits as residents of the township from the proceeds, but as future Aqua ratepayers, they would also see the rate impact of paying for those proceeds. The proceeds, the rate-making rate base done under fair market value needs to be paid by someone, and it's paid ultimately by the ratepayers of Aqua and the acquired system rate.
Well, I agree with you on that. I think it's somewhat awkward for the municipality to say, and we're going to do all of this without increasing taxes on the part of anyone in the municipality. Well, but the people in the municipality are going to be paying increased rates for the wastewater services. So I'm not sure that that's a fair statement on their part. Somebody pays for everything is what it comes down to.
Right, and in the world that I work in, those are the ratepayers.
But in the context of that, that somebody's gonna pay for, what's the basis for the Commonwealth Court looking behind the PUC's weighing of, the rates go up, but on the other hand, you've got this better service, you've got these experts, you've got whatever else they talked about. So, are you not just looking at one side of the ledger? Isn't it proper to say the PUC looked at both sides of the ledger, and the Commonwealth Court's only looked at the rates, these so-called rate harms?
No, I think the Commonwealth Court correctly looked at both sides of the ledger, which is what we attempt to do as well when we litigate these cases. When we looked at the benefits that were claimed from the transaction, the benefits were tied, and we think aspirational and very generalized, which the judge saw as well, and Commonwealth Court. They were the kinds of benefits that come from Aqua being a fit water and wastewater provider. We didn't argue about that. That was never an issue in the case. What we said, and what the record supports, is that East Whiteland Township was also a capable wastewater provider. And they acknowledge that. That's in the reproduced record. So, yes, they would have access to some of the things that Aqua does because of its large size, but they would also have other things that they didn't currently have that may not be seen as a benefit by everyone, and they would also be paying a lot more in their rates in exchange for that. I don't think it's reasonable to presume that Section 1329 means that regionalization, fair market value carry the day at any cost to ratepayers, ultimately. I don't think that's a reasonable interpretation because the 1102, 1103 benefits harms test remains. So I did want to talk about in a general fashion. The difference with cases where fair market value or 1329 are used is that because of the determination of rate-making rate base in the application, the Commission has more information in those cases than they might have back in the City of York case where you had a merger of telephone companies. I think that language continues on, but the Commission needs to look at the harm like the McCloskey Court told it to do, and it didn't do that, in our opinion, because it relied on the aspirational statements, which weren't material or substantive here for the status quo type of transaction.
But again, your
statement was because, in your view, the existing authority in the township was operational.
Yes, yes. East Whiteland Township, and there are references in the testimony from OCA's witness Eastman, but also from the witness was from the township, but sponsored by Aqua, that East Whiteland Township was providing adequate wastewater service.
Was that the test? I mean, does it have to break down and start spurting sewage everywhere?
No, not at all. And I think the appellants want to sort of paint that gloom and doom, but I don't think that's at all what the 1103 standard says.
Was there consideration given to the current employees that were employed by the authority in the township that were doing the duties to operate the wastewater system?
My recollection, subject to check, is that those employees were going to be hired by Aqua post-closing, presuming they met the Aqua requirements for hiring employees. So there was consideration.
And I think I was asking a little bit of a different question because to the extent that I think the township attorney spoke, he talked about the concern of the police department responding to sewage calls and being taken off their police duty to respond to wastewater issues, which to me seems like an incredible harm to the township. And was that type of consideration factored in your analysis?
So actually, yes. There was a public input hearing testimony that was taken from customers of East Whiteland Township, and some customers of Aqua testified. And actually, that procedure that was in place for the township, a customer testified, my recollection is they testified that that worked fine, and there were very few times when that procedure had to be implemented. So they also expressed no concerns with billing and other issues that are pointed to by the commission as benefits of the transaction. So the public input hearing testimony, as always, is always very informative and address some of those on-the-ground operational
It just seems
issues.
to me that it would be a valuable asset to the community health and welfare on a general sense to know that you had dedicated personnel that were trained and employed in the service of the wastewater system on a full-time basis, as opposed to pulling to other departments within a township's employment, i.e. your chief of police or your borough manager, whoever, who might not necessarily have that same type of expertise for the benefit of the residents.
Oh, I certainly understand. I think the question is, again, in weighing those benefits with harms, how much do ratepayers pay more for that kind of service? And there was public input hearing testimony about that, because remember, this is not just one instance where Aqua's existing ratepayers are paying additional rates and to fund these types of acquisitions. So the cumulative impact was part of that testimony as well. But I certainly understand the point, yes.
Thank you.
But you just used the word weighing.
Well, 1103.
Right, but in your answers to the last couple of questions were very interesting, because you went through the testimony, you went through the facts, and you weighed them against the rate impact associated with the transaction, the recovery of the $5 million delta. That is what the petitioners here are claiming the Commonwealth Court inappropriately did, that the PUC did that exact same weighing and just came out a different way. And why does the Commonwealth Court get to re-weigh? Why is your advocacy here in front of us about the weight really the question? Shouldn't the question be, did the Commonwealth Court re-weigh what the PUC did? And if they did, we should reverse.
Well, I think we didn't ask the Commonwealth Court to re-weigh the evidence. We don't think they did.
Where was the abuse of discretion or the legal error upon which the Commonwealth Court based its reversal?
Well, the Commission's application of the legal standard relied on its policy statement on regionalization and consolidation. It relied on Aqua's fitness, and it relied essentially on benefits that it drew from the 1329 valuation, which we've talked about. And that analysis is not correct under the legal standards, including the more recent, at that time, McCloskey decision that told the Commission that it needed to review the rate impact of the transaction.
So the error that you're saying the Commonwealth Court found below was a McCloskey error, was an error that they didn't look at the rate impact at all. You're saying the PUC didn't make any findings regarding the rate impact.
The PUC characterized the rate impact as purported, which is essentially what it did in the McCloskey case.
That was 2018. Was that clearly before this happened?
Yes. I think this case was litigated in 2022, final order in 2022. Sorry.
I'm just asking you whether the PUC gave any consideration to the rate impact of this that was anticipated by the statute.
It called it purported. It said we can deal with it in a future case, which the actual rates designed, we agree, would be dealt with in the future case, but the impact, the revenue shortfall that comes just from the $54 million rate-making rate base is known and won't be addressed again in future rate cases.
How would you like them to address it?
I think
Because McCloskey was a remand, right?
it was.
This wasn't a remand.
No.
The Commonwealth Court didn't say, hey, they didn't just issue a PC order that says, in light of our decision in McCluskey, we vacate and remand for you for reconsideration, right?
Right.
So how should we give if you're right, and this was, they didn't give any view of the rate, maybe the Commonwealth Court still erred by going ahead and doing a de novo review. Maybe they should have done what they did in McCluskey and vacate and remand.
Well, OCA is the petitioner in Commonwealth Court, asked for a reversal in this case because the record was fully developed in this case. In the McCloskey-New Garden case, there was no rate notice or anything like that. It was the first 1329 case. So in East Whiteland Township, the record was fully developed. The statutory time period had already passed. And in fact, Aqua and East Whiteland had closed on the transaction. So to us, there was really no real reason to go back when we were saying apply the proper affirmative benefit standard to the record that was developed. We weren't asking for a different result by weighing the facts differently. We were simply asking them to apply the affirmative benefits test under
Okay,
1103.
Ms. Hoover, I think we understand your position. Any other questions? All right, thank you very
Thank you.
much to all counsel, Mr. Shapiro, Mr. Povolitis, Ms. Tate, Ms. Hoover, great job. Thank you very much. Mr. Minner, we're going to adjourn until 1:15.
We're in recess until 1:15.
Break.
back in session, please be seated.
Thanks.
Nicole Bredbenner versus Michael Paul Sr., appeal of Lebanon County Domestic Relations Office. Representing Paul, Mr. John Gregson, representing Mr. Paul, Miss Megan Tidwell.
In this case, the trial court found father to be in civil contempt for failing to pay child support and sentenced him to 100 days incarceration with a purge amount of $2,000. Father testified at the contempt hearing that he did not have the present ability to pay the purge amount. Father did not pay the purge amount and spent 100 days in jail. On appeal, the Superior Court vacated the trial court's imposition of the purge amount, recognizing that father had already served his sentence of incarceration. In this appeal by allowance, the Lebanon County Domestic Relations Office asks us to determine which party bears the burden of establishing that a condemnor has the present ability to comply with a purge condition so that a trial court can determine beyond a reasonable doubt that a condemnor has the present ability to pay the purge amount. Please proceed.
Thank you, Your Honor. As he just said, I'm John Griggs, and I'm for the Domestic Relations Office. This case that we're looking at a case that came from this court in 1977 called Barrett v. Barrett, and then there was another one issued the very same day called Morasko v. Petulski.
I'm having trouble hearing you. Could you get closer to the microphone or pull it up maybe?
Okay, I'll try that. Is that better, Your Honor?
Well, pull it up a little bit because you're tall.
Okay.
Thank you.
I was told it was finicky, so I didn't want to be too close to it. But.
No, you're good.
Okay. All right. I'm sorry. So the case we're starting with, Your Honor, came from this court in 1977. It was called Barrett v. Barrett. And another case that was issued the very same day was called Morasko v. Petulski. I'm not aware of any cases involving civil contempt and purge that have come down from the high court since then. There's been numerous Superior Court decisions. So the problem, the gist of our complaint is kind of articulated a little bit by Judge Charles in his 1925 opinion, and that he says the defendant has every motivation to just clam up and say nothing and provide no information to the court. And we don't feel that that's a good policy to allow the defendant to do that and then be able to avoid any meaningful...
Counsel, he's subject to, I'm sorry to interrupt.
That's fine.
He's subject to cross-exam. I mean, he doesn't have a Fifth Amendment interest here, right?
No, I don't believe he would.
So why wouldn't the cross from the obligee or the DRO elicit the relevant information?
I mean, we do attempt to do that. I think in this case, the defendant's testimony is just very flat. I don't have a job. I don't have $2,000.
I mean, it's not convenient, but the DROs can do some homework.
Yes, it's theoretically possible. The amicus pointed that out in their brief. My response to that is that I think it requires a rule change because a rule change, Your Honor, because the Rules Committee have set forth that discovery, sort of standard type of discovery, is not generally available, that contempt proceedings are supposed to be decided within 75 days. I think neither of those could survive. There is something akin to discovery, though, on the order to appear that's sent out saying you need to come to court for contempt. It also says you are required to bring various documentations, your income.
That's Rule 191025B. So what's the issue?
This particular defendant did not do that. In fact, he actually had quite the history of not bringing stuff to establishment hearings as well.
Since it's civil, why couldn't the court draw an adverse inference? Couldn't the evidentiary predicate in whole or in part be laid by the adverse inference of the obligor's failure to bring what he's been commanded to bring?
Well, I believe in this case, the court drew the inference from the fact that Mr. Hall had made multiple lump sum payments to purge contempt.
That's not the same, though. That's not the same because that doesn't mean he has the present ability, right?
I suppose it doesn't, Your Honor. At any rate, the key issue, I don't know that I have a whole lot of like spiel about this case. I put it down in my brief what the questions I want the court to answer are. I believe that the preferable rule would be that the defendant be required to bring the issue up. I think there was some issue with the defendant possibly not being properly advised. Well, he was advised of his right to counsel, but for some reason he had not gone to the public defender. When she came in and tried to help him, she did bring it up very briefly. But I think the court should clarify that the defendant needs to bring that up at the contempt hearing, at which point the trial court must consider it. So.
Bring what up? What do you want the defendant
is
to bring
alleging,
up?
well, when the defendant is found in contempt, I believe that amounts to an implication that they were able to pay the order.
I don't think that's true.
No.
I think that means that means the person willfully didn't follow the order. But that doesn't necessarily mean that at the time you make the determination to put them in jail unless they pay money, that time at that point has any reflection on whether they willfully failed to pay the order previously. This is a separate, independent assessment from the contempt. It flows from the contempt, so they're now a contemptor, or whatever that word is that we're using in this case. Of the myriad of options that I have as a trial court judge to remedy the contempt, I want to throw this person in jail. But the only way I can throw them in jail is if I give them something that they can remedy. That's what we're dealing with, is did the trial court make the assessment that our rule requires for the trial court to make? Meaning, did the trial court, before setting the value, make a finding that the value could be satisfied?
Well, he sort of did, Your Honor, in this case. The trial court was clearly very convinced that Mr. Hall would be able to pay the money. The only real testimony in the matter was him saying that he could not.
Well, sir, if I may address that. The issue before the court is whether a contemptor, after finding of contempt, posits that he's unable to pay a purge. Does the contemptor waive the issue if he fails to proffer affirmative proof of financial circumstances? My understanding of the evidence provided in this particular case was that he was unemployed because he lost his job to miscommunication about job responsibilities, and that he claimed he had no income or expenses as he was being supported by his brother. So why does that not meet the requirement of an affirmative proof of inability? What is it that you're requesting? If you're saying that that information is insufficient, what proffer of evidence is required?
I believe, Your Honor, that he should have probably brought in the documentation that was demanded of him on the order to appear form. But ultimately, that's a question for the court, and it's not one that I will presume to say there's a right or wrong answer for. So,
But that could have been a separate contempt, right?
I suppose it could have.
The trial court said it could have said,
Yes.
I'm going to throw you in jail until you have someone produce this documentation, or I'll give you 10 days to produce the documentation. And if you don't, I'm going to throw you in jail. That doesn't tie it to ability to pay. It ties it to the ability to produce the document.
It would be a separate contempt, Your Honor. We have some interest in avoiding a multiplicity of layered proceedings on these things because we're trying to get them in and out. We're subject to a federal efficiency standard, so a lot of what I'm advocating is just practical stuff given, but again, the question is for the court, so any answer that Your Honors will give us will be helpful.
When you say federal implications, are you talking 4D?
Yes, Your Honor. Yeah, we get...
It's definitely an inconvenient thing, but you know the old saw that he has to have the keys to his jail cell in his pocket, right?
Yes, Your Honor, and I believe I even mentioned that in my reply brief, that I believe that should apply to the evidentiary matters as well, that the defendant should come into court prepared to explain what he can do about the contempt. So.
So what is it, let me ask what Justice Donahue asked. What is it that you want us to do?
This is your appeal.
I know, Your Honor. As I said, I believe the law is somewhat less than clear on this procedural issue. The rules are not much help.
Are you talking of the rule for contempt? Which rule are you, or the procedure of
the procedure of what happened? Like, there's this reference in older cases to a bifurcated hearing, and I believe the public defender in her brief referred to that as well. That's not something that's clearly provided for by the support rules. If this court finds that that's something that's required in order to form an appropriate purge, then an opinion from the court saying that would be helpful in terms of our getting a procedure in place to make it work.
Are you asking us to modify or correct 1910.25, the enforcement of support order, or are you asking us to make the domestic rules relations
I mean,
it might be. I'm trying to tease from you what you really want.
Okay. I do believe that it would be helpful to refer all of these questions to the Rules Committee so there would be a statewide process.
And what is the question you think they should be?
The question is, once the defendant has been found in contempt, what happens next? Does the defendant still retain, it's said in the case law, defendant's failure to comply with the order is an affirmative defense. Is the defendant's failure to be able to make a purge also something the defendant has to bring up?
How many issues do you have, one or two?
I believe it's just one, Your Honor, but it could be, it sort of splinters. It's
sort of what?
It sort of splinters.
Okay, the issue that you have in your brief is the question involved is as stated in the aliquotter, where a condemnor, after a finding of contempt, posits that he is unable to pay a purge, does the condemnor waive the issue if he fails to proffer affirmative proof of his financial circumstances? Is that
that's a fair statement, Your Honor. I mean, that was what I wrote when I wrote the petition for aliquotter.
Did you write the brief?
I wrote the brief. I wrote the petition for aliquotter. I mean, I think another way of putting it is I don't think there should be a presumption of inability to pay, but
You're not asking, a waiver might also be the wrong word. You're simply saying you want us to say that when a person is held in contempt for failure to pay a support order, and the judge chooses as the punishment for the contempt imprisonment with a purge, that there is a presumption that they can pay unless the condemnor establishes an inability to pay.
Yes, Your Honor, I would go with that. Or I don't even necessarily would say establish, but at least provides some sort of...
Which a judge can credit, not credit, which I struggle with because our rule actually requires the judge to make a finding of ability to pay.
Beyond a reasonable doubt.
And that's why if we create a presumption, it seems to be contrary to our rule. So I think since this is really, we're taking this case is moot. We're taking this on the principle at this point in time. We have two options. We either issue an opinion that augments or adds meat to the rule on this issue of burden shifting, or we refer to our Rules Committee and let them sort it out for future cases.
Fair enough, Your Honor. I mean, I know the specific, the question I don't think is moot, but what to do about it in the future is still important enough that I would ask the court to consider.
So there's not any issue in this particular case that you're seeking redress?
No, Mr. Hall is out. I believe his order is actually suspended right now because he finally came in with medical evidence that we've been asking for years, but it's not with regard to this case. It's with regard to all future cases that will involve this same fact scenario.
And what was the request of the DRO for the contempt? Were you asking that he be incarcerated as a result of criminal contempt? Or, considering this was a purge factor, one would have to assume it's civil contempt, which would have required his present ability to pay, which I think the court may have overstepped its boundary by imposing a fee without a purge amount, without a proper hearing as his inability or ability to pay.
We prefer civil contempt, Your Honor. The Judge Charles, and I hate to wander into the realm of anecdotal things that have happened after the record on this case, but Judge Charles has taken to citing them for criminal contempt, which we actually don't like. We want them to have a monetary purge. We want that purge to be in accordance with the law. The biggest question is, how do we get it in front of the court? And is it the defendant's responsibility to bring it up in the first place?
I apologize. Are you saying that a particular judge is utilizing a criminal contempt procedure for what you're requesting to be a civil contempt procedure? Because there's two huge differences. Bail, appointment of counsel, and the criminal.
Well, he does those
Ability
things.
to pay, and with the purge factor on the civil.
Yes, I'm aware of all
So
those
that's
differences.
what I'm trying to find out where you're what you're asking us.
Okay, it's in this particular case, Judge Charles believed that Mr. Hall could pay $2,000, and the reason was probably, as I had mentioned, because of his history on the case. It was not really because of evidence that was brought up at the hearing. The evidence that,
Okay, so are you,
and so that's what we have. I would like the court to clarify that when the defendant says the purge is unaffordable, that the defendant has to bring that up. And to be fair, Attorney Tidwell did attempt to bring it up at the very end of the hearing. But
How would he prove that he has no money, other than saying, I don't have any money?
I'm not sure, Your Honor, and I
Well,
also
but-
don't know
but
how
that's
we
why-
would prove that he does have money.
Well, but I mean, that's sort of the dilemma. That's why we keep saying, what do you want us to do? I mean, if he testifies, I mean, and as Justice Weck pointed out, you can cross-examine him. You know, did you have a job? Did you quit your job? I mean, you know, there are things that could be done. And why are you adverse to using indirect criminal contempt? I mean, the rules
That's more
provide
of
for
a
it.
policy choice, Your Honor. I mean,
Pardon me?
That would be more of a policy choice, Your Honor. It's
Your policy
with regard to our office,
Yeah.
and as a sort of quasi-prosecutorial function, is that it is very much my belief and that of the department director with whom I work that we prefer there to be civil contempt, because the purpose of contempt proceedings is to collect money. It is not specifically to punish the defendants.
well, counsel, my understanding from the facts of this case was that this individual had been brought forth to the court on several occasions, held in contempt, and prior to the contempt finding, he would pay, he would whip out some cash to pay the purge. Is that true?
Yes, Your Honor.
Was that information brought forth by your DRO department such that there be substantive evidence on that record for the judge to institute a purge of that amount?
It was, Your Honor, but it was not formally shown on the transcript. But we have a paper.
Explain that to me.
That
Did your office introduce any evidence of his noncompliance except for the day of incarceration when he would reveal his cash?
Yes, Your Honor. I mean, but it shows, the way that shows is in the docket itself and on a document that we call a contempt court case summary that is given to the judge. It has historically not been made an exhibit or anything like that. And what it would show is that, I have a copy. Hang on.
Well, if it's not in the record.
Yeah, I mean, it's not
If
on the
it's not in
record,
the
which is
record,
why I
we don't
didn't
wanna
argue it in the brief, so.
Okay. Anybody else have any questions?
Just one thing, Chief.
All right.
Counsel, in Lebanon County, I assume, or tell me if I'm wrong, the court will presumably sometimes find the obligor in contempt and direct them to report to the DRO or, you know, some sort of ongoing manifestation of attempts to get work. That's an available tool, isn't it?
Recently, yes, we've been doing that. And
Thank you, sir.
Thank you.
Let's hear from Ms. Tidwell.
Good afternoon, Your Honors. May it please the court. My name is Megan Tidwell, and I represent Mr. Michael Hall. A court cannot jail someone for civil contempt unless it finds, based on the evidence, beyond a reasonable doubt, that the person has a present ability to pay. Our position is the duty belongs to the Commonwealth and the court, and it cannot be waived by stipulation or assumption. The Superior Court properly enforced that constitutional and statutory boundary, and we ask this court to do the same. Opposing counsel and I agree that the seminal case instructing on this issue is Barrett v. Barrett. However, opposing counsel has also cited SR versus REW to argue that if defendant fails to prove inability to pay during the contempt phase, the trial court need not assess present ability to pay a purge. And that's not what Barrett says, and it cannot be what Barrett means. Barrett holds, in imposing coercive imprisonment for civil contempt, the court should set conditions for purging the contempt and effect release from imprisonment with which it is convinced beyond a reasonable doubt the totality of the evidence before it that contemptor has the present ability to comply with the purge condition.
Counsel, I agree with you that the rule sort of puts the burden on the court and not really on the parties, in a way, the way it's worded. We took this case because there's some advocacy and some Superior Court decisions, I guess, on this burden shifting dynamic. Would you have an objection to something that we issued that simply says, if a judge is going to do this, the judge should give the parties an equal opportunity to present whatever evidence they want to present on ability to pay, not a burden shift or whatever, and just say, we're going to have a hearing, I'll listen to whatever evidence you want to offer on ability to pay, and then I'll set my purge amount and just be done with it. And so really keep the onus on the judge to give the judge an opportunity to ask the parties to submit whatever they want to submit, and then the judge makes the call.
Following this case, essentially that is what started to happen, is that it would be a bifurcated process. The contempt portion would go first, are you in contempt, are you not? And then later on down the road, we would have this sentencing hearing about whether or not imprisonment was appropriate based on whether or not he had the ability to pay.
Is that the way you do it in Lebanon County, that they have a separate day?
That was not traditionally what had been happening. It was after this case occurred that started happening. And I think we've pulled back on that since. But I think we still run into the problem with people arguing over whose burden it is to produce evidence. And I would say we would have that ability to pay hearing. But if my client truly has nothing, I am a public defender, so my clients are often people that are being brought in off the street. They don't have homes, they don't have jobs, they don't have bank accounts. If they truly, truly have nothing, they're going to come to court with nothing. And if the truth is nothing, they're not going to be able to meet this burden that the Domestic Relations Office wants us to meet, is to show some documentation of the
That's why I'm
nothingness.
saying, just leave it open-ended. Just leave it open-ended and say, because the contempt could be, the contempt standard is willfulness. So a person could have nothing, but still be in contempt because the reason why they have nothing is they've chosen not to seek work.
I agree.
So they could be in contempt for that.
Correct.
But when you get to ability to pay, the fact that they have nothing is really when it comes into play. Not the reason they have nothing, not why they have nothing, because even if they're willfully unemployed, they can't get employment while they're in jail to pay for this, right?
I agree.
So what's wrong with just us saying, because I think, again, we're being asked to we took this to just sort of say what the standard is. Why not, instead of a burden-shifting invitation, we just say, if a judge is going to bifurcate this process, the judge has a duty under the rule to make a finding, and the judge should use the lawyers as the judge's tool to get the information. It's the judge's obligation, because the judge can only make the purge determination based on the evidence.
I agree that it is the judge's obligation, and I'm fine with that. I would point to Barrett footnote 3 that still suggests or instructs that it says that since a proceeding in civil contempt remains essentially civil, despite quasi-criminal elements of the possibility of imprisonment, our rules of civil discovery are applicable and should be freely employed to aid the complaining party, in this case is the Domestic Relations Office, should be freely employed to aid the complaining party in attempting to prove the alleged contemptor's present ability beyond a reasonable doubt.
Well, we're past the alleged contempt, but I don't disagree with you that discovery rules aren't available. Maybe the judge says, I'm going to order expedited discovery, you'll sit for a deposition tomorrow, bring all your documents, and if you don't, I'm going to hold you in contempt again. I'm not saying discovery's out there. I'm just saying, instead of the burden shifting, why not put the burden on the judge?
I think there is a duty for the court, but I also think there is a burden on domestic relations to prove the
Prove
positive.
the inability to pay?
Prove the positive that they are essentially sitting on, in this case, $2,000, and they can put forth, give it over to their child who needs the money, and that will release them from jail.
You want us to say see, that's what I'm saying. You're advocating to put the burden on the DRO. DRO is advocating to put the burden on you, and I'm suggesting there's a third option, which is the burden's on the court.
I think the burden must be on the domestic relations office, the way that, I think it's hand in hand with that. Go ahead. Yep.
Question about suppose the 40 attorney or the obligee's attorney or both elicit evidence, as I saw more than once when I was there, not, as the judge, not as an obligee or an obligor, that the obligor had very recently, procured his inability to pay, perhaps by offloading cash to a girlfriend, or buying a car, or parking cash elsewhere. Ought that to figure in the calculus, or would you maintain that that kind of instrumental conduct has to be disregarded because he literally doesn't have the cash in his pocket in the courtroom?
When I practiced in a different county, there was a case like that where he had just bought a $75,000 car, but the defendant was arrogant enough to say that in court, and the judge did hold him in contempt, and the purge was $75,000. I would not necessarily have an objection to that. That's a liquidable asset.
Okay, so by hypothesis, say there was a $75,000 car purchased that day or the day before. Defendant is in contempt and shall purge himself of contempt by tendering $75,000 within 24 hours, or is sentenced to county jail on a $75,000 purge? Which is the appropriate or acceptable?
Preferably, it would be time for him to go out and do that thing before going to jail. But again, I don't necessarily think that the court would be wrong for opting for the second option, which is go directly to jail, and you have to tender $75,000 as a purge if you want to be released.
Counsel, with regard to your concern of making the burden on the DRO, the facts of this case are, as Mr. Gregson indicated, the support docket sheet is part of the file, I assume, which is hypothetically marked and moved into evidence. Is that sufficient for their burden to prove that your client has been held in contempt previously and has cash? It just seems to be a practice that he waits until he's going to be incarcerated before he pays?
I wouldn't have an objection to it being made part of the record as an exhibit, but I do think any history, in this case, I think at the time it was 10 years of history that the court had with this client, that would go more toward phase one, perhaps whether or not he is in contempt, but whether he has a history of showing up to court and tendering a couple $1,000s to settle his case wouldn't have any bearing on does he have $2,000 today to put toward a purge.
Well, wouldn't that, hypothetically, that I see a history, I'm the sitting trial judge, I see a history of him bringing out anywhere from $1,000 to $1,500 every time I'm about to sentence him to jail. Why could I not, if that's part of the record, for me to say I'm holding you in contempt? I'm sentencing you to 30 days in jail with a purge factor of $1,500. If I get that $1,500, he doesn't go to jail, but at least I've gotten it, and it proves that pattern. I'm just trying to find the framework that you're seeking for the burden of proof.
I think that pattern would cut in the defendant's direction. That pattern would show that the coercive tool does actually work when he has the funds available. So 10 times we set a purge at $2,000, you show up to court and you pay $2,000, it's because he had it. He has shown that when he has that money, he will pay it. And now we're at a penalty phase, the well has run dry, and there's no evidence that he has any money.
Focus on to punish him or get money for the children.
Yeah, we need to keep civil contempt coercive. If we do not have any evidence that he has a certain amount of money, then it's not coercive anymore. He can't pay it, he's going to sit in jail, and the child doesn't get money.
Yeah, I mean, and I take it your position also is that upon a finding of contempt, the court has other arrows in its quiver. Besides the immediate incarceration, it can suspend a sentence. If it finds evidence of an imminent ability to pay, like by tomorrow or the next day, suspend a sentence.
provide for a bench warrant, right? The problem in this case is the immediate incarceration without premising it on a present ability to pay. Isn't that the problem?
It is. Yes, sir.
All right, any other questions for Ms. Tidwell? Thank you both very much.
Thank you.
Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Ronald Jenkins Jr., representing Mr. Jenkins, Mr. Spencer Bradley, representing the Commonwealth, Mr. Ryan Light.
In this case, during the Commonwealth's closing statements at appellant's trial for, among other crimes, the rape of an unconscious victim, the prosecutor commented that appellant obtained counsel before participating in an interview with police prior to his arrest. We granted allowance of appeal to consider whether the Commonwealth's commentary regarding appellant's pre-arrest retention of an attorney deprived appellant of his right to a fair trial, and if so, whether such error is structural or subject to a harmless error analysis. Please proceed.
Thank you, Your Honor. Spencer Bradley for Ronald Jenkins with the Dauphin County Public Defender's Office. May it please the court, before I begin, I do wish to give consideration to the work of the Aplt amici brief in this matter. Professor Epstein and Brian McNeil out of York. I value their work in this. In this case, the prosecutor used the fact that Mr. Jenkins, prior to being arrested, prior to charges being filed, spoke with an attorney and brought an attorney to an interview and, crucially, used that action by him to impugn something negative as consciousness of guilt. We are seeking this court to hold that a prosecutor cannot refer to a defendant's pretrial retention of counsel because that is a violation of the Due Process Clause.
Did you raise the Due Process Clause challenge at trial?
In candor, Your Honor, I was not the trial attorney. However, the allegation of a mistrial at its core is in many ways alleging a violation of the Due Process Clause. A mistrial is saying my right to a fair trial has been violated, the whole thing needs to be scrapped, and we have to start over.
Would it be a fair recollection that the objection that was raised to this testimony in the closing statement of the prosecutor, I believe, was raised as prosecutorial misconduct?
It was raised as essentially the Commonwealth's attorney violating his right to a fair trial. His right to counsel was also thrown in there by the trial attorney. In essence, the sought relief was that this, and the reason I proceeded on appeal as a due process theory rather than some other theory is because it fits more cleanly in saying his right to a fair trial was violated, therefore the whole thing needs to be thrown out vis-a-vis a mistrial being granted.
So is this a 14th Amendment case, or is this a 6th Amendment right to counsel case?
I believe consistent with the courts that have analyzed this issue, Your Honor, the 14th Amendment makes more sense for this type of claim. And the reason behind that is the 6th Amendment, or the Pennsylvania equivalent, only attaches once charges have been filed. So I'm not trying to seek an expansion of you have a right to counsel at every conceivable moment or when the Commonwealth starts looking at you.
So if you're arguing this is a due process violation, which I think you are on the 14th Amendment.
Yes.
Just so I'm clear, and I want to frame and put your argument into proper context, are you claiming this is a trial court error subject to a harmless error analysis, or is this a structural error requiring a mistrial?
Our position would be initially it's structural error. I mean, the three portions of this argument is, one, it's error. Two, we believe, both myself and amici believe that it is structural error, but even if it is subject to harmless error, we would win under that analysis. But our first thrust of our
Under a
argument
harmless
is,
error analysis? You think you would win under a harmless error analysis if it's a trial court error?
Our position would be that under harmless error, if we're going to talk about that, is for the three sort of categories of harmless error, you have whether it's a de minimis error. Well, if this court holds that it's a constitutional error consistent with this court's cases in Rivera, a constitutional violation, we can't call that de minimis, right? So throw that one out. It's not cumulative in any way. It's not adding to anything. It's not like...
If it's a constitutional error, it's got to be, by definition, it's got to be a structural error.
Well, not necessarily.
Not necessarily.
Yeah, not necessarily, Your Honor. Other constitutional errors, as much as I would love this court to expand the definitions of structural error to include all violations of the Constitution.
Now's your opportunity.
Respectfully, Your Honor, that was not the question I sought relief on. I will be more than happy to add that to my list of issues to continue preserving. But the current state of the law is each error is then analyzed for whether it falls within structure or harmless error analysis. It is our position that this type of error, while it does occur during a trial, I will concede that, that's not the test pursuant to Weaver that determines whether this is or is not a structural or a harmless error. While it is true, most trial errors will fall within that harmless error analysis.
You can have a curative instruction, for example, at trial.
There was a curative instruction given, Your Honor. That's also part of the reason why structural error, to our position, is the stronger avenue to seek
It's a pretty good curative instruction.
I would find some fault with the curative for a few reasons. At first glance, I would concede that the trial court attempted to salvage what had happened. I put full faith behind the court behind that. The problem with this curative instruction, though, is one, it talks about burdens and not to alleviate burdens, but it's not a targeted curative instruction to what actually was said, and most importantly or crucially, as to the defect in the curative, is it asked the jury, we're asking you not to consider this thing. I know that's somewhat semantics here, but asking the jury to do something is markedly different from telling them, you heard the Commonwealth make a inference towards his retention to counsel. Get rid of it from your mind, don't consider it. If that curative instruction was given, and this court were to find that this type of error is subject to harmless error, I might be in a very different situation in all candor.
So we have applied a harmless error analysis to references of the right to remain silent. If we were to follow your logic, what becomes of those cases?
Well, I think candidly, going to Justice McCaffrey's point, is now we would have to start, reconsidering under, Chapman is the seminal case in this area, right? Chapman says, the starting point is harmless error, but that's not the ceiling, that's the floor. We would have to consider, and we could consider, whether these constitutional errors really are based off of the effect of those violations as, subject to harmless error, or are they actually touching on something a little greater? And as this court noted in its commentary about the exclusionary rule in Pennsylvania, we don't have an exclusionary rule like the feds do to just punish the government for, finding something illegally. That's not why we put a lot of faith behind something like the exclusionary rule. We do it to vindicate our citizens' constitutional rights. And thus, if this was presented as, under a Pennsylvania constitutional analysis or under Pennsylvania law, those rights, while maybe subject federally, under a federal claims analysis to harmless error in the federal jurisdictions, don't follow the same path in Pennsylvania. But to that point about the considerations here, it's not just Mr. Jenkins who is affected by this type of logic here, right? One of the things that makes an error structural is whether it protects some other interest, some other thing to protect other than just his specific right to a fair trial. And across the Commonwealth, as amici points out rather persuasively in their brief, is that from the moment someone thinks they've committed a crime, not even has started being charged, has been arrested, they have an interest in seeking out learned criminal defense counsel. I'm a public defender, so I don't get to necessarily handle those moments, but what I will say as far as experience goes is the times where counsel has the ability to work with someone and either mitigate, explain, provide evidence, facilitate the investigative practice, those are important societal steps, and society has an interest, the defendant has an interest, the accused has an interest, in being able to go talk to an attorney and not have that spun around
That's kind of
him.
what the trial judge said in his curative instruction, that, it's reasonable for a person accused of a crime to consult with counsel, and, he's entitled to do so. He has a constitutional right to do so. I think the curative instruction kind of, lessened any negative impact that the reference to the hiring an attorney had.
Respectfully, Your Honor, based off of the distinctions that I pointed out with my analysis of the insufficiency, I suppose you could say, of the curative instruction, I would rely on essentially the proposition that the trial court, perhaps assuming that this would be subject to harmless error, is going that route to try and cure it vis-a-vis a curative instruction. It is my position, as well as Pacto's position, as I'm kind of stealing from them, that this is subject to structural error because of the interest that Judge Tully did, articulate. I'm not taking issue with that, and I'm not necessarily even taking issue with the trial court's attempts to salvage this trial.
But the counsel, the only issue that we took is whether this was structural error or trial error subject to harmless error.
Yes.
We have a binary choice here, right?
Yes.
I guess we could say it wasn't error at all, but I'm not sure. But we're not here to decide whether it satisfies harmless error. You didn't ask us to decide whether, if we say it's a trial error and harmless error applies, this was not harmless error. You didn't ask us to decide that question.
I would concede that, Your Honor, because if harmless error was, applicable here, the analysis by the majority opinion below probably satisfies that level of analysis. However, I would say that in determining whether it is subject to harmless error or not subject to, or subject to structural error, that's the question that...
Yeah. In other words, the only way you win is if you convince us that this was structural error.
Yes.
Okay.
I could try to be cute and try and backdoor some form of issue preservation here, but I'm not going to go down that route.
Just tell us
Right.
why it's structural error.
And I think it, goes to, one, that first element that it's protecting some other interest. I think, while it's not a Sixth Amendment claim, it's sort of circling it's knocking on the door of the Sixth Amendment. It's knocking on the door of the accused to be able to essentially find a way to defend themselves. Once you have a type of violation where a defendant could be punished for their consultation with an attorney, as the Commonwealth points out in their brief, he would have had a decision then. He could have not talked to counsel if he didn't want that to potentially be used against him. That's sort of the, externality of not viewing that as an important societal interest. The other two aspects of Weaver, I think, weigh in favor of viewing this as structural, is that whether it's too hard to measure. I mean, there is a cultural phenomenon of lawyering up. You can't prevent a jury from speculating and thinking about, well, you brought a lawyer there. Why would you bring a lawyer unless you're guilty? There's that stigma there that, and to the curative instruction point, is there's within the record, there's the defense argument, closing argument, there's the Commonwealth's argument, defense counsel then objects, there is a approaching to discuss that issue. it is denied, and then the jury instructions begin generally, and the curative instruction is then given kind of in the middle of it. It's not necessarily as responsive to that issue.
But if you're arguing to us that it's structural error,
It doesn't matter.
it doesn't matter how effective the curative instruction was, right?
And that's correct. But to the point of trying to figure out the second Weaver factor of too hard to measure, that's where I'm sort of thinking or conceptualizing, like, where is that inability to really qualitatively analyze? How do you view that error? This isn't necessarily as, and to be clear about what I'm asking here, is the error isn't necessarily the jury hearing that counsel had been retained. That's not what I'm here to discuss. The issue is how that's then used by the Commonwealth. And that goes to the third factor of fundamental fairness. There's a difference between, referencing somebody's, actions that have no bearing on guilt or innocence and using that against them as some form of consciousness of guilt. This is using, free association, in essence, if you really want to keep adding on, societal interests here, the interest of people to be able to communicate freely, participate in commerce, and protect themselves when they're facing down the potential life-altering consequences of prosecution and understanding what's going on. And in this case, what's done is to say he lawyers up, and then what does he do? He doesn't essentially admit to anything. He lies. And that's the problem.
Well, that's what I didn't even understand. I had a hard time connecting the lawyering up thing with lying. I didn't even understand how the two were connected. Were they suggesting to the jury that immediately when you hire a lawyer, you start lying?
And that seems to be the issue. I mean, that's our position, is that's the issue. There's no reason.
That doesn't say a lot about our defense bar in Dauphin County. That hire the lawyer will tell you to lie.
Well, it's really.
They were private counsel, so I can't defend them too much.
Counsel, I find that probably the most egregious part of what happened here.
Yes.
I mean, there's an implication here that this lawyer was involved with a deception. I mean, this goes to the heart of what attorneys are about in our society, why potential defendants hire attorneys. I mean, my question is, did the curative instruction here take into account the egregiousness of the implications that were involved here?
And no, Justice Donahue, I don't believe it did. And not to belabor it too much, but that kind of goes to when I said it focuses more on the burdens that are applicable in this case, right? The trial court didn't attack or try and actually cure what had gone wrong here. What had gone wrong here was the Commonwealth's attorney, respectfully, got over her skis and made an inference that this defendant lied. As the Superior Court, and I think Judge Lazarus has the jumping to the end of the story, our position is Judge Lazarus had the right of it. This isn't a reference to DNA or anything like that. That doesn't come up at any point.
Counsel, this is in closing argument. The jury's instructed that what the counsel say is not evidence. How does this become structural when you have to weigh it against the overwhelming evidence of guilt against your client? My understanding, he claimed he didn't meet her, he wasn't with her, yet the Commonwealth indicated him carrying the unconscious woman wrapped up over his shoulder into the hotel room where he raped her. I'm trying to understand this structural error with regard to not only the normal jury instruction, that what counsel says is not evidence, but the curative instruction based upon a statement in closing, not evidence.
Well, to that point, Your Honor, I think two things. One, if we simply rely on the arguments of counsel is not evidence, then that effectively would defang, or foreclose really any challenges to any form of prosecutorial commentary during closing argument. You know, a prosecutor, just to follow it out here, if the prosecutor engages in full-blown misconduct, makes references to, you know...
AKA, he calls the defendant an animal.
Yeah.
That's outrageous. Got that.
Yeah.
If he's making reference.
Well, if the Commonwealth is, if their arguments are not still analyzed as to whether those arguments were violative of any rights, then that curative instruction that says that's not evidence, don't consider it, it defangs that ability to bring forth that claim. I think the proper analysis is to say it was misconduct necessitating a mistrial, and the trial court erred in denying that request, and after the fact, issued that curative instruction.
Distinguish these facts or your argument from our decision, the Supreme Court's decision in Commonwealth versus Wright from 2008.
I think the fundamental issue here in focusing in on Wright, and that was not a key part of any briefing on my end, so I will not try and...
Permit me. We ruled the prosecutor's error in referencing Wright's failure to testify was harmless where, 1, the evidence of Wright's guilt was overwhelming, and 2, the trial court specifically instructed the jury not to draw any adverse inferences from the prosecutor's remarks. That's what this court ruled in 2008. Tell me why it's different in 2025.
I think the difference is, 1, the defendant's interest in Wright was his decision to or not to testify. That's a fundamental decision that only an individual has.
Counselor, I apologize. Let me add to that. Commonwealth versus Wright dealt with the Fifth Amendment issue that was right there, that very absolute right not to speak. You've already indicated to us that this does not invoke the Sixth Amendment Constitution or one analogous to our own. Therefore, how are you comparing this case with no constitutional implication over our decision that had a constitutional implication?
I would disagree respectfully that this case has no constitutional implication. I would think the right to a fair trial, a trial where a defendant is not, for example, referred to as an animal, or, you know, is their guilt or innocence, or, you know, guilty or non-guilty status, is determined by the evidence and not actions by the government, that goes to the heart of a 14th Amendment analysis.
Well, that could be true of every rule of evidence violation.
If we wanted to get hyper-academic about it, that would be the proper presentation.
Nobody's ever accused me of being hyper-academic, but...
Well, if we're going to go down that road, then properly, what defense counsel should do in evidentiary rulings that are against them is to say it not only violates the rules of evidence, but it violates my client's, you know, right to a fair trial under the 14th.
No, but I'm just saying that if you say that there's this sort of, the overarching right to a fair trial is at play, is equivalent to what Justice Doherty was pointing out, a Fifth Amendment right to remain silent, and that being used against you. The right to a fair trial is not being used against your client here.
Well,
and that's what was at issue of right. The Fifth Amendment assertion of a right was being used against the individual in that case. Nothing was used against you here that rose to a constitutional right. What was used against your client was, and I think completely appropriate, was the fact that outside of the context of Fifth Amendment protections, your client consulted with a lawyer, which was brilliant. Most people should do that. But it didn't rise to the right violation. It wasn't being used against you. I think that's Justice Doherty's point, is in Wright, we have allowed an actual adverse use of a constitutional right invoked by a criminal defendant to be used against them, and nonetheless have said it's not structural error. Here, no right that your client used was used against your client, but you're saying structural error.
Well, I respectfully disagree with your Honor's analysis that there isn't a constitutional right at play here. A right to a fair trial is to have the state act in such a way that is dealing with the evidence. Every prosecutorial misconduct claim would, in essence, be a 14th Amendment violation.
And every violation of the rules of evidence would be a 14th Amendment violation.
Well, if we're going to get, again, hyper-technical, I think you could preserve it as a due process claim. I know habeas counsel federally, that's how they get their teeth into a case. But secondly, I think insofar as there's a distinguishment, evidence is about what comes in at trial, right? This is something that has nothing to do with guilt or innocence. It is simply consulting with an attorney and the Commonwealth going around and saying, aha, because you consulted with an attorney, there is some level of lying or malfeasance that went into your conduct. And that's what makes this a 14th Amendment violation of a right to a fair trial.
That's what you're drawing, that's a conclusion you're drawing from the comments, though that isn't what the DA said.
Well, I wouldn't say it's just me drawing that. I think everyone but the Commonwealth in this case is conceded or believed that there's been some form of error or misconduct by the Commonwealth.
Yeah, but I'm saying what you just quoted was not a quote. It was your description, your
fair
on what the DA said.
Right. I think insofar as to address Justice Brobson, your point about whether this has any element of constitutional analysis, I would rest on the analysis and ask this court to adopt the analysis of the courts in Sizemore, Macon, and Angel. I think those are cases that are dealing with this type of issue where the Commonwealth, the state, whatever you want to call it, uses in some way a defendant's consultation with counsel and uses that against them. Those courts have found that this is violative of the 14th Amendment.
Okay, we understand your argument. Are there any questions? Thank you very much. Let's hear from the Commonwealth.
Good afternoon, Your Honors. May it please the Court. Ryan Lacet on behalf of the Dauphin County District Attorney's Office.
You raise the mic, please.
Oh, sorry.
You're very tall. Keep it going.
I wear my heels,
Thank
too.
you.
Thank you, Your Honor. Sorry about that, Your Honors. Ryan Lacet here on behalf of the Dauphin County District Attorney's Office, the appellee in this matter. Just piggybacking off of what we were talking to at the conclusion of the appellant's argument, I don't think there was any improper comment here whatsoever by the prosecutor. There was no Fifth Amendment right to counsel. There was no custodial interrogation occurring. This was over the phone. He voluntarily acquiesced in this phone call. There was no Sixth Amendment right to counsel. There were no formal charges against the defendant in this matter. This was actually a cumulative comment because the defendant had...
Was a what?
I'm sorry, Your Honor, cumulative comment because the defendant had also lied to the victim's husband in the recorded phone call, going into the second prong of Pennsylvania's harmless error analysis. I argue that it could also, assuming there was error, which the Commonwealth does not cede, that it would be de minimis under the circumstance that there was no constitutional violation here.
I'm sorry, what do you contend was a cumulative statement?
That the defendant, after he obtained counsel and subjected himself to a second interview, in so many words, with law enforcement, given that the first phone call between...
This particular fact pattern deals with the fact that the prosecutor, during his closing argument, made reference to the fact that the defendant retained counsel before he gave the statement to the police.
Yes, and the heart of...
What was the purpose of throwing in there, hey, he retained an attorney? Unless to fix in the minds of the juror some type of consciousness of guilt. That's what I don't understand here.
Yes, Your
I
Honor.
thought that was a conceded point, because why else would you ever reference the fact that he retained an attorney before he gave a statement to the police?
And I disagree with the characterization that has been, that occurred in appellant's argument here with Your Honors, that there was an inference that because the soliloquy, because the defendant obtained an attorney, that he must be lying. I did not find that. from a review of the closing argument in this matter.
Why do you believe the prosecutor said to the jurors the defendant retained an attorney before he gave the statement?
Because
Why would you do that?
Because after one retains an attorney, one would presume that the attorney is competent and would render competent advice, and also one would assume, and we're making lots of assumptions here, that the defendant would disclose to his attorney kind of what the status of the matter is up to that point. Oh, I did this, I didn't do that. And so the defendant, after being informed that there was a rape kit conducted in this matter, which the defendant's DNA was found in the rape kit.
Right.
Therefore, unless he is going to claim that he was so blacked out that he didn't know what happened, he would have been aware that he, at least at some point, engaged in sexual relations with this woman. And his denial, when presented with these allegations, is that nothing ever happened.
Yeah, but that still doesn't solve the problem, if it's a problem, and could be, that the assistant DA gratuitously brought up his retaining counsel.
Yeah, that's where I'm
It's
lost.
gratuitous and troubling, particularly when it's juxtaposed with the repeated labeling of the defendant as a liar.
Yes, Your Honor.
The latter being permissible in closing, but the former coupled with it being problematic, don't you think?
Again, there being no deprivation of a constitutional right, such as under the Fifth or Sixth Amendment vis-a-vis counsel. Now, appellant has brought in that to freedom of association and stuff, and I don't think that is as direly implicated in a jury trial as is the right to counsel. Again, not calling him a liar because he obtained an attorney, but because when ostensibly given reasonable advice by counsel under the circumstances and presented with evidence that a rape kit was conducted, though the results had not yet come back, he continues to not heed this ostensibly reasonable advice from his attorney.
That's not what the prosecutor said.
No.
I mean, that's not what the prosecutor said in this case. And there you might be a little bit more on. I mean, we're kind of like nickel and diming about what the jury could infer or not infer about this. I just have a general problem with, I'm not sure why, and if it's a common practice in your office, I'm a little concerned about it, that you would hold, no constitutional right attaching, but that you would use someone's decision to consult with a lawyer when potentially faced with criminal charges against them in order to get your conviction. That's just, it may not be a constitutional violation, but it just doesn't sound right. And maybe that's why the lawyer at trial didn't raise the constitutional violation and simply said, this is prosecutorial misconduct. We can't allow prosecutors to use the fact that we consulted with an attorney about a potential criminal charge against us. Not constitutional, it's just wrong. What's wrong with that?
Why would it be wrong if there's no constitutional violation?
Because if I'm innocent of the charges, you're saying an innocent person wouldn't consult with a lawyer when they're under potential investigation?
I didn't say that.
It seemed to me that, I'm sorry, go ahead,
Just to
Justice.
say, counsel, you did. In your brief on page 39 to 40, you wrote, if appellant had an issue with the fact that he, of his own volition, brought an attorney to his discussion with police, he could have not brought an attorney to his discussion with police. Are you kidding me?
People.
So the purpose of the conversation with the police was because the police had all this information and wanted to arrest him for rape, yes? And it's your position as the arbiter of truth that the Commonwealth believes someone who's being called to or have a conversation with law enforcement whose intent and purpose is to incarcerate and or seek a deprivation of liberty should not enjoy the right to have someone who knows the law present with him.
It would certainly behoove that individual to have someone who knows the law.
So, and in this particular case, since it behooves him, why was that used against him?
I've not heard any authority yet that it can't be used against him. If it's not a violation of the Constitution, how would it affect his fair trial rights?
Okay, could we separate what you said in the brief, which I'd recommend you move to strike, and what was actually said at the trial? The DA at the trials, was this you at the trial?
Oh, no, I don't do trials, Your Honor. It's hard for me to talk in front of people, so. As I'm sure is aboundingly evident.
We're definitely not people.
Yeah, you're doing great so far. Go ahead.
Just keep coming
Especially
here.
quite esteemed people.
Just keep coming here then. Okay. In the trial, the ADA said, and I'm quoting, "And what does appellant do? Because he knows the importance of all this, he gets a lawyer. He gets an attorney. This isn't some schlep who just went in and spoke with the police without the benefit of having someone there to protect your rights. No, he goes in with an attorney." When I read that, my impression was the ADA was saying, this guy's sophisticated, he knows what he's doing, not that that led to him lying. I mean, that's just the way I read it.
But I'm sorry, Your Honor.
You should agree with me.
I always agree with Your Honor.
Why isn't that susceptible to a very different reading? Why isn't that a big red flag waving? I mean, I guess unlike Chief Justice Todd, if I was presiding at that trial, I might have stopped it right there and brought counsel to sidebar, and then I'm not sure what I would have done. Maybe declared a mistrial. That is an outrageous and gratuitous thing for a prosecutor to say in a closing. I'm kind of shocked that you don't immediately concede that and try to show us why it would be harmless error instead of defending it.
Well, Your Honor, I can accept that it would be error. I just don't want to gratuitously concede the issue. Again, if we're not referencing a Fifth Amendment or a Sixth Amendment right to counsel, I mean, what?
Well, the impression that I was getting from the tenor of your opposing counsel's argument was that it was connected, the statement of his having gotten an attorney was connected to his lying, that somehow brought about his lie. And I just was proffering to you that I don't see that in that series of statements. Now, that doesn't mean I don't think that was an error, but I'm just saying it doesn't seem to me to be what it was alleged to be.
And my thought from earlier, Your Honor, is what I was saying is despite the fact that he obtained this counsel and presumably received reasonable counsel under the circumstances, he still chose to lie. It's not his attorney saying, oh, the lie is. It's this defendant after having, he wasn't a defendant at that point, consulting with an attorney, ostensibly having been given reasonable advice under the circumstances, like, one would think that this defendant, knowing that this was the victim, would inform his counsel, we've had intimate relations in the past. That would inform him maybe something would come of the DNA test that was given to him. And so the defendant knows this DNA test is coming down, has consulted with his attorney, has either withheld information from his attorney or has received counsel from his attorney that, your DNA is going to be found there, maybe you should say we had consensual sex, and he still denies it.
Okay, let's just pretend here that, or assume that we're all convinced it was an error of some sort. What then happens? Can you make a good argument to us that it's not a structural error?
Yes, Your Honor, because it is not one of those errors such as the whole denial of a right to counsel or the proceeding before a biased tribunal that it affects trial process from beginning to end. I mean, the best argument here for them would probably be the concept of primacy, that the last thing the jury hears is this comment, and so maybe it could have affected them or be stronger in their mind for that point. But again, this is a fleeting comment at the end of the trial.
That goes to the question of whether the error was harmless or not. That's a different question than whether the error is subject to a harmless error analysis or whether it's structural error.
Well, it can't be, because it's just a prosecutorial comment, which is not evidence in closing at the end of trial. It can't, by definition, have affected the entire framework within which the trial proceeds, rather than an error in the trial process itself, which can be reviewed by taking the whole record here, the evidence, the arguments, and comparing what, if any, effect it had. And so that's why I do not believe it's a structural error. Plus, with the federal and this honorable court, or the state of Pennsylvania's jurisprudence, it would align that it is subject to harmless error analysis. I don't think it could be more egregious than commenting on a defendant's right to remain silent. I think it should be treated akin to that if there is error discerned.
Any other questions for the Commonwealth? All right, thank you both very much.
Thank you, Your Honors.
Thank you, Your Honors, always a pleasure.
Thank you.
Would you call the next case, Mr. Minner?
In re Chester Water Authority, representing the Water Authority, Mr. Kevin Kent. Representing Chester County, Mr. Fred Emmerich. Representing the City of Chester, Mr. Matt White. Representing Aplt 10, Mr. Scott Withers. Representing Delaware County, Ms. Candace Hall.
These consolidated appeals concern the potential sale of Chester Water Authority, which was incorporated by the City of Chester in 1939 and provides water services to Chester residents along with residents of 33 municipalities across Chester and Delaware counties. Pursuant to Section 5610 of the Municipal Authorities Act, Chester Water Authority's board is comprised of 3 members from the City of Chester, 3 members from Chester County, and 3 members from Delaware County. Under Section 5622 of the Municipal Authorities Act, a municipality may acquire a water authority by appropriate resolution or ordinance adopted by the proper authorities. We are asked to consider whether this provision allows the City of Chester to obtain the Chester Water Authority and its assets in order to effectuate an eventual sale of the authority without the approval of the authority itself. Please proceed.
Thank you, Madam Chief Justice. May it please the court, I am Kevin Kent from Clark Hill. I represent the Chester Water Authority, a multi-jurisdictional joint municipal authority operated by a majority-minority board that provides clean, affordable drinking water to over 200,000 people and businesses. Refer the court to page 7 of our brief where you can see the service area for the authority. As far as the split of the arguments between myself and Chester County's counsel, for the CWA, I plan to address the Burke precedent of this court, as well as the impact of Act 73 on the MAA. Chester County will focus on how allowing the Commonwealth Court's order to stand would lead to absurd results. So the court is familiar with the background of this larger dispute from its 2021 decision in CWA's case against the DCED. Summarizing the CWA's argument in this case, the city can only succeed, and Aqua can only succeed, if this court concludes that at least all 3 of the following propositions are correct. First, even if Section 5622A of the MAA applies, this court decides that it did not mean what it said in the Burke case. Second, that Act 73 means nothing other than giving the counties ceremonial seats on an Act 73 authorities board, even though Act 73 reorganized the CWA by replacing the 5-member board appointed by the city with a new 9-member board appointed equally by each member municipality. And third, that the project of any authority can be seized solely by the, quote, original incorporator, end quote. And that third point is primarily what Chester County will focus on, Chester County's counsel. Simply put, the city's claim of unilateral power to order the CWA's dissolution and seize the CWA's project is untenable. The city uses language like repossess and take back in its arguments. The city never possessed the CWA. It never contributed to it. This case is not about ownership or possession, which is really not addressed by the MAA. It's about the division of government power by the General Assembly of the Commonwealth, not ownership. The only word relevant to these appeals, starting with RE, is replaced. And why do I say that? That's because that's the language used in the statute whereby the city's appointed 5-member board was replaced by a new 9-member board appointed 3 each by Chester County, Delaware County, and the city. And I just stress, not a seat each given to the counties, equal representation on a 9-member board. Now, to get into the details of my arguments, I'm going to start with Burke. Now, this is issue number 2 in the court's order taking jurisdiction. And because it's dispositive, I'm taking it first. So as you can see from our briefs, the CWA's argument is that 5622A does not apply definitionally to a multi-member municipal authority. So you might say, well, why are you starting with Burke? I'm starting because if you take the Burke holding and you apply it to any situation in which a municipality is trying to take the system of a municipal authority, it decides the issue regardless of Act 73. So in the Burke case, this court held that an authority's board must approve a transfer of projects. That's an express holding. It's never been overturned. This court affirmed no less than 3 separate times that such a transfer, quote, must be accomplished by an appropriate resolution or ordinance adopted by the authority. And Burke is right, and I submit this for this reason. If you look at the language of 5622A and its predecessor, Section 18, that language, quote, adopted by the proper authorities, end quote, in 5622A would be completely unnecessary surplusage if you read 5622A to apply to only the municipality passing an ordinance to transfer the system. It could end with the
Mr. Kent, if I can break down that real quick?
Yes.
Your position, if I'm reading you correctly, is that proper authorities in this particular context should be read to include all 9 members, and in the event that this court decides that the assets can be transferred or sold, it would require a majority of the 9-member board, and therefore resolutions of Delaware County and Chester County?
Correct. That it would at least, under Burke, include the CWA's board.
So that in other words, that's the proper authorities, all 9-member board plus Delaware County, the city of Chester, and Chester County?
Yes, the majority of the CWA's board.
I just want to be clear on that. Thank you.
Yes, at least. I mean, we haven't reached the issue of whether Chester County, Delaware County, and the city of Chester would have to also agree. I mean, I think that's implicit in the statute that they would have to.
Counsel,
yes.
Implicit in what? Just focus on 5622A. Why do you have to go beyond 5622A for your argument? I mean, if it requires a resolution by the authority, why do you need anything else?
I don't. That's why I'm starting with Burke.
I mean, isn't the composition of the authority, et cetera, irrelevant?
Under Burke,
this controls what you need in order to convey the asset.
absolutely, Your Honor. I agree completely, Justice Donahue. Burke controls, that's actually why I started with this argument, because regardless of what Act 70...
It's not Burke. I mean, it's the language of the statute, correct?
Well, I agree with you on that as well.
That's what we're here for. I mean, the argument's been made that Burke is dicta. So we would really, in the first instance, be interpreting what the statute means, but assume we agree with the Burke court's analysis. That would be the beginning and the end of the analysis, wouldn't it?
Yes, absolutely, Your Honor. And that's our argument. That's why I'm starting with Burke. I think Burke is very straightforward on that. I think it's a holding, and I think it's correct. And even if it wasn't, for some reason, as this court has stated before, changing course would demand some special justification over and above the belief that the precedent was wrongly decided. That's clearly not the case here. Happy to take any more questions on Burke. Otherwise, I will move on to some of the Act 73 arguments. Okay. Now, even if this court, for any reason, decides that Burke does not control here, Act 73 precludes the Commonwealth Court's interpretation and Aqua's and the city's interpretations. Even the most generous reading of Section 5622A gives a municipality a limited ability under certain conditions to acquire a project operated by an authority that the municipality created and controls through board appointments. And we think, obviously, subject to Burke's requirement that the authority approve the transfer.
It's not Burke's requirement. You keep saying that. It's the language of the statute, isn't it?
The language of the statute as interpreted by Burke. Yes, Your Honor. So I'm putting Burke aside, that interpretation for a moment. 5610A1, which was added by Act 73, as well as 5610G, reorganized municipal authorities providing multi-county water service where a majority of the population served 4/5 or greater is outside of the incorporating municipality. Under Act 73, the board that was once appointed by the city alone is, quote, replaced by a governing body, end quote. That includes Chester County, Delaware County, and the city, all with equal appointment power. Accordingly, the authorities board is no longer, quote, a board appointed by a municipality, end quote, under Section 5622A. It's a board appointed by 3 municipalities. And that's inherently, there's inherent logic there. It makes sense for a multi-jurisdictional authority operating throughout many cities and counties and boroughs, as opposed to an authority whose board appointments are controlled by one municipality, to fall outside that definition. So there was no need, there are a lot of arguments in the briefs from Aqua and the city that somehow there was a need to change Section 5622A itself for Section 5610A1 to affect it. Those arguments that the General Assembly should have been expected to alter Section 5622A make no sense when you read Section 5610A1 and 5622A together. Now, Aqua and the city actually attempt to rewrite Section 5622A with terms that aren't there, like, quote, originally incorporating municipality, end quote, or incorporating municipality. Now, those terms come from 5610. Those terms are never used in Section 5622A. They are completely absent. So even by Aqua's and the city's own logic, the use of the phrase, quote, project established by a board appointed by a municipality, end quote, in Section 5622 means something different than, quote, incorporating municipality, end quote, in Section 5610A1. That's a conscious decision by the General Assembly to define projects subject to Section 5622 with reference to the nature of the board establishing those projects, i.e., it did not extend it, 5622A, to multiple member municipal authorities. Now, the city points to the word established being in the past tense in 5622A as having some sort of magical meaning for our purposes here. That's clearly simply because a project has to be established before it can be transferred. And the city and Aqua, frankly, ignore the present tense in the same section of Section 5622. That uses, quote, is, end quote, and quote, has, end quote, in the present tense in reference to the project. 5622 in that regard says, quote, the project is of a character which the municipality has power to establish, maintain, or operate, end quote. That's clearly a reference to the authority's present projects, not historical projects 100 years ago when the authority was incorporated. So we think the text of 5622A clearly takes, even if 5622A somehow, the text of 5622A just does not apply to a multi-member municipal authority like the CWA or any other Act 73 or other joint authority, multi-member authority. Now,
say that again. You're saying it does not apply?
I am saying 5622A definitionally does not apply to a multi-member municipal authority.
So what does? What does apply? Because it's certainly not 5610, which says nothing about what the powers are. It just says how powers shall be exercised, and then states the composition of the board.
Yes, and it does state the composition of the board, certainly. 5622A, we would submit, does not apply to any authority that has more than one member. And and I'm trying not to tread on Chester County's arguments, but to answer Your Honor's question, I think I have to on this point. Mm-hmm. It's never been suggested, and we've never been able to find a case that says 5622A applies, for example, to a joint authority. So an authority with multiple members. If if the Commonwealth Court's decision is allowed to stand, 5622A would apply to all authorities, Act 73, a joint authority under Section 5604, that have more than one member, or at least certainly those who have later joining members. And that cannot be right.
Okay, just one more time then. If 5622A doesn't apply, what does?
Well, 5619...
In terms of how and when a transfer can be effectuated.
5619 applies, and that is purely discretionary from the authority's perspective. If the authority decides to transfer the project against the will of a municipality. And you can see that in the way that 5619 operates, because it requires, unlike 5622, it requires a payoff of debts, basically an entire windup. 5619 is called termination of the authority. And I want to make sure I answer Justice Donahue your question.
5622A requires the assumption by the municipality of all the obligations incurred by the authorities with respect to that project.
Correct. It is not a wind-up provision like 5619 is, and it, 56. That's why, in our view,
why would you need a wind-up provision if they assume all the liabilities? Then they could wind it up by transferring it or whatever else they're going to do with it. That would be how the wind-up took place after they acquire it, based upon an assumption of all of the obligations incurred. It's theirs, and then it's done. It's wound up.
Yes, they could wind that up if it's acquired per Section 5622. They could certainly wind it up later after assuming debts. That I think, Your Honor, raises the question of, well, who can exercise a 5622A power? And from our standpoint, that has to be a single-member municipal authority where it controls the board appointments. Not an Act 73 authority or any other multi-member authority where there are board seats for all of the participating municipalities.
So contrary to what you told me in the beginning, 5622A does not control this, and Burke does not control it.
Burke controls only if you decide 5622A applies to an authority like the CWA or any other multi-member municipal authority.
But you don't think it does?
We don't think it does. But it's so dispositive, that's why we addressed it first. The authority's board.
Board.
Well, certainly the authority's board, and they would have to have obviously the consent of Chester County, Delaware County, and the city of
That
Chester.
goes to my original point. If the city of Chester and Chester County and Delaware County decide together that they want to sell off the assets, Delaware County and Chester County could prepare a resolution to sell off the assets in conjunction, or to acquire the assets in conjunction with the city of Chester, and then convey it through a third-party sale to Aqua. Is that correct?
No, they would still need the CWA board's authorization under Burke. I'm sorry, they would still need the authorization of the CWA's board.
Okay.
So just moving on to the next point, and this is a good segue, Your Honor, because if 5622A does apply to an Act 73 authority, the only logical way that it can be read to apply to such an authority, or any other joint authority, is that the three appointing entities would have to have the power to approve a transfer. Meaning if this court were to say, doesn't matter what the CWA's board says, it's only either the city of Chester or the three appointing entities that would have that power, it's some combination of them, then the most rational reading that could possibly, the only rational reading that could possibly apply in that circumstance is that it's all three of those entities.
That was my point.
Yes. And I apologize, Your Honor.
But your
if I-
contention is that regardless of what the three entities, the appointing entities want, if the board says no, that the assets cannot be sold. That's not my understanding or reading of 5622A in conjunction with 5610A1 under Burke. Because if Burke stands for the proposition of anything, if Justice Donahue just mentioned, 5622A stands for the proposition, it's that a single joint authority, the municipality can acquire the assets of that particular authority regardless of what the board wants. In this particular case, under Act 73, it expanded the board to 9 members from 5 members, as you've already conceded, with 3 from Chester County, 3 from Delaware County, and 3 from Chester. If I'm reading this logically, and I'm thinking about it logically, if that's the asset of the participating entities, or that's the idea of the participating entities, Chester County, Delaware County, and the city of Chester can get together and say, we want to sell off that particular asset, and we're going to enter into a resolution to acquire the asset, and then sell it off to Aqua or any other third party. No? Why would the board, or what authority do you contend the board has to thwart the plans of the appointing authority?
Under Burke, and I apologize, Your Honor, if I didn't express this correctly, what the Burke case says is that the authorities board has to approve.
Okay.
So that's what the Burke case says. For purposes of this portion of the argument, I'm saying ignore Burke. Just forget about it. If this court for any reason says, you know, the Burke case was wrong, it doesn't apply, then the only rational reading of Section 5622 and 5610A1 in looking at the entire context of the MAA is that the 3 appointing entities collectively would have to authorize that transfer. And
that was what I just said. That's my reading the line of cases and reading the statutory construction. It would seem to me that under 5622A, in conjunction with Burke, the 3 appointing entities have the right to acquire the asset and ultimately sell it off via resolution without the board's approval.
I agree with Your Honor if we put Burke aside. If we put Burke aside and the definitional argument I made about 5622A not applying. But if you assume 5622A applies, then I think the only rational reading of it is the reading that Your Honor just gave. And I say that in particular because of Section 1938 of the Statutory Construction Act. Because what Act 73 does, if you look at how 5610A1 in particular operates, it makes the 3 appointing entities, meaning Chester County, Delaware County, and the city, the successors to
the original 5-member
board. The original 5-member board. That is the only rational way I think you can read 5622A if this court decides it applies to an Act 73 authority. To say otherwise would mean that the city of Chester forever, notwithstanding that it is, you know, has a small portion of the service area, and that Chester County and Delaware County have been given seats on the board, and for all other purposes of governance, that they have no say whatsoever in the most important thing that could happen to the authority, which is its ultimate disposition.
Sure.
It just doesn't make any sense.
Well, Act 73 specifically recognized that. It expanded the board from, disbanded the 5-member board, created the 9-member board, because at that point, I think, 80% of the ratepayers were from Chester and Delaware County, not part of the city.
Absolutely, Your Honor. I agree completely on that point. And that is the point I think we've made, Chester County's made, I think Delaware County agrees with that point, even though they're an appellee here. So I agree completely with Your Honor there. And, you know, I should probably stop there because I want to make sure I give Your Honor some more time for questions or leave time for Chester County. But that's exactly what we are getting at, Your Honor, with our arguments.
We have all night, Mr. Kennedy.
Okay,
Well,
good.
How does it work then? What happens? Go through the steps. Who do you think has to be involved with the transfer and how?
Okay, first, we think because it's a multi-member authority, it is a joint authority by any reading. Joint authority is not a defined term. If you look at how joint that works for a joint authority in the statute, the transfer, It's not expressly addressed. It appears that it does not, a joint authorities project could not be subject to 5622. We've looked, it doesn't look like it's ever been tried.
Well, let me ask you, I don't know why that is, because 5610A1 starts with the proposition, if a water or sewer authority incorporated by one municipality provides water or sewer services to residents of at least 2 counties, et cetera, et cetera, et cetera, and then it goes on to say how that authority has to be constituted. Correct?
Correct.
Okay. This expressly anticipates the situation we're in here. We had an authority that was incorporated by one municipality, correct?
Yes.
And then it grew into a situation where it was providing services beyond that municipality, as is anticipated in A1.
I'm sorry, as is anticipated.
Anticipated in A1. That's why the board is then constituted as is required by the remaining subsections of this particular statute.
Yes, Your Honor.
Okay, so why doesn't 5622 apply in this context? Because it talks about a project established by a municipality. There's symmetry between these two sections that we're talking about. So that the authority that would have to approve the sale or transfer would be the multi-county authority that was established under 5610A1.
I agree that it's the multi-county authority that
But
has
you're
to...
saying 5622 doesn't apply to multi-county authorities, and that's why I keep stumbling over this
Yes,
part
and
of your
I
argument.
apologize. I'll try and be a little bit clearer on this point. It doesn't apply to multiple member authorities because it's no longer a project established by a municipality because of the replacement of the board.
But it was originally established by one municipality, just as it's anticipated in 5610A1.
Yes, but if you look at the rest of 5622, it talks about the project in the present tense. The
Yeah.
current project, as a result of Act 73, creating a 9-member board appointed by 3 municipalities, the project is now one that's established by multiple municipalities. And note that 5622 does not use the term incorporating municipality. It's nowhere in section 5622, section 5622A. Had the General Assembly wanted to refer in 5622 to an incorporating municipality, it could have used those terms. It didn't. And that's also why, Your Honors, I think it's important to note that if we were talking about a 5604 joint authority, the rationale that the Commonwealth Court used would be equally applicable, meaning if you were to take the city's and Aqua's arguments and the Commonwealth Court's rationale that the phrase Your Honor just used, established by a municipality, equates to incorporating municipality, then every joint authorities project would be subject to being taken by only the original incorporator. Doesn't matter how many joined later, whether it's 5 or 50. Only that 1 or 2 who actually incorporated the original articles could take it. That cannot be what the General Assembly intended here. And I just can't think of any circumstance under where it would be a rational reading to conclude that. And I think if you look at the Commonwealth Court's opinion, unfortunately, I think that the kind of trapdoor that it fell through is in looking at this at the MAA not as a statute that distributes government power among municipal authorities, municipalities, different municipalities, but in this term of, this thought of ownership, like it's a private corporation where somebody holds stock. That's not we submit that is not a good way to look at this. I'm referring specifically to the Commonwealth Court majority's opinion in one of the footnotes. And I think if you look at the dissent in the Commonwealth Court, it's dead on a lot of the points and questions that your honors have raised here today.
That's by Judge Wojcik. That's what you're talking about?
Yes, Judge Wojcik's dissent, which I believe was joined by Judge Cohn-Jubilier.
That's where the idea of proper authorities came from, which I was just talking about earlier, which in this particular case, the proper authorities would be all three appointing municipalities.
Yes, I agree with that if you believe Section 5622A applies to a multi-member municipal authority.
You would agree that, I'm sorry.
No, go ahead, Justice.
You would agree that this particular board, this particular entity now, as expanded, doesn't necessarily meet the definition of an individual authority or a joint authority as they're defined under the Acts.
It's not an individual authority, correct. I don't necessarily agree with your Honor's statement on the second point of joint authority. Joint authority is not defined. Joint authority is really used as a descriptor in 5610, not just A1, but throughout 5610 and in 5603, 5604, and several other places. It's not a defined term. If you look at the MAA as a whole, it really just means an authority that has multiple members, multiple municipal members. Whether it's an Act 73 authority or an authority that is created incorporated by 2 municipalities or 5 under 5603, or a municipal authority that under 5604 joins later. So yes, I generally agree with the concept that your Honor was stating, but I think it's a little more nuanced because joint authority is not a defined term in the MAA.
I got you.
Mr. Kent, can you move on? Do you have any
Yes,
other
just a few concluding points, if your Honor will indulge me for a minute. Aqua and the city asked this court to engage in essentially rewriting the statutory language based on claimed equitable considerations outside of the pleadings. Basically, if you boil it down, the city in particular and Aqua say they want and need to get their hands on the CWA system for a lot of reasons that we think are well beyond this court's consideration. We don't think the court should countenance that. If it does, I would just ask the court to be cognizant of the substantial interest of the over 200,000 people and businesses relying on the CWA for clean, affordable water. We ask the court to reverse the Commonwealth Court, vacate its order, reinstate the trial court's orders denying Aqua's and the city's motions for judgment on the pleadings, and to decide this case as expeditiously as possible to give clarity to the people and businesses who rely on the CWA. Thank you for your attention to this very important issue for southeastern Pennsylvania.
Thank you, Mr. Kent. Let's hear from Mr. Emmerich.
Good afternoon. May it please the court, my name is Frank Emmerich from Eckert Siemens, here on behalf of the County of Chester with it. So the Commonwealth's decision and the appellee's arguments rely on the premise that the Municipal Authorities Act creates lesser status participating municipalities in authorities. And therefore, at the end of the day, only one authority, the original authority, the one that appears, municipality, the original municipality that appears on the Article of Incorporation.
Incorporated party, yeah.
Can effectuate a 5622 termination or conveyance, of a project. I plan on addressing my comments and pointing to 5 areas that I think, when you look at the Commonwealth Court's decision, cannot be reconciled with the rest of the provisions of the MAA. We have to start with some context first, which is that the financial cost of infrastructure and the requirements, environmental, regulatory requirements that go into now water and sewer treatment created the situation where municipalities were best served by joining together their operations instead of trying to do it solo. And Act 73 looked to address situations where the authority that's serving multiple municipalities no longer reflects the original envisioned project that started the water service. So the General Assembly decided that a legislative created mandate would be required when jurisdictional boundaries of the authority have now so exceeded to where it represents less than 20% of the ratepayers. And all that Act 73 really did was create an additional process that joined municipalities together. 5604 is nothing more than a process. How? If I want to voluntarily join an authority as a municipality, how do I go about doing? And it goes through the process. 5604 does it. It sets forth a process. Act 73 just created a process that says if this situation definitionally is met, therefore the board changes and the governance of the municipality now has, or excuse me, the authority has now changed. Now, the city and Aqua argue that Act 73 solely provides Delaware and Chester counties with a lesser governance role, just a seat at the table of that. And they argue that equal decision-making to the city would have required, if the CWA was going to be governed by anyone other than the city of Chester, would be for the 36 other municipalities of this 37 municipality authority to have gotten together and pursued the process of 5604, passing the resolutions, being approved, and the city of Chester approving them being brought into the authority. Now, recognizing that there's flaws in the Commonwealth Court's decision, is the city and Aqua come forward and brief in front of your honors the fact that what in actuality has happened is that there's a difference between Act 73 and authorities formed under 5604, and they talk about that 5604 created incorporator-like rights to the adjoining municipalities there. But if you put aside, even if you put aside Act 73, the Commonwealth Court's decision would strip municipalities that were formed under 5604 of any decision-making of whether a project of an authority is continued, expanded, or eventually conveyed to a municipality. Because the Commonwealth Court said that that is reserved exclusively, essentially, to the municipality appearing on the Articles of Incorporation. So that is flaw number one of the Commonwealth Court decision, in the sense of that, and it was talked about by CWA's counsel, is that you could have, outside of Act 73, municipalities that have joined under the process of 5604 and have the same situation where, under the Commonwealth Court's decision, 5622 could be used to force, on behalf of only the decision of the original incorporating authority, municipality, I apologize, the originally incorporating municipality's decision to have that project conveyed. So no matter what percentage of the product is represented by a adjoining municipality under a 5604 process or an Act 73 process, no matter what infrastructure the municipality, that's some municipality other than the original incorporating municipality, has no power if you apply the Commonwealth Court's decision. The only person, the only entity that has power, which it would be the original incorporating authority. Now, we believe that when you look at Act 73, the county's position on that is you can't assume that the General Assembly intended for that to be the impact. Is if they're adding Act 73 dealing with representation, okay, and saying when it becomes so lopsided, factors in the counties of Delaware and Chester County in this particular instance have to be joined into the authority, there's no way that the Commonwealth Court's decision, which would render a 5604 or an Act 73 joined municipality subject to the whim of one municipality, which is the original incorporating authority. Now, perhaps the city and Aqua brief in front of your honors and emphasize this incorporator-like aspect of it in terms of a 5604 authority, because again, the object of statutory construction is, can you make the sections work together? So let's just go with the idea of 5622 talks about conveying of projects. Now, whether this court wants to look at conveying of a project as a defined project, build a water tower, do this, or as the authority as a whole of it, is 5622, as the Commonwealth Court decided, could be used by the original incorporating authority to end the authority, to terminate it, to end its existence, conveyed away the property to the municipality. Well, let's look at what the Municipal Authorities Act talks about as far as the issue of when an authority has been expired, when it is over, when it's done, when it ceases corporate existence. What did the General Assembly say there? And this is 5623. So 5622 ends it. If it needs to be revived, 5623 clearly says that that has to be any municipality that has joined the authority. Not the incorporating municipality. Is 5623 says if you want to resurrect an authority that has expired, you need the consent and the approvals, resolutions, and so forth of all the joined municipalities in that authority.
Council, if 5622 is read in the manner that the Burke Court read it, wouldn't that assuage your concerns? Because it would need the vote of the authority constituted pursuant to 5622, 5610A1, in order to approve the conveyance. So there could be no conveyance without the approval of the joint board as constituted under 5610A1.
Correct, if I understand.
Are you okay with that?
Your question, Your Honor, is that if Burke applied and the authority itself has to approve of any
Correct. Yeah.
termination of a project or of its own existence, is yes, correct, Your Honor, is then that's talking about the 9-member board, in this case, 3 from the city, 3 from Chester County, 3 from Delaware County.
And that takes care of your concerns. Is that correct?
Well,
or not? Because you would say then that only the municipality that originally established the project could move for the acquisition of the water authority.
I would say that's what the Commonwealth Court is saying, Chester County's.
But they said more than that. I mean, they didn't account for Burke, which doesn't allow that to happen automatically. I mean, Burke would, the reading of 5622 would suggest that the incorporating municipality would have to present a resolution for consideration by the authority's board, who would then have to approve or disapprove it. I mean, that's what Burke's reading of 5622 would suggest.
And Your Honor's question with that.
Are you okay with that?
I agree with that's what Burke says, correct.
But are you all right with that resolution?
Yeah, in the sense of, Your Honor.
Because you're asking, I mean, to me, I'm just having a very difficult time reading more into 5610A1 than what it says. And it says a lot. I mean, obviously, it grants representational authority to the various participating municipalities. It clearly does that, and that's a big deal. But all that does is suggest how the board then has authority to act. It doesn't authorize any particular activities at all. It just says, here's what you need in order to have a duly constituted board in this situation.
Well, Chester County's position is what that does is creates a joint authority, a legislatively mandated joint authority. So whatever this court would find would be rights to a 5604 municipality that's joined in authority through that process would be the same as an Act 73, call it legislatively mandated joint authority. And the point of Chester County, I think, you know, Justice I think you said would Chester County be okay with it or something like that is, yeah, the point of Chester County right here is Act 73 clearly was intended to create representation, okay? So that's what Chester County's here fighting for, which is that the legislature clearly said when something became so disproportionate, the authority, you know, the jurisdictional reach of an authority has become so disproportionate to who is on the Articles of Incorporation, there must be a change, and we are going to mandate it through Act 73.
The representation has to be changed.
Representation and control of the board, of how this municipal authority would work, okay, is, you're right, is there's nothing, you know, after, you know, 5610A1, you know, defines, okay, this is the situation, and now we're going to create a 9-member board with it, but it doesn't change everything else in the MAA that would apply. And that was my point on 5623 is, okay, if the CWA was expired, had terminated, okay, it had been conveyed, let's say, to the city, okay, and therefore expired, but for whatever reason the city needs to reactivate it or whatever, that's where 5623 is saying, no, you can't read it like the Commonwealth Court and limit 5622 to the incorporating authority, the incorporating municipality. You have to read it, and now under Act 73, as to an act of all three participating municipal entities. The other thing I want to point out is an absurd result of the Commonwealth Court's decision and in the focus on incorporating, the emphasis on the incorporating municipality is you would go through and again, the rest of the MAA, could it be applied and make sense, is that of the 9 board members that are required under Act 73, is 5610 would then require at least 5 of them to be not only city residents, but also city citizens. Okay, so is that what the General Assembly was trying to accomplish in representation of creating a situation where, again, if the incorporating municipality has some heightened meaning and importance within the MAA that doesn't exist in the definitional section or anywhere else, is 5610B and 5610A1 do define how and what call it the makeup of a member for the municipal board needs to fit, what criteria that needs to fit. But 5610B says that the majority of the board has to be residents and citizens of the incorporating municipality. So again, it's the County of Chester's contention that is, if you try to use the Commonwealth Court's decision as to 5622 and apply it throughout the Act, the MAA, to make the other sections reconcile with the other sections, is that's another area where there's a problem in what the Commonwealth Court decided on there. Is this court would have to say that the intent of the General Assembly in Act 73 was to mandate that the city and the 9-member board with the County of Chester and the County of Delaware saying, outside their jurisdictional reach, and saying, all right, who lives and who's a citizen of the city of Chester, I want them to be my representative on the board. And when you look at 5610 and 5610A1 as far as the initial, call it preamble as to who and what the profile of a member should be, is I think you can look at it and clearly get the point of what Act 73 and what in general 5610 was trying to do was trying to accomplish that the board representative on a municipal authority would match the appointing authority, would have the interest, would, be coming from the same background, the same community, have the same interest in it. And the reality as far as the makeup of the board and being a majority, being residents and citizens of the city of Chester, is obviously throughout the history of the CWA since Act 73, the city has never required that. The next point I want to raise is that Act 73 was enacted to provide fairness to the ratepayers. And that's demonstrated how the MAA has addressed the money of the authority prior to Act 73 and how it strengthened those provisions in Act 73. So Act 73 in 5612A1 created a prohibition and in fact created a private right of action to a ratepayer for that, saying that the money of an authority may not be used for any purpose other than directly related to the purpose and mission of the authority. And I'm bringing this up because it goes again to the point of trying to make the MAA work, and could it work with how the Commonwealth defined the municipality under 5622 as only being the incorporating municipality. And then consistent with what was specifically put in place as far as the money of the authority having to benefit everyone, not just the incorporating municipality, it has to benefit all the ratepayers, is that concept actually was already in the MAA prior to Act 73 in 5622D in talking about reserves of the authority. Again, saying that they should only be used for purposes of operating, maintaining, repairing, and improving and extending the project. Again, just simply a point to illustrate the fact that pre-Act 73 and post-Act 73, there's an obvious conscious effort by the General Assembly to create a system that is fair to all the ratepayers, not just to the incorporating municipality. And my final point of the problems with the Commonwealth Court's decision is it would allow any original incorporating authority to circumvent, Act 73. So whether it be an authority that's created under 5604 or an authority that is soon to be created under Act 73, all the original municipality, the original municipality that incorporated the authority would need to do is simply create a second authority. Beat the statistical 80%. Just take the CWA, create CWA 1, CWA 2, boom, still control both boards, 100% the city would control both boards in that situation. And, again, thwart the clear intent of Act 73, which was intended, especially when the demographics of the authority had so much switched, to make sure that each ratepayer was appropriately represented and their interest was protected. And for that reasons, we believe, on behalf of the County of Chester, is that the Commonwealth Court decision should be reversed and the trial court decision put back in place with it. Thank you for your time.
Thank you, Mr. Emmerich. Let's hear from Mr. White for the City of Chester.
Good afternoon. May it please the court. Matthew White, representing the City of Chester. I'm from Ballard Spar. Co-counsel Scott Withers. Mr. Withers is from Land Macrolane. He will be representing Aqua, who you heard from earlier today. I don't think he's going to go on as long because given the hour of the day, we're going to try to...
Don't make any promises you can't keep.
Unless there's a lot of questions. And Candace Hall from McNeese Wallace is representing Delaware County. Delaware County, as the court knows, had a different argument for affirmance of the court below that neither Aqua or the city made.
All right.
With that, Your Honors, I'd like to start with the Municipality Authorities Act. We have Act 73 has been discussed a lot as if it was some major sea change in the Municipality Authorities Act. In fact, it was a relatively minor change and it's an important part of the statute, but the statute where it was changed goes to the governance of the board. That's it. The Municipality Authorities Act, I dog-eared my copy, but it was started, the initial version was in 1935. It was amended in 1945. It was reenacted in 2001. At all that time, the sole incorporator under all of those versions of the act for this water authority was the city of Chester. In 2012, there was an amendment, not to the entire act, but just to section 5610, and the provision, of course, is 5610A1.
A1 creates a new board, expands from 5 to 9, and gives the counties, Chester and Delaware County, 3 members, right?
And in fact, Your Honor...
Was it your position, just so I'm clear on this, as we move forward to put this in context, that all that did was change the governing philosophy and didn't give the Chester County or Delaware County any kind of oversight responsibilities or ownership of the, well, it doesn't give them ownership, but what's your contention? It just expands the board and gives them members and that's it?
Yes, and the reason for that is twofold. One is, when you look at the language of the statute itself, 5610A1, after the prefatory language about which, when there's something within an incorporating municipality, and now it's grown to serve additional counties and additional people, the language of this section says, all of the following apply. And it goes 1, 2, 3. All of the following apply, and it goes to the board makeup. It doesn't say that there's any other provisions that are affected. It doesn't cross-reference that we're planning to amend all of the other sections of this statute that highlight the importance of the incorporating municipality. The Municipality Authorities Act in 1935 was started to provide municipalities with a way to fund big public projects like water systems, sewer systems, things of that nature. It was done at a time coming out of the Depression to allow municipalities with some federal funding to do things where they didn't have to raise taxes and they could fund things by ratepayers.
Does it matter that your client had no skin in the game even back then because it was financed by revenue bonds of the new authority? I don't think your client was at any risk at all.
The city of Chester and all of the other municipalities that, the only incorporating municipality was the city of Chester. The skin in the game, it doesn't have any more skin in the game or any less skin in the game than any other of the municipalities in this courtroom.
Except that the bulk of the ratepayers are not in your client.
Well, Your Honor, that's the situation now, but that's not an unusual situation under the Municipality Authorities Act. In fact, when you look at the whole structure of the Act, 5603 is how you incorporate an authority. The incorporating municipality incorporates and has to have a public hearing and has to sign on to it, has to file things with the Secretary of State. 5604, which my colleagues alluded to, talks about joint authorities and how other municipalities may join an authority that has to be approved by the incorporating authority. There's power vested in the incorporating authority throughout this statute.
And that didn't happen in this case, right?
In what respect, Your Honor?
In other words, they didn't join. This was a creation of a new board member.
As a matter of fact, Your Honor, that's exactly right.
So your position is this is not a joint authority, it's a single-use authority.
And in fact, the county in their brief, and Judge Wojcik in his dissent went so far as to say that this was a a joint authority by legislative fiat, which just means that it's not in the language in any part of the statute. There's no part of the legislature that says we're creating a new class of authority. There's no part of this, of 56A10, which is the only change in 2012. There's nothing in that statute that was passed, Act 73, that says we're creating this new type of authority.
Then why do it?
Excuse me?
Why do it?
Why do what, Your Honor?
Why expand the board? Why disregard, why disband the five-member
Why
board?
did
from
they
Chester
expand the
County?
board?
And why create a whole new board giving Chester and Delaware County membership, or 3 or 6 members? Equal membership.
Well, Your Honor, and there's a lot of talk by my colleagues from the county, representing the county, about the supposed legislative intent and what the legislature must have been thinking. What we're left to do in this case is to look at the language of the statute itself, and that's it. Look at and the only thing that we could find, the only thing that was referenced is actually in the amicus brief by the House parties, was from the Legislative Journal of the House in June 19 of 2012, and it says that the purpose of this is so that the county commissioners in those counties would get to appoint members to the authority board. The additional members would represent authority customers on rates, service problems, and other issues. That's it. A seat at the table, which has been sort of said derisively.
But not this biggest issue.
No, Your Honor.
Those other issues don't include this biggest issue.
And that's what was said, and that's the only thing that we have from the legislative history. It doesn't talk about that there's some intent to make some wholesale change and upset the balance of power that's granted to the incorporating municipality.
Well, if they get a seat at the table, aren't they entitled to eat? In other words, if the sale of this particular property goes through, don't they get a portion of the assets of the sale? Or does it all go to Chester?
Your Honor, the incorporating municipality is not entitled to just take. The incorporating municipality under 5622 has to assume all the obligations that the authority has. So in other words, whatever debt is incurred by the authority, specifically under 5622A, that has to be netted out and that has to be taken care of. So it's not as if all of the proceeds of any sale that could be done would do that. And by the way, there's nothing in this record.
Where does the net profits go then? I understand what you're saying, but who gets the net profits under your analysis?
Your Honor, first of all, there's nothing in the record that says there is a sale. This is all about whether, and the only narrow issue that went up on both from the trial court.
But that's the whole idea behind this, right? They want to sell off the asset to satisfy some debts.
Your Honor, I think specifically the state of play right now is that, and this is not in the record, but it's what's publicly available. The state of play right now is that the receiver for the city wants to monetize the issue and keep it in and ideally keep it in public hands.
So, Counsel, 5622A, is the city's position the proper authority is the receiver?
No, Your Honor. The city's position is that the proper.
Who are the proper authorities under 5622A?
Yeah, let me get right to it, and I just want to read it exactly. The introductory sentence, the project established under this chapter by a board appointed by a municipality. The municipality is the city of Chester. Then it goes on and says it, which is the municipality, may by appropriate resolution or ordinance adopted by the proper authorities, which means it's city council, signify its desire to do so, and then the authorities, this means the water authority, shall convey by appropriate instrument the project to the municipality. That's what that means. And
are you saying that the authority is a project for purposes of 5622A?
we're saying that the project that's been established, which is the entire water system, and I grant you, Your Honor, I don't think that there's any difference. I think if the entire water system were taken back, I don't think there'd be much left for the authority to do. But it would also be taking any of the obligations that the authority had for instance, any debt that the authority had undertaken, bonds that it had issued. So it's not a free lunch.
Counsel, if I might, I mean,
Yes.
your reading of 5622A is inconsistent with the Burke Court's reading of 5622A, and it's internally inconsistent. The Burke Court said that proper authorities refers to, as in this situation, the water authority.
Burke
And so, as I read this statute and I read Burke's interpretation of it, if the city wishes to acquire that the assets, they have to present a resolution to the board of the authority, and the board of the authority has to act on it. If they approve it, then it's transferred as long as the city takes on the indebtedness, and if they don't approve it, there's no transfer.
Your Honor, I'll answer it in a couple of different ways. The Burke case was thoroughly analyzed by the court below.
I disagreed with it. Okay, and so, you know, they relied on a lot of their own jurisprudence. I mean, I'm reading 5622A on its face. I think it says what it says. If you read it in conjunction with the other provisions of the Act, the definition of the term authority becomes very clear. Look at 5622B and its use of the word authority. I just don't.
Your Honor,
your reading of this ignores the fact that there is some passage of a resolution that has to take place by a proper authority, and as that term is used elsewhere in the statute, it seems to me that it is applying to
Your Honor,
the authority.
resolution, the phrase that's used is resolution or ordinance.
Correct.
Resolution or ordinance is used multiple times in the statute to refer to the municipality, not to the authority. So, for instance, in 5605, which talks about an amendment to the articles, and again, this is something that's important because while the authority has the ability to amend its articles, it must be approved by resolution or ordinance of the original municipality. Similarly,
Has there been any amendments since the joint board was created? And if so, was it approved by who? What entity?
have there been amendments to the?
You just said the authority has the ability to amend its articles of incorporation, or?
That's right. I'm not aware of anything in the record that's been the case. I can get back to your honor, but the statute itself, 5605, requires a resolution or ordinance to approve the amendment, the resolution or ordinance by the municipal authority, to Justice Donahue's question about the use of the phrase ordinance. Another instance where ordinance or resolution is used is in 5619. Counsel for the authority had said that 5619 and cited to the court was a termination of the authority and that it could be done unilaterally. That's not entirely accurate. There must be a certificate that's by the municipality, where the certificate is approved by the municipality by its ordinance or resolution. So again, in 5619, the word ordinance or resolution is used, and 5622 uses resolution or ordinance, which is the same language. So when you look at that phrase, it only applies to municipalities throughout the statute, not to the authority itself, because as I believe, as the court below recognized, ordinances are nothing, there's nothing in the Municipalities Act that allows an authority to establish an ordinance. That phrase isn't in there. It's only used in conjunction with municipalities.
Counsel, a moment ago you read an excerpt from 5622A, referencing the municipality if a project established, et cetera, is of a character which the municipality has power to establish, maintain, or operate. So I guess we can agree that the municipality had the power to establish, because it did. But maintaining and operating, those are largely outside the city of Chester at this point, right? I mean, do you maintain some sort of extraterritorial argument here? Or?
Absolutely, Your Honor. It's right in the Municipalities Authorities Act itself. First, you start with, and when you look at the powers that are granted to authorities in 5607 D, Section D, in sections 18 and 19, answer this question. First of all, it says to contract with any municipality, corporation. These are the powers granted to an authority. With any municipality, corporation, or public authority of this or adjoining state on terms that the authority shall deem proper. So this allows you to go even outside the Commonwealth with whatever project you have. And Section 19, which is right after that, talks specifically about doing water and other services to municipalities that are not members of the authority, or to and for the Commonwealth, municipalities, etc. So that specifically references it. 5615 talks about the power of eminent domain, and it specifically allows a municipality to exercise eminent domain outside of its boundaries. So when you read those sections in conjunction, separate and apart from any kind of having to create any kind of a joint authority because the authorities have expanded outside of their range, the Municipalities Authorities Act specifically permitted any kind of authority that an originally municipality established to go outside its boundaries, and it makes sense because other municipalities or other people in outside areas, outside the counties, may have wanted to just pay a fee to join. They didn't want to have to establish their own authority. There's no indication in the record, nobody's ever said that Chester County wanted to join this municipality, or that Delaware County wanted to join this authority, or that Chester County wanted to join this authority. By the way, if they did, it would have had to have been approved under the statute by the original incorporating municipality, because that is how this is structured. The original municipality is given the license by the Commonwealth to establish authority to do big public projects, and it has the ability to let the authority go run its business, but at all the key times in the life cycle of that authority, when you're going to amend it, when you're going to bring in new members, when you want to dissolve it, it all has to be approved by the incorporating municipality, by the originator. They started the authority, they can end the authority. That's always been the case. There's nothing new. And 5610A1 goes solely to a governance issue. That's it. It didn't make any changes in any of these other parts of the statute. It didn't make any changes to anything else that was going to say, oh, we're going to all of a sudden say we can have a joint authority by implication or legislative fiat. That's what the dissent said. It doesn't make any sense. If you talk about what's the rule of statutory construction, they would say, well, if you can divine what the legislative intended by one section to mean that we're rewriting all of the fundamental balance of the role of the incorporating municipality, then there's no guardrails to that. That can't be a real statutory interpretation. That just means you get to make it up as you go along. In this court, I've sat through 2 days of your arguments. No way does this court do that. I will cede my time. Are there any further questions?
All right, thank you very much, Mr. White. Let's hear from Mr. Withers.
Good afternoon, Madam Chief Justice Todd, Honorable Justice of this court. May it please the court, Scott Withers of Lamb McElwain on behalf of the appellee, Aqua Pennsylvania, Inc. I'm joined at council table by my law partner, John Cunningham, and also on our brief is our other partner, Joel Frank. I'm mindful that this court doesn't want repetitive arguments from the parties. And I take this opportunity to tell the court that we absolutely agree 100% with the arguments that were set forth by my able colleague, Mr. White, with regard to Act 73 and MAA. Aqua's appellee's brief in this court fully addresses all those arguments, and we would rely on that brief. I will briefly address just one thing that Mr. White did not. The briefs filed by the appellants, Chester County and the CWA, contain multiple speculative arguments unsupported by the record regarding the effect that an affirmance by the order of the Commonwealth Court, by this court, would supposedly have on CWA ratepayers. And CWA and the county allege that there's going to be some terrible rate effect on the ratepayers and the service people who have service from CWA by this decision. And I just want to point out to this court that rates have nothing to do with this case. You heard earlier today a case in which I'm also co-counsel on, with Mr. Povolitis. You guys have already heard about rates and the importance of those in further proceedings in front of the PUC. Rates have nothing to do with this case and are not part of any reason to reverse or affirm the Commonwealth Court. We would simply request that this court, for the reasons set forth in the briefs of the city and Aqua, affirm the order of the Commonwealth Court. Thank you, Your Honors.
Thank you.
All right, does anyone have any questions for Mr. Withers?
No.
You win the award for the shortest argument this session. Thank you. Ms. Hull?
Good afternoon. May it please the court. Candace Hull on behalf of the County of Delaware. The county has specifically not taken a position on whether 5622 requires the approval of the original municipality, the city of Chester, or all three for the return of the assets. What it has argued is that the Commonwealth Court should be affirmed in holding that the Burke decision did not stand for the proposition that Section 5622 provides the authority itself with the authority to transfer its property on its own accord. And if you look back at the original pleadings that started this litigation, you'll understand the importance of that. This was started with a petition by the Water Authority to place its assets into a trust. And the terms of that trust would place the assets of the authority outside the terms of the MAA and prevent any of those municipalities from exercising their rights to the project or the property.
That's in perpetuity, correct?
In perpetuity, correct, Your Honor.
It's tough for me to say.
The initial three trustees were proposed to be then members of the board of the authority, but the proposal then allowed those trustees the power to appoint new trustees, not the municipalities. So those three people then essentially usurped much of the authority of those municipalities. No further appointment by the municipalities themselves was contemplated.
So, Ms. Hull, does Delaware County take any position whatsoever with regard to whether or not they should have a say in the sale of the asset or taking back the asset?
In our brief, we have not taken a position regarding the interpretation of 5622 and 5610. Only that the decision cannot be made by the board of the authority itself to do what it is proposing to do in the underlying action.
Which is set up a trust.
Which is to set up the trust. And we would argue that this is an essential question that is ripe for disposition by the court now. First, because although the lower court referenced that it needed a hearing to decide that issue, we believe that it does not, because it is clear as a matter of law that the authority cannot do this, and there's no facts in dispute that would change that determination as to whether or not these assets can be moved to a trust. And second, it's within the Commonwealth Court's interpretation of the Burke decision and the specific issue that the court granted Alicotter on to decide the meaning and further precedential value of that case regarding what an authority itself can and cannot do. The powers...
Counsel, who owns the assets of the authority? You would know that because we're talking about trustees who are transferring assets, which would sort of suggest that they own the assets so that they can convey them. I mean, who owns the assets of the authority?
I believe the authority owns the assets, but its ability, there is some oversight from the municipalities as to what they can do with those assets. It is, as was described earlier, that the MMA, statute that explains...
Is there title to the assets? I mean, 5622 talks about conveying by appropriate instrument the project to the municipality. What's the appropriate instrument? Is there a title or something regarding the assets of the municipality, of the authority?
Well, there are, I believe, some of these assets were acquired from individual property owners over time, easements and things like that.
By whom? By the authority?
By the authority, yes.
Can I just follow up? Because you just said something that I'm not sure I understand. You said that the Delaware County and Chester County have some oversight.
No.
They have some oversight in terms of they appoint those people to the board.
Correct.
And then they help run the authority.
To represent the people of Delaware County or Chester County with regard to the ongoing operation of the board, right?
Correct.
So if they have oversight, shouldn't Delaware County and Chester County have some, I mean, Mr. White said a seat at the table. That's what the governance did. It gave them a seat at the table. If they have a seat at the table and Delaware County and Chester County both have oversight via their appointees, shouldn't they have a say in the acquisition of the asset and ultimately the sale of the asset?
I think that is consistent with what we are arguing, and specifically, our concern here is that...
I don't think it is. I think your co-counsel, Mr. White, suggests that the city of Chester should be able to just take it back and do with it what it wants, and to hell with what Chester County and Delaware County want.
I believe that is Mr. White's position. Our position is that specifically with regard to this transfer of the assets into the trust, these appointees, the 9 of them acting as the board in transferring it, are removing the county's control and the seat at the table.
They're removing your asset from the oversight, and they're basically making your seat at the table meaningless. But my question to you is, why do you care? Because if Delaware County or Chester County don't have a say in the acquisition by Chester of the asset and ultimately the sale by Chester of the asset, you're not going to have oversight, you're not going to have any seat at the table if they do that, if they're correct.
We did not agree or disagree with Mr. White's position or the Water Authority's position regarding which municipalities have the authority to seize back the assets. So we are not saying definitively it's only the city of Chester and that they could take Delaware County's share of this. We simply did not take a position on that in the brief.
On 5622A.
Or do you have one?
Do you have one?
We do not have one, Your Honor.
Okay.
We were arguing specifically that the board appointed here cannot go rogue beyond its powers, transfer the assets outside of the oversight of any of these municipalities and into a trust that essentially removes public oversight of these assets. And so that is the concern of Delaware County specifically in this appeal.
I didn't mean to make you adversarial to Mr. White. I see you both looking at me. I just wanted to clarify that. That's all right.
And we didn't have anywhere else to put you to sit. You're not really on their side, is what you're telling us.
We have a unique position, I believe, Your Honor.
Switzerland.
Exactly.
Anything else, Ms. Hull? Any other questions? All right, thank you all. Very well argued. We'll take it under advisement. Thank you. This concludes
our 2025 spring argument session. I would like to thank PCN for filming our sessions as an educational tool to the public. We really appreciate it. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, for their outstanding service to the court, as well as our court security for looking out for us, John Evans, Gary Shovlin, and Scott Town, and of course, the Capitol Police. Mr. Minner, you may adjourn the court.
It's Wazari.
Yeah, it was good. Thanks a lot, Brian.